If I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I get started, for those who don't know me, I'm a Texas trial attorney going on my 5th year in the game. I got the law license on the wall, signed by the 9 justices of the Supreme Court. And I was minding my business. And I was drinking my water. And somebody said we got motions today. Thank you to Tia for sending me the the motion. Let's go through some of these motions. Thank y'all, my good people, for joining and for waiting on me. I think Glanville rubbing off on me. You know how you set a time and then something come up? Clients calling. I'm like, man, I got to get on. Oh, man. Chicky said this is going to be a good one. I haven't even read the motions. From my understanding, there's like 2 of them so far. Maybe more have came out since then. Is this the top of my computer screen showing? I might have to lift my camera up. I'll do that in a second. Yeah, no tie today. I said, I'm going to just relax. She said, let's talk about it. What's going on, A-Rod? Nurse. Where's she at? Nurse Shells. There we go. Hey, Erica. Yeah, comfort break. Hey, breaking it down with B. And shout out to King Goddess. Thank you again for the kind support from the last stream. Oh, okay. Thank you, Mango. Gelato. Am I saying it right? Hello, Tracy. Thank you for joining. What's been going on in the YouTube streets? What I missed? And I'm gonna see it in. All right, y'all. Let me see if I can put up these motions. I don't even know how long they are. All right, DeMonte Kendrick's motion for a mistrial comes now. DeMonte Kendrick. Y'all know who this is. This is Weinstein's client. Let me move me out the way. By and through his undersigned counsels and bring this motion for a mistrial. And then he goes on to say, we think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice would otherwise be defeated. So he's saying that you got inherent powers to throw out a case. You don't really need no case law. It comes with the authority of the court. You inherited this power to throw out a case. He goes on to say the courts, they are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But after all, they have the right to order the discharge, and the security which the public have for the faithful, sound, and consciousness exercise of this discretion rests in this, as in other cases, upon the responsibility of the judges under their oaths of office. So that's pretty self-explanatory. They want the case throughout, and since this is something that doesn't happen that much, you don't rarely have a judge that go rogue with a prosecutor. Then sometimes you got to improvise, and he's saying it's common law. Not only common law, it's common sense. And it's so rare that stuff like this happens that he's citing a case from 1974 and even further from the U.S. Supreme Court all the way in 1824. So it ain't too much legal authority in Georgia that gives judges the right to throw out a trial like that just happened with the Alec Baldwin trial when the judge threw it out. And sometimes there's not a law. Sometimes you got to go back to the old ways. You got to go back to the common law. Y'all ain't saying nothing in the chat. And I'm going to kind of skip read some of this stuff. It might be repetitive. The state has had witness after witness that failed to provide testimony that it would like the jury to hear. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of his own witnesses, including at least the following key witnesses: Trontavious Stevens, Walter Murphy. Don't even give me the line on this name. Is it Archelian Bennett, Eduardo Nava Flores, Adrian Bean, D'Angelo White, and critically, aka Woody, Kenneth Copeland. And normally you don't impeach your own witnesses. I mean, that's something that just simply don't happen. Now, a lot of times you can, if your witness forget, you can refresh their memory, refresh their recollection. But you don't impeach your own witness. You don't try to prove that their testimony is inconsistent. Not your own witness. You do that on cross-examination. The other side witness, you want to prove that they're, not being truthful. But your own witness, it don't happen. That's what they're saying. They're saying the state can't even prove with their own witnesses what they said they would prove. Witness after witness. Somebody said, what is the state to do? Losing its case, apparently unconcerned about the need for public justice, the state clearly saw an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick that he would have no choice but to request a mistrial. Well, y'all see how he called him out? He said, y'all losing the trial. So y'all did this on purpose. Y'all had that secret meeting in the back room with the lights off because y'all was losing. And what y'all wanted was another bite at the apple. So the lawyers are saying no. The lawyers are saying no. The defense attorneys are saying you don't get another bite at the apple. Hell, y'all thought this was. Let's keep on reading. They said it was such an egregious violation that Kendrick would have no choice but to request a mistrial. Not Kendrick. Just call him by his first name. Why not? We're on first name basis now. We've been here for months. Now, goaded by the state in the actions of Chief Judge Prosecutor Glanville, Kendrick has no option. He has no choice but to move this court for a mistrial to respect the constitutional rights of Kendrick, not Lamar, and not defeat the ends of public justice. While this trial has been riddled with corruption, riddled with confusion, riddled with scores of errors. At least 3 demand an immediate mistrial. What that mean? At least 3 demand an immediate mistrial. So they're saying there's so many errors, we're not even going to list them all. We're just going to list at least 3 for a fact deserve a mistrial. Yeah, you're right. You're right, Slick. It's been a long. It's been a, you're right, Slick. But I just like calling him just Kendrick. I mean, that's how we know him now. When you got a first name, a last name for a first name, and a first name for a last name, why not? They just mix it all together. Okay, first place. Okay, well, first placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the point the afternoon of June 12th, which I don't know how they're going to do that. That's almost a month and a half when Kendrick moved Chief Judge Glanville to recuse himself, and he improperly failed to halt the proceedings pending determination of recusal. Since that date, the jury heard days of testimony from Woody, testimony that can't be unheard, which is crazy because not only that, do y'all know that Brian Steele is trying to wipe the jury's mind, so to speak? He wants their notes to be scratched out. Any mention of Woody in Woody's testimony, Brian Steele say it gotta go. And you know, the human nature in us, the judge might say, hey, forget that. Don't remember that testimony. Or like me, don't remember the last names. Don't remember Kenneth Copeland. Just delete it out your minds. Take it out your head. Don't be like Nathan Wade, Fonnie Willie's boyfriend. Delete it out your mind. We ain't gonna forget no Woody. We can't forget no Woody. That boy there, he's something serious. Let's keep on going. Let's keep on going. Second, Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings, even though DA Love tried to lie and say it wasn't a critical stage. The secret ex parte meeting among the state, Chief Judge Prosecutor Glanville, Woody, the state investigators, aka the bodyguards for the DAs, the court staff, and the deputies. And state investigators, they are like police officers for people that don't know. They just work for the DA's office. So instead of going to the police station every morning, they go to the DA's office every morning and they just work the cases and help the DA's office. They may go locate witnesses, prepare witnesses, track them down, build a case against the defendants. So you got a lot of that going on. They license peace officers, so they carrying guns. So you got all these security in one room. Woody was pressured. Woody felt like he had to testify when you got all these cops. You got the judge and you got the DAs in there threatening this man to keep him locked up forever, indefinitely. Let's keep on going. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Copeland to testify, pushed him up against the wall, jacked him up, and said, you're going to testify or you're going to jail. Y'all read the transcript. None of the above 3 reasons for mistrial would exist if it wasn't for the dirty DAs. If it wasn't for DA Love and Hilton, their intention to goad Kendrick into this unfortunate position of having to regretfully request a mistrial. Is it really regretfully though? Is it really regretfully? Shout out to 305. Well, I've been preparing for trial myself. I always tell people I'm not just a YouTube lawyer. I'm actually a lawyer in real life, so I actually still have to go to court. I have clients. And there was nothing really going on in this case until like today, when I found out that motion was coming out. I remember the judge said that the motions for the defense are due today, and then the motions for the state to respond to these motions are due on Friday. And I believe we start back court on possibly the 5th. So that'll give the judge all of next week to go through all of these motions. All right, let's keep going. The background. January 2023, 18 months ago, we know the trial began against DeMonte Kendrick. Wait a minute. Now, is I'm messing up his name? Or we missing? Or they miss out a D? Okay, we got Kendrick with the D, and then we got Kenrick. So I'm not the only one messing up, Slick. I'm not the only one messing up on names today. Goodness. But I understand. Sometimes you got to type them fast. You got a deadline. You just got to do what you got to do. So let's keep going. All right. So 18 months ago, jury selection took more than 10 months because Glanville was so slow. He took more comfort breaks than a little bit. He took more comfort breaks than A-Rod said that I needed. So we know a secret meeting was held on June 10th, 2024. So he's trying to prove up why this case should be throughout. In attendance were corrupt Judge Glanville, sworn witness Woody, prosecutors Love and Hilton, investigators from the Fulton County DA's office, court staff, and members of the Fulton County Sheriff's Office. See, you can tell this is Weinstein writing because he's calling Love and Hilton prosecutors. But when Brian's still right, he called a lawyer Love and lawyer Hilton. He ain't trying to put no respect on their name. Somebody said those comfort breaks were so the jury would forget Cross. Right? He timed those breaks so perfectly. So if the state was struggling, he gonna take a break. If they needed more time, he knew how to time those breaks. If the defense started what they call cooking, he want to take a break. So yeah, if y'all go back and look, especially knowing what we know now, it do look kind of suspicious the way the judge was moving. He was moving kind of shady. She said they don't deserve any respect. They don't. I mean, we got to remember we're here because of their actions, what they did. People always get mad at us on YouTube. Why you talking about them like that? We didn't do it. They the ones that caused this. Not only that, they had a chance to fix it, but then they got worse. Let's keep on going. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants is Woody. On Friday, June 7th, Woody was sworn in after being given a grant of immunity, which he did not want. A lot of people say, why did he take the immunity? Because he didn't have a choice. Immunity is something that's forced upon you. It's not like a plea deal where you have to agree to it, you have to sign to it. They just force it upon you. You have to take it. After being given a grant of immunity and being warned by the judge prosecutor that incarceration may be the result of refusing to testify, Woody insisted on and continued to plead the fifth. And guess what happened? He was held in contempt and he was ordered incarcerated by Chief Judge / Prosecutor Glanville on that date on June 7th. So he went to jail on that Friday. Then the judge / prosecutor instructed Woody and all parties that Copeland will be returned to court on Monday at 8:30. And basically that was designed to give Woody another chance. Hey, Woody, we don't want to leave you in jail. We're going to give you a chance to change your mind to testify, which is okay. They could have did that in open court before the jury came out. They could have brought Woody in. Hey, Woody, do you want to testify today? Yes or no? Woody say no. Okay, go back to jail. It's simple. But what they did was they took him to a back room without the lawyers knowing, and then they pressured him to testify. And then obviously that created this big mess. And that's why we don't like judge number 5. So let's keep going. So they brought him back June 10th, 8:30. This was the time we were supposed to start. Defense counsel was told to be present in court at that time and were in fact present. Unknown to any member of the defense counsel, an ex parte secret meeting was being held behind closed doors with the chief judge / prosecutor on that date. And who was there? Chief judge, prosecutor ADA Glanville, ADA Love, ADA Hilton, investigators, police officers that work for the district attorney's office, other deputies that work for the courthouse itself, Woody, court staff, Copeland's attorney, Miss Kayla Bumpers. Shout out to Kayla. No member of the defense counsel was present at that ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights and the meeting being a critical phase of the trial. And just for clarity, we all know Kayla is not a member of the defense. She's not a member of the defense team. She was the attorney for Woody, not for any of the people that's on trial. So that's why she was present and not the others. So nobody in that room that was supposed to, like the court staff, the judge, the DA's office, made any member of the defense counsel aware of the secret proceeding either before, during, or after the proceeding. Several defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Chief Judge Glanville or from the DA's office. Critically, Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. A review of the recently released transcript of the ex parte proceeding reveals the occurrence of the following events. So basically, we all know this. They had a meeting that we don't know. 305 say who told. We still don't know who told first. We still don't know. Oh, shout out to Larry. Larry, I don't have that set up, but I do plan on doing something like that in the future for the ones that want to support. Somebody say we know who told. Who told politicking with Mel? Mel say she know. All right, let's keep going. So this is what happened in the meeting. We already know. Copeland announced that he would invoke his Fifth Amendment right and not testify. This is Woody. Woody stated that he would rather sit in jail for 2 years than testify. And they told him, no, Woody, it's going to be longer than 2 years. They said, no. And then Woody stated that he would rather sit in jail 2 years, okay? Chief Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. So Woody was like, hold on now, I can do 2 years for y'all. And I can't do indefinitely. I need to know to prepare mentally how long I got to do. And Judge Glanville said, somebody said who? 313, the bench side. Shout out to 313. She said it was either Kayla or Woody. Yeah, and if y'all don't mind, hitting that like button, appreciate the support. So let's keep going. Copeland was informed that there were over a dozen defendants left to try. So they said, not only just this 6, you got 12 more that's still cooking in the pot, still stewing. And we're going to keep you in jail until we drag those trials out. And y'all got to remember, Glanville was still a judge at the time. So we already know if Glanville took forever just to get to this point, 10 months on jury selection, for only 6 people, imagine how long he would have took for 12 people. So they would have really had Woody in that jail for a long time. The paralegal Barbie, shout out to her. She's saying that her theory is one of the deputies told Young Thug, and then Young Thug told his lawyer Brian Steele, and then they went to Kayla and said, "Kayla, is this true?" And Kayla confirmed it, and that's why it would violate client attorney privilege if he reveals his source. Now that makes sense. If Young Thug was the source and he told Brian Steele, then that could be attorney-client privilege. It's a privileged communication between the attorney and client. And this is the theory that the paralegal Barbie has. That's what that's her theory of the case. Who knows? Maybe we'll find out more in the future about the person who revealed that information. But let's keep on going. Is this big enough for y'all to see? Let's see, is that a little better? Following the above scare tactics by Chief Judge Glanville working in concert with the state, sworn witness Woody stated at the ex parte proceeding that he would testify. He said, golly, goddamn. Y'all want me to testify that bad that y'all gonna keep me in jail indefinitely? Y'all know my dog finna have puppies. Y'all know I want to hug my nephew so he don't turn out like me. Y'all know my daughter's birthday is coming up. Y'all timed this perfectly. Y'all know my lawyer is out of town. Yeah, he had Kayla there, and she did the best she could. She was brought up to speed, but his lawyer for a year wasn't there. So all the cards were stacked against Woody. So he said, you know what, I'm going to testify. Somebody got to testify. And Woody said that was going to be him. So Chief Judge Glanville also presented sworn witness Woody with a printout. See, they're all in the back room. The judge is giving Woody a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Now, this is ridiculous. The judge shouldn't be printing out laws to threaten Woody. You already said you're going to lock the man up indefinitely for contempt. Now, what you're doing, you're printing out statutes that he could be prosecuted for lying. Judge, you're not a prosecutor. You weren't supposed to be. So why are you printing out perjury statutes and false statement statutes? You should have brought him out there and said, you're going to testify. Like my grandfather said, he's going to tell you one time and one time only. You say no, you go back to jail. See, them old school judges, they'll just lock you up. We already explained the rules to you. So now we'll like just lock you up. And then when you're ready to testify, you'll be contacting me. You'll be reaching out to me as a judge before I keep bringing you in there every day and making it seem like I'm trying to, force you. But the prosecutors used Glanville, and he fell for it. Miss Love skirts when that tight, I know, Judge. Couldn't have been for you to break the law like this. Let's keep going. Copeland said, if y'all put me on the stand, I'm going to lie. He said, I've been lying anyway. He said, all I do is lie. I lie to the police to get out of trouble. The state never gave Kendrick these critical Brady materials. These troubling facts not only implicate the judge in an impermissible effort to join forces with the state to trick Woody into testifying, but also to demonstrate an illicit effort to repress Brady material that should have been provided to Kendrick and the rest of the co-defendants. If Woody is back there saying, hey, I'm a lie on the stand, I did these crimes. This is stuff Woody said. I did these crimes. I'm a lie on the stand. What is the statute of limitations for murder? I'm not saying he confessed to the murder, even though that was originally reported. He just said, what's the statute of limitations for murder? Because he don't want to get charged with it. He don't want to be perhaps falsely accused of it. So he's saying some critical stuff that the defense should know about. If my client is on trial for a RICO charge, and then you got somebody in the back room confessing to said RICO charge, the same RICO charge, I need to know about that because that's evidence that proves my client innocent of the charge. So for the DA to come out and say, oh, that wasn't a critical stage. Woman, what have you been drinking or smoking or both? Back in the day, they used to say DA Love must be on dope or dog food to think that that wasn't a critical stage and something that Young Thug and his lawyers had a right to know about, as well as the rest of the co-defendants. So after the meeting, on June 10th, the petitioner filed and presented a motion to recuse and an accompanying affidavit from Douglas Weinstein to the chief judge on June 12th. So once they found out about it, we all know Brian Steele was not happy. He was ready to tear that judge up. He's ready to tear him up. And the judge held him in contempt. We know the judge tried to lock him up. But what happened was Brian Steele's co-counsel, Keith Adams, basically told the judge, if you lock up Brian Steele, you're going to have to lock me up too because I'm not going to participate without him. And then that handcuffed the judge's hands because now if both of the lawyers go to jail, Young Thug would not have a lawyer left. And if Young Thug doesn't have a lawyer left, then the trial cannot go forward. It'll definitely be a mistrial. So that's why he let Brian Steele out. And that's why DA Love asked for the judge to let Brian Steele out. Not because he was, acting on the kindness of his heart. He had no choice. And then he really got embarrassed when the Supreme Court came in and said, oh, hell no. He won't go. Brian Steele won't go to jail. That's what the Supreme Court said. And they gave him a bond. And it was a rightfully filed motion to recuse because it was based upon the impermissible secrecy of the ex parte proceeding and violation of the judicial code of conduct that occurred during the secret meeting. The motion was denied instantly. Judge Glanville wasn't trying to hear it. Soon as they brought it out, it was denied. But he didn't put it in writing until June 14, 2024. Nurse Shell said Love told him what to do, like you said. She told him exactly what to do. I bet you he's so mad at that woman right now, they don't even speak to each other. They're not even on speaking terms right now. She done messed up his career. He had a good thing going. And then she came in there and messed it up. Shout out to D. And Tracy said her theory is after the email or call from Melnick, the defense asked Kayla about it. After the email or call from Melnick. Well, okay, so somebody would still have to tell Melnick for him to call and tell the defense. So I guess that could be a theory. Yeah, thank you, Stacey Lane. If y'all don't mind hitting the like button. And subscribing if you want to stick around. And if you don't, I'm gonna wear you out while I got you here. Somebody said Fannie got all their careers in shambles. Yeah, I mean, we know she losing this case. She losing the Trump case, and And a lot of money went into those cases. Some say millions of dollars. She could have gave Milner text. I mean, that, that could have. Who knows? Somebody politics and somebody had a wire on. I think that's what Glamour was really scared about, a wire. His office is bugged. That's what he was wanting to know. So we think this is bad. We haven't heard the half of it yet. Let's keep going. Okay, so the judge denied the mistrial, of course, and this is the Glanville. Despite meeting all the requirements of Rule 25, it was denied without following the rules. To be such a stickler for the rules, Glanville sure break a lot of them. A formal order denying the motion was entered 2 days later. But on July 1st, the fire got hot. The fire got too hot for him. So instead of, June 12th, when he was, let's go back up. June 12th right here, when he was first filed, that's when the trial should have stopped. The judge waited all the way until the 1st of July. July 1. And that's why the lawyers are now saying anything that happened after July or after June 12th all the way to July 1st should be deleted from memory. And that includes all of Woody's testimony. So they basically want the jury to forget that they ever saw Woody's face. Now, that would be interesting because now, even though Woody's testimony may be struck from June 12th, could the state potentially recall Woody and start all over again? Because I don't know that there's been any, his evidence hasn't been excluded altogether. So even if the judge strike everything from going back to June 12th, they may just recall Woody again. And by they, I mean the prosecutors. But Woody's not a bad witness. I mean, if I was a defense attorney for Young Thug, I wouldn't be scared of Woody hurting my client. If anything, Woody's going to help him, especially the way he's been, on social media. I think somebody said free YSL, and he was in agreement. Let's keep going. So on July 1st, the judge / prosecutor Glanville reversed his order on June 14th and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. And 14 days later, July 15th, Judge Cross recused Chief Judge Glanville. And see, the way he put it kind of soft right here. She recused Glanville, but she really didn't want to. I mean, her motion, it was so watered down. She basically said Glanville didn't do nothing wrong. She said Glanville could still be fair. Shout out to Lee. And Miss Kimberly. Thank y'all for popping in. Judge Cross said he really didn't do nothing wrong. But just so I can seem like I'm being fair, I kick him off the case. Even though Judge Glanville gave $2,000 to my re-election campaign. I seen part of it. I didn't get a chance to watch it all because it was over 2 hours, and I did try to finish watching it last time, but I didn't get a chance to. All right, let's keep going. So he's basically saying what I said earlier. Mistrial is required as all proceedings after June 12, 2024 are void. And now he's saying this honorable court, Judge Whitaker, the ball is in your court. You're now faced with the inevitable and impossible task of rewinding the case to the afternoon of June 12th. I don't even know if that can be done. I don't think you can rewind all the way back. I don't think you can go, because the jury cannot delete. Oh, okay, somebody said still filed another motion. I got to find that one. Still filed a motion to review Judge Cross's order. So what was the order? I guess he didn't like her wording, maybe. I mean, if she said that the Judge Glanville did nothing wrong, I guess that is a problem. I mean, when you're getting ready to file an appeal, if you need an appeal, they may not be found guilty. Okay, so I'm Thugger Daily. Shout out to Thugger Daily. I'll go check it. Let's keep on going. How long ago was it? Let me see. I'll find it. I was trying to let me see. I'll find it. Let's just keep going. Where was I at? Mistrial. Okay. This honorable court is now faced with the unenviable and impossible task of rewinding the case to the afternoon of June 12th. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. So he listed a case from 2011. So, okay, towards the end of the week, I'll go find it. I was gonna, I was gonna call somebody to pull it up for me, but I'll send it. I'll go through that later. Let's keep going. Kendrick moved Chief Judge Glanville to recuse on the afternoon of June 12th, and he denied that motion. Critically, the judge failed to follow the rules. We kind of went over that. All right. Subsequently, Judge Cross, July 15th, found that Chief Judge Glanville should have been disqualified. Therefore, under the Props v. Morgan case, all proceedings since the afternoon of June 12th are invalid and have no effect. This is something new, so I don't know if that's going to hold weight when it's time for, if they're found guilty, you need the appeal avenue. Could a jury really go back to June 12th? That's a lot of stuff you're asking them to forget about. I doubt that is possible. Let's keep going. This honorable court is now saddled. They're using some words in this motion with repercussions of Chief Judge Glanville failure to follow Rule 25. Glanville should have halted all proceedings as required under Rule 25 and he should immediately send it to another judge. Nevertheless, he persisted, just like Fonnie Willis is persistent with this case. Fonnie Willis can end this today. She can come in and say, you know what, I'm going to withdraw all charges. She can't possibly think she's still winning. I mean, even it's a bad sign for the prosecution when the defense is saying in a motion that she's losing. But under repeated objections from Kendrick and the other counsel, the tainted testimony of Woody was presented to the jury over the course of 4 days. The remainder of the day on June 12th and on June 13th, June 14th, and June 17th. During that time, Glanville, who should have been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. So, I mean, we all seen that. He was favoring the state. He was favoring the state. Shout out to Jiggy. I didn't know Jiggy was here. And Miss Carol Clemens. Thank you for stopping in. You caught live today. All right. Now this court is tasked with unringing the bell. You can't unring that bell. Good luck. Good luck trying to unring a bell. These are all the most normal chat in the YSL trial YouTube universe. All right, let's keep going, y'all. Now, this is what I want to know. This is a good question. How is this court to accomplish this impossible task? That's what I want to know. How does this court take the jurors' notes from these days from the jurors? How can the jury unhear days and days of testimony? This is not a matter of a witness uttering a single statement that the court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. I mean, anybody agree with that? Do y'all really think that the jury, if they're instructed by the judge to disregard all testimony from June 12th, do y'all think that's possible? And who's to say that their notes are in order? What if they like wrote some notes and mixed them in with other dates to go back on the timeline? And now they say remove all notes from Woody, but the notes may not just be in order. Hey, Breezy Barber, thank you for joining. She said no. Tracy said that's impossible, not in my opinion. Politicking with Mel said they would poll the jury and the jury would tell it because they want off. They want off this case. It might be more manageable though. Now that Glanville is gone. They might can actually get some work done. Mel, them people tired. They tired. Let's keep on going. Instructing someone to not picture flying elephants only results in the listener conjuring images of Dumbo. Wiseman is funny, ain't he? He is funny, not Dumbo. You tell them not to think about it, and then they're gonna think about it. Weinstein got a thing for ears, don't he? Y'all know Dumbo had some big ears that can fly with his ears. And y'all remember when he told Love she can talk the ears off a donkey? Yeah, so today is the last day up until 5 o'clock. So we still might be getting more coming in. And then the state has to respond by Friday. Wow. Hey, let's go. Given the impossibility of erasing the proceedings since June 12th, the proceedings that are void due to the state knowingly and properly requesting the chief judge to hold an improper ex parte meeting with the sworn witness. And then on top of that, the chief judge subsequently failing to halt the said proceedings, according to Rule 25. Right, Love? This judge ain't finna give you no extensions. Yeah, she said like telling someone don't look. All right, they're gonna look every time. Every time. Yeah, Love gonna wait till it's gonna be 4:59 on Friday when it's time for her to respond. I got a family emergency. Give me 2 more days. And then the 2 more days are gonna come, and then the responses are gonna be Love, if you watching this, don't write the responses. Let somebody else do it. I know you want to put a little attitude in there and and pop your stuff, but it ain't giving what you thought it was gonna give the last one. It ain't gonna give this time either. Trying to help you out. All right, let's keep going. So he didn't stop it as required. This honorable court has no alternative but to declare a mistrial. She really do. But she might still press forward. This motion for mistrial would not exist since the state requesting the improper ex parte proceeding, and that's true. Had it not been for the state asking Glanville to go into the back room and turn the lights down low, then none of this would have never happened. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick in this position. And some people have said that. Some people have said that the state was not prepared for this trial. They weren't ready, and they were looking for a way to call a mistrial. Who knows if that's true? I mean, they had 10 months just to pick the jury. So I mean, if you can't get ready in 10 months, then you ain't gonna never be ready. As low as they can go. So as low as they can go. Let's say turn off the lights and light a candle. Oh, don't pay me no mind. Don't pay me no mind, y'all. Okay. So it's a mistrial is required as of June 12th. Kendrick, DeMonte, his constitutional rights, Young Thug, all of them. It was violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret ex parte meeting among the state, the judge, Woody, investigators, court staff, and deputies. Defendants were not provided notice of the hearing. Under both federal and state constitutions, a criminal defendant has a right to be present during the critical stages of his trial. Allen v. State, 310, Georgia, 411, 418, all of that. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in the critical stage of the trial is coerced into testifying. A critical stage is one in which a defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Brennan v. State. Here, the outcome of this case is substantially affected by the bullying. Not bullying. They didn't bully that man, did they? They did. They jacked him up against the wall. All of it. All of that. All of it. They bullied that young man. And get mad when we talk about it. So they said the outcome of the case, because had they not bullied Woody, he may have never testified. He may not have said he's going to lie, a whole lot of stuff. If it was a field, there's a lot of stuff. If this happened, that may not have happened. Copeland is a key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas. Now that's an interesting, statement right there. Weinstein is saying Copeland is a key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas. He goes on to say, while the case against Kendrick is weak at best, even with the testimony of Woody, without Woody, the state has virtually nothing attaching Kendrick to the murder of Thomas. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick had a right to participate. So they're saying Weinstein saying for his client DeMonte Kendrick that Woody is the only thing connecting DeMonte Kendrick to this murder of Nut Donovan Thomas. And without Woody, you can't even connect Donovan. You can't even connect DeMonte Kendrick to the murder of Donovan Thomas. And they say even with Woody, it's still weak because his testimony ain't worth a damn. Woody already said that he has the credibility issue when it comes to talking to the police. He's going to lie to them. Hey, Jiggy, whatever the case may be, Jiggy said, I don't think Woody was tricked. He said that he was intentionally helping the defense and found a very, very clever way to get the state caught up. And that could be true. Whatever Woody doing, somebody said he doing something right. Because he out living his best life. Got a social media following on all platforms. Giving interviews left and right. We got to get Woody over here. Woody, we need you to come to talk that law. And we ain't going to ask you nothing about the case. Yeah, thank you. If y'all don't mind hitting the like button on your way in, because when you leave out, you're going to forget. All right, let's keep going. A mistrial should be ordered by this court given that Glanville denied Kendrick's constitutional right to be present at the critical stage of the trial, the ex parte meeting with Copeland. Furthermore, this mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would go Kendrick into moving for a mistrial. So I agree, the state has some responsibility. In the state, you cannot cause a mistrial and then try to get a second bite at the apple by having the case start all over again. So what the lawyers are saying, this should be a one and done. You tried and you lost. Right. The state and the court used their influence to pressure his testimony. He didn't want to testify. Let's see what Sean got to say. Let me see if I can separate it so I can actually read it. They didn't bully him, bro. He thought he could plead the fifth, so the judge had the meeting to explain to him what was going on. But they could have done that in open court, but they didn't have to. Well, that's the issue, and that's exactly what we're talking about right now. According to DA Love and you, they didn't have to do it in open court. So what you're saying is they had a right to have that secret meeting behind closed doors. Because you're saying, but they could have done it in open court, but they didn't have to. That's an interesting take. And that's why we're here today, because we think that, that should have been disclosed. They could have explained that to him in open court and sent him back to his cell. Matter of fact, I believe it was explained to him on Friday, before he testified what would happen. Not only that, he has a lawyer. The court and the prosecutor, is not their duty to explain to a client what the law is. That's why you have counsel. His lawyer could have explained to him how he could cure his contempt, how he can purge it, how he can get out of jail. That's what Caleb was there for. That's why he had what's the lawyer Caleb stood in for? That man. Now his name is slipped my mind. All right, let's keep Melnick. Thank you, DJ. Melnick. So many names to keep up with. All right, let's keep going. Mistrial is required because Chief Judge Prosecutor Glanville tainted the proceedings. See, this goes directly to what you just said. Let me scroll back up, Sean. They said the judge tainted it. This is what the lawyers are saying. They said, and they used the word bullying. They bullied that man. And they used the word bullying in emotion. That ain't my words, but because my words would be much worse. But they definitely, here we go. They bullied him. But everybody got the right to their own opinion. But that's why we're here. That's why we're here. Copeland testimony is tainted. And some of this stuff is repetitive, so I'm just kind of like skip reading through it. They saying the judge pressured that man in the face of his repeated refusal to testify. Not only that, Copeland saying that he's gonna lie on the stand. All of that was an act of impermissible intimidation by the judge in a violation of the judicial code of conduct. See, the judge could have never put himself in that situation. He could have told Love hell to the no. To the no. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions. And the state's actions in working with the Chief Judge Glanville, when he intentionally tricked kindred into the only possible outcome. This motion for a mistrial that should be granted by this court. So they didn't say that 1,000 times, but I know it's necessary just for the record purposes. And as a natural result of the state's actions, they said the judge, prosecutor, Glanville, has violated multiple rules of the JCC. And they also violated kindred's constitutional rights to due process and a fair trial. And see, it's important for the there you go. all of that. All of that. All of that. All of that. After question by the state, Chief Judge Glanville had an improper proceeding. And the thing is, you want to tie the state in there. If you say, hey, the judge did something bad, then what can happen is the case can get thrown out and then the prosecutors can start all over again. But you want to say, not only did the judge do something bad, the prosecutor did something bad. Because when you tie the prosecutors into it, now you're saying that it should be dismissed with prejudice where it could never be brought again. They can't retry it like the Alec Baldwin case. So it was smart for them to say the prosecutors committed misconduct, not just the judge. We don't want to redo with a new judge. We want it to be done for good. Not only that, they want the prosecutors. Somebody else filed a motion to dismiss the two prosecutors, Hilton and Love. See, and I think Hilton probably meant well when she first started off, but she started hanging around Love in the midnight hour, and Love started rubbing off on her. D, please don't get Jiggy started. That's all Jiggy need to see. I don't know what evidence, it don't even seem like Woody's snitching now. Let me tell it. It seemed like Woody testimony helped them more than it hurt them. All right, so we kind of know. And they got a rule here in the footnote, Rule 4.1. It generally prohibits ex parte communications except authorized by law or rule. Judges shall neither initiate, which they did, the prosecutor initiated, but he considered. So you can't initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. It's only authorized, secret means, in extraordinary matters, like a temporary restraining order, temporary injunctions. In other judicial hearings, both parties should be notified. And that's common. If it's a restraining order, something temporary, you can, and it's an emergency, you can get one side can go to the judge, and later on, when you have a formal hearing, then you can bring in both sides. So that's how I normally go. And then Rule 2.9. The judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. Judges shall not initiate, permit, or consider ex parte communications or other communications made to them outside the presence of the parties or the lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. And you got a few exceptions here, like scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believed that no party would gain a procedure or tactical advantage. The prosecutors gained a tactical advantage when they got a witness in the back room with the judge and they threatening him. That's a tactical advantage. They saying you can't do that, Glanville. Guess what? He violated B. The judge makes provision promptly to notify all the other parties. Did he do that? No. What did he do? He got mad because they found out. And he wanted to know who told, and Brian Steele wouldn't tell him, so he held Brian Steele in contempt for the maximum amount of 20 days. And then it goes on to say judges may obtain advice of a disinterested expert on the law if they give notice to the parties of the person consulted in the substance of the advice and afford the parties a reasonable opportunity to respond, which don't apply in this case. Conduct which assures every person a fair hearing. Ex parte communications are presumed to have been in error. So that basically means we start off saying that if you had an ex parte meeting, we're going to automatically assume that it was error. And then we can disprove if it wasn't an error. But what that say? Kimberly. Kimberly said Kayla tried to jump in and swing her purse, but Love tagged Hilton in and tag teamed her, all while Glanville was holding Woody by his shirt saying, "You gonna testify." Oh. Kayla wasn't going down without a fight, I'll tell you that. And not only that, she used to be a prosecutor, so she know they tricks. She know how the way they move. Shout out to Kayla. Likely prompted by the state, not only did Chief Judge Glanville fail to notify defense counsel, as required by Rule 2.9 with his sneaky self, but he made every effort to conceal it. And all this started because Woody pled the fifth on that Friday. Chief Judge Glanville should not have, what she say, put Woody in a headlock and force him to testify. A trial judge should not attempt to intimidate or actually intimidate, not attempt, actually intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. And that goes all the way back to a 1976 case and a 1938 case. The situation of the prison case is similar to Welby, Texas, a 1972 case. Not Texas. What we did now. While in Weld, a trial judge intimidated a defense witness into not testifying. Wow. See, I'm not familiar with this case. Intimidated a defense witness into not testifying. And it's similar to the present case. It correlates with the present case. How? Because in the present case, Chief Judge Glanville intimidated a state witness into testifying. So in Texas, we out here intimidating people into not testifying, and Glanville intimidating people into testifying. And then let me go up and see some of the footnotes right quick. Okay, they may consult with court staff, consent of the parties. So all of this stuff don't apply down here. In reversing a conviction in Weld, the Supreme Court said that in light of the great disparity between the posture of the presiding judge and that of a witness in these circumstances, the unnecessarily strong terms used by the judge could have exerted such duress on the witness' mind as to preclude him from making a free and voluntary choice whether or not to testify. And that's why judges should be in the back room, because you don't want to be accused of putting so much duress on Woody by saying that you're going to keep him in jail way past 2 years until all of the defendants are tried. That's a lot of duress that will make him testify, and he would lose the use of his free will and his voluntary choice whether or not to testify. Y'all see the law right here. Wait, what she talking about? These YouTubers would be in my paperwork if I was stuck. I mean, you just never know. You never know what defense lawyers might try. Anything. Anything. And if they find out that something was discussed outside of court, then they could bring it up. But that ain't mean they have to prove it. ID at 98. And he basically said that same thing, that same disparity occurred with Copeland. The same thing that happened in Texas in 1972, probably before then, by the time I made it to the court, it was 72. It's happening right now in 2024 with Copeland. A trial judge in his chambers, in cooperation with prosecutors, surrounded by investigators and law enforcement. See, all of these law enforcement, these are basically police officers. They coerced Copeland with the threat of years of jailing. Woody said, I can do 2 years. But more than that, he said, I'm telling it all. He said, what y'all want to know? And I mean, you kind of get it. He spent most of his life in jail. So he really ain't got no years to be given, back. When he got a daughter out there that he trying to support. And he said, you know what? He came with a clever way. I'm going to testify, but I'm going to do so where I won't hurt Thug. And then I don't have to stay in jail. I can come out and be a celebrity on the outside, a hood celebrity for my neighborhood. Oh, y'all got a whole little combo on the side. Erica, journalist who talks and takes picture with the defendant's parent. Yeah, I'm trying to. Yeah, I see the chat. I'm trying to, read things, but I'm taking a break every once in a while to see what y'all talking about. Somebody said Woody probably should be talking to anyone. I mean, and like the court say, as long as they're not talking about the case. If you're not talking about the case, now could he open up a can of worms? Right, I better leave that alone. See, Lee knows something I don't know. You know something I don't know. Let me say, leave it alone. Keep reading your little paper. Keep reading your paper because you're gonna step off in some. Let me keep on moving in. This train gonna keep on rolling. Let me mind my business and what I say, and drink my. Get him, Joe. Say my water. Joe say mind your business and drink your water. Y'all ain't saying nothing in the chat. Let's keep going. The state of the judge exerted such duress to preclude Copeland from making a free and voluntary choice whether to testify. Thus, Kendrick, who was neither present nor represented in the secret meeting, was deprived of his 14th Amendment due process rights. Yeah, he was deprived. He should have had a right to be there. And that's why when the judge started deciding these motions that we're reading right now, the clients need to be in the courtroom so they can know what's going on. And if the judge is going to make a decision about pretrial, bond, stuff like that, especially at this stage in the trial, considering everything that's been going on, you don't want to leave the clients in the dark about anything. Kimber says she's trying to read between the lines. I am too. I may need to make this print a little bigger. Widen the gap so I can see what y'all see. Hey, Tiff State, thank you for joining. All right. Yeah, if y'all don't mind hitting that like button for the chat. Thank you, Kimberly, for all right, let's keep going. As in, in the Texas case, this court can't repair the infringement of Kendrick's due process rights under the 14th Amendment, no matter how hard you try, Judge Whitaker. He's telling you, you can't fix what is broke. Regardless of whether the violation was under well or when, however you want to pronounce it, Kendrick's rights were violated by the judge's intimidation. As the state likely expected, Kendrick has now been goaded into seeking a mistrial. They wanted a mistrial, is what Weinstein is saying, because of the due process violation, and respectfully, regretfully request a mistrial. They said the state knew what y'all was doing. They said they planned this. They set it up because we was beating them and they wanted to start over and they needed a way to do it. They not slick. Thank you, Tim. All you gotta do is turn off live chat replay. That's Politic Mail anytime. Thank you for the coverage and knowledge. Oh yeah. Some people don't learn from their previous lessons from covering other trials. They get too involved for cash app scams and checks. Not scams and checks. People still writing checks. Somebody say cash out. Cloud. Thank you, Erica. Oh, y'all funny. I'm not sure. The last I heard, someone had said that she got hacked, not once but twice. And they keep deleting all her videos. And I believe they did that to Woody's videos too. So I'm not sure what's going on with that. So I know she had got like a lot of views and a lot of subscribers from those videos. And then all of a sudden, somebody going in deleting them. But if she got them saved, then she probably can just put them back up. But I don't know how to stop somebody from taking it back down. Speaking of cash apps, what's yours? Yeah, don't have them people. They'll be writing about me next. But thank you, Tiff. I posted at the bottom right here for a few seconds. No, I haven't. And I don't plan on it. I guess I keep talking about the wrong people. Somebody gonna try to get up and knock it down. Oh, somebody said he was advised to take that stuff down. Everybody got hacked, huh? Somebody said ain't no hack. It's called the Bar Association, not the bar. I mean, I don't. Let me. That's what I heard. Yeah. This is all hearsay. I mean, don't give me the line. Y'all gotta confirm that with her, but that's what I heard. India. Movie said they do. You might as well put yours up. Yeah, I created one when I first started. People were asking. All right. The Bar Association is on. You may have to remove this video. They hack you. You might as well go to the club. He said, y'all let them play with your intelligence and common sense if you want. Jiggy ain't going. I have no idea what none of this. Yeah. Okay, so she did say her channel was that. Okay. I thought so. Yeah, she had a lot. Actually, she had invited me on that first live. I was on that one with the 80,000 views. So they took us down? What? I gotta call Kayla. Kayla, put that video back up. D said, I made my ruling. I made my ruling. And that's the order of the court. All right, y'all. Let's see if we can push through this motion. I think we're at the end. Wherefore, Kendrick respectfully and regretfully requests his honorable court to declare a mistrial based on the practical impossibility of avoiding this case after June 12, 2024, the violation of Kendrick's rights by being, where are we at? June 12, 2024, the violation of Kendrick's rights by his being absented. They kept him away at a critical stage. And not only that, they tainted the testimony. They tainted the judge's chambers. Somebody said, nah, them chambers was already tainted way before that. You're going to tell it. Let's tell it all. Let's keep it right. It's tight, but it's right. I ain't making it up. Y'all know it. And they tainted it by having him in that headlock while he was handcuffed. We can't forget he was handcuffed and shackled while he was in there. It's crazy how they treat you like a big threat when you're in custody. And the only reason he's in custody because he didn't want to testify. But if he testifies, then all of a sudden the shackles come off. Or he don't need to be in jail. He can freely move around the court. And that's the same thing Young Thugman was saying. Y'all said that these other guys were so dangerous and they shouldn't get a bond, Young Thug co-defendants, but as soon as they pled guilty, all of a sudden they're not a danger anymore and they're eligible for probation and you can let them back out on the street. Okay. So, furthermore, Kendrick respectfully requests his court to find for a mistrial based on the meeting. And it was signed today, July 23rd, 2024. Then the certificate of service. Whew, yeah, that was a lot. I don't even want to know what y'all saying over here in this chat. Killy Boxy, this trial is done. Is it Killy or Kylie? Killy. This trial is done. Was there another motion? Let's see. I don't think I got, let me check my email. I don't think I got the other motion. So what I'll do is, it looks like there was a bond motion. Second renewed motion for a bond. I asked a judge yesterday for a bond. She said, "You done asked me 7 times. I'm not touching this bond." Well, hurry up and put me in front of the trial order, the trial docket, so we can go ahead and get this over with. Wait. What happened? You saying the state got a motion for the media? The only thing with starting over, she might not get the case again. So if she do a mistrial, more than likely it has to go back into the wheel, and it might be another random judge that get it. So she may not. The camera's gonna leave the courtroom. I don't know if that's if they do it for her. Maybe she don't care about the fame and the fortune. The rich is untold, or the silver and the gold. Hey, what's going on, Keys Mobile? Okay, yeah, I'm gonna go and find that other motion. Tracy, I think that was the check one so fast. Oh, yeah, there we go. All right, so we got the second motion for bond. No bond has been issued for Kendrick. He's currently been held in the Fulton County Jail for over 2 years, since May 9th, 2022. Charged with the following 9 counts: 1, 2, and 57 through 63. He was denied bond in 2022. He was denied bond in 2023 after the state argued that the defendant and his co-defendants were a danger to the community. And that's what I was talking about earlier. They such a danger to the community, but let them say they want a plea deal for probation. Then all of a sudden, they're not a danger to the community. They can go home. Number 4, since the denial bond in 2023, the state has presented its weak case in a plotting manner with no apparent concern that Kendrick and his co-defendants at trial are incarcerated, presenting witness lists that at times have topped 700 witnesses. But this judge that they got now, she said, we ain't gonna have no 700. She said, I'm going to exclude all these unnecessary witnesses. Not water to a well. Y'all got there's so many comments going, I can't keep up with them all. Let me keep going. Today, the state has presented almost 100 witnesses, and none of them said a damn thing with no end in sight. While the state has argued that Kendrick is a threat to the community, none of the 100 witnesses have presented any testimony demonstrating that threat. Lying love. The state has 7 months to do so and has failed. The state saying they don't need a bond. They dangerous. They threaten the witnesses. What witness was threatened? What witness was threatened? Y'all had 100 people in here and not one said they were threatened. I can't keep up with y'all. Y'all be this chat be moving. Kayla, they say you may need to start a backup channel and load them there as well. Yeah, some strange for them to keep deleting, taking their stuff. Politicking with Mel, yeah. They said all these people were scared, and not one said they wouldn't understand. So many like, yeah, they're lying. Let's see what page 2 is. This, let me see, page. What number was that? 5. Since the denial of bond, the state has offered and entered into plea agreements. See, this is what we argue as attorneys with at least defendants Murphy, Arnold, Stevens, Greer, Kitchen, Sledge, and Lee, permitting them to return to the community. This offer was despite having previously argued to this honorable court that those defendants pose a threat to the community. Right, you're saying that they bad people, they so dangerous, they need to be locked away in prison. As soon as they take probation, oh, you can let them out. They good now. What? The court having been convinced and connived by the state's arguments before should no longer provide the state with the benefit of the doubt. One must now question how much of a threat the state truly believes these defendants pose. Therefore, any argument made by the state in opposition to this motion ring hollow. Right. If anybody bullying, it's the state. It's the state riding around bullying the witnesses in the back room. They had Woody in there. It all started on Friday, June 7th. What she said, 7 p.m. Friday, 95 degrees. The state say we ain't got no case, and no case ain't got me. It all started on a Friday. Yeah, Keys Mobile, where is the threat? They ain't got no case. She said the killers have been released. Not the killers. Hey, so who the shooters? I was in the car when we slid. That's what Woody said. That's on my kid. I was in the car when they slid. Who was in the car, Woody? India, don't pay me no mind. Let's keep going. Let's keep going. Let's keep going. He said that it should ring hollow. That means empty. Y'all told so much lies that y'all lies are empty now. The court has granted bonds to Miles Farley following his severance from the present trial. Yeah, did Miles ever get out? I know the judge gave him like a $650,000 bond, but did he get out? Or I mean, it makes no sense to have a bond and you can't pay it. I mean, right? You still gonna be. That's like a judge. She take my client's bond from $2 million to $1 million. Judge, you should have just left it at the 2. You gonna go to 1? Oh, Miles been out. Okay. But see, Miles, he been out, but he ain't get the well, he's a defendant here. So he really not he not situated like Woody. Woody can go on social media and because he's not under indictment that can go to jail. But if Miles, it'll be a bad idea for him to do it because he's still fighting for his life. Because he still got to have a trial after this one is over with. I think Miles is the one. his lawyer had went to jail for like a prescription bottle or his medication. I believe that was a setup. Okay, number 8. Kendrick poses no significant flight risk. He's not gonna fly away. He's not gonna flee. Especially now they win and they're not going nowhere. Number 9, Kendrick poses no significant threat or danger to any person. It will not jeopardize the safety of the community. 10, Kendrick poses no significant risk of committing any crime pending trial. 11, Kendrick poses no risk of intimidating witnesses or otherwise obstructing the administration of justice. Kendrick assures his court, he promises the court that if you give me bail, judge, I'm not going to flee, I'm not going to hide, and I will respond to whatever you want me to do. Any of your orders directed by the court. 13, reasonable bond is one that is adequate to assure the principal accused will return to face the judgment of the court. But at the same time, one, let's see if we can get page 3, which is attainable by the defendant. In this case, the court's failure to set a reasonable bond for Kendrick has kept him incarcerated since the date of his arrest over 2 years ago. And if he was to get bond, judge, number 14, through a surety authorized by the state of Georgia, he could go back to work and he could pay his attorney. He could pay his lawyer because his lawyer ain't been getting paid. And then also he can aid counsel in preparing his defense. He can help out the lawyer work on his case outside of custody. So he basically saying, Judge, give me a bond. Quit playing. I don't know, King ATL. Why would they want to mess with Woody at this point? King ATL. Because I don't think Woody is doing anything right now that's going to hurt their case. In fact, I might even argue the opposite. If something happened to Woody in the middle of this trial and the jury find out about it, you don't want them accusing your client. You don't want them accusing Young Thug of having anything to do with that. So I don't think that'll be smart. No, I really don't. Because we got to remember the tapes and the interviews of Woody was coming in. They would have brought in the detectives, and the detectives could have testified to what Woody told them through the tapes or played the tapes. But now that Woody testified, Woody can say, yeah, I did give interviews to the police on tape, but guess what? All those tapes were lies. I was saying what I wanted to say, what I needed to say to get me out of jail. Don't believe nothing y'all hear me say on that tape. Yeah, D, but what was that connected to though? Do you think that was somehow connected to this matter? Or was that something that might have been something separate? Put it like that. Hey, what y'all think about that? So let me see if any we went through the, let me see. Oh, somebody okay, let me find that. What was the motion I was looking for? I think it was this one. And this was the previous motion that some people already read. It was just basically Brian Steele. It's just basically the same day Brian Steele. He filed another motion as well on top of this one. But he basically wanted Judge Cross' order to be reworded because Judge Cross said Glanville did nothing wrong. Let's go through it real quick. He said he don't want the result of Judge Glanville get kicked off, but he do want he do challenge the way she wrote her order because she basically said that he did nothing wrong. Glanville did nothing wrong, and Brian still said his client, Young Thug, is innocent of all crimes. And he said the Honorable Judge Cross made two findings that are respectfully, disrespectfully erroneous in her order granting the recusal of Glanville on July 15th. Young Thug is not challenging the result of the order, but they're challenging her wording. Judge Cross wrote divorce from his hyperbole Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the secret ex parte meeting. Let me get, hold on. There ain't no really meat on here. Let me get the page too. And y'all let me know. We're waiting on more motions to come out, and they have until 5 o'clock today. And right now, I believe in Georgia it's 4:12. Here we go. Brian still go on to say, it is worth noting that the Honorable Judge Cross agrees generally with Judge Glanville's assessment of the secret ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Now, she know that's a damn lie. That meeting was wholly improper to have a meeting in the back room like that. And that's what Brian still said. This finding is wholly against the law. At the improper ex parte hearing, Mr. Williams and his counsel had a right to be present for several reasons, including but not limited to the fact that Woody provided statements bearing on the substance of his testimony, but also his credibility. Woody said, I was lying. He said, not only was I lying to the police, I'm a lie right now when y'all put me on the stand. Yeah. There was enormous amounts of Brady evidence shared at this meeting with lawyers Love and Hilton and Judge Glanville, and they all attempted to keep it a secret. And the Brady material is basically evidence that Woody saying, I did these crimes. Not Young Thug, not DeMonte Kendrick, and all the other ones. But he's saying, I did these crimes, is what Woody said. That's something that Young Thug's attorney has the right to know about. Did they make you clean out the closet? Young Thug's outfit manager. Did they say clean it out? Let's keep going. He say there was no lawful reason for this ex parte get together. Not a get together, a get together like a barbecue, a cookout, a family reunion. What y'all back there getting together for having to get together? She said, "You right, you right." He said Rico ain't show up, but Brady show did. Wait, what? Perry, wait, who is Perry? Oh, y'all having a conversation with y'all amongst yourselves. Regina say it's a cookout. Brian still. Boy, Brian ain't no good. It was no reason to have this get together. Okay. Brian still say there's more reasons. He did some more wrong. Brian said there's some more stuff. There's some more skeletons in the closet that he got going on. And some more of her rulings are completely wrong by Judge Cross, but it do not affect the outcome of the correct ruling, recusing the previous trial judge. He say, wherefore Mr. Williams respectfully requests that this motion be spread upon the minutes of the court, and if needed, stands ready for a hearing on the same. God, boy, you better write that motion, Brian. Write that motion. He say, spread it on the minutes of the court. And if need be, if necessary, stands ready for a hearing on same. Oh, man. Let me see what else. This was another motion. I think it was really short and straightforward. What's going on, Simone in HD? Thank you for popping in. You must have just left one of your other channels. Just playing. Don't be coming over here in the fourth quarter, flipping on in like nobody wasn't gonna notice. Nah, shout out to Simone. We got another motion, y'all. Shard just dropped the motion. Let's see if we can find that one. So, but this one right here that I got pulled up is basically a motion to strike any testimony that happened after June 12th. We kind of went over that in the YC motion. They say anything after June 12th shouldn't be allowed. So all of the jury notes and anything that mentions anything after June 12th should be struck from the record. Let me see if we can get a new motion right quick. Let me see if I can find it. Is there? When all else fails, where do we get motions from? Somebody say, shout out to Thugger Daily. Oh man, I don't even know which one is which. Hold on right quick. Let me close some of these because they all starting to look alike. Okay, so this was just filed 3:07 Eastern Time in the Superior Court of Fulton County, State of Georgia, versus Shannon Stillwell. A motion for a fair and constitutional trial. Shout out to Chicky. Thank you so much. Chicky, you was here on time. First one. Oh, thank you, Road. So, all right, let's go. So this is like something that you're guaranteed by the federal and state constitutions. So it's just funny to put it on paper, but when you haven't been getting a fair trial this whole time, I guess it's about time you ask for one. So motion for a fair and constitutional trial comes now. Just some lawyer legalese language comes now, Mr. Shannon Stillwell, by and through undersigned counsel, and hereby files this motion for a fair constitutional trial. In support of this motion, I'm going to show you why I wrote it. And I'm going to show you as follows. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia Rico law and substantive felonies in this indictment. Mr. Stillwell is factually innocent of the charges against him. And obviously that's, a jury determination. Question for the jury. Oh, thank you, T, for sending me that. I'll open it up after this one, a better copy, so we can actually. So number two, like all citizens, Mr. Stillwell is guaranteed a fair trial and due process at trial by the federal and state constitutions, the Confrontation Clause, and the Due Process Clause, and all other constitutional protections. This might be a better copy to read. Let me make it bigger. Shout out to Tia for sending it to me. Okay, here we go. Number three. Mr. Stillwell demands that this trial be conducted in a fair and constitutional manner. The state is seeking a life without parole sentence for Mr. Stillwell if he is convicted. And Mr. Stillwell's constitutional rights must be protected without exception. We're not going to give you an inch of violating our constitutional rights of our clients. He said without exception. And this is why lawyers fight so hard. They're trying to lock him up for life. If you have so much evidence, anything you do should be out in the open, not hiding in the back room, trying to curry favor with the judge. Okay, number 4, Mr. Stillwell and his co-defendants have been in trial for approximately 19 months for reasons unknown. Approximately 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of his trial. I don't know. I think they were joking around. Somebody mentioned it earlier. But it was so many comments I couldn't even read them all. Let me see what this I was started, but I'm here before going to any other channel. Don't do that, Tom. Well, let me know then. I didn't know. I said, She done got caught in another chat because somebody that came and told me. I'm just playing. I'm just playing. Okay. Number 5, Judge Earl Glanville has been the trial judge to this point. This case has been plagued by discovery violations, lost and missing police report. Now, they ain't lost, they destroyed. They hide them. And Brady violations. The defense also takes issue with several of Judge Glanville's legal rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801B2E. Most recently, Fulton County District Attorneys Hilton and Love took part in the ex parte meeting with the Judge Glanville. This meeting also included witnesses, Kenneth Copeland, well, I guess it'd be just one witness, his attorney, Caleb Bumpus. Neither Mr. Stillwell nor his attorney were informed or invited to the cookout. They weren't even invited to the get together to attend that meeting. The same is true for all of Mr. Stillwell's co-defendants and their counsels. No, they didn't invite y'all. And y'all found out anyway. Number 6, Kendrick filed a motion to kick out the judge on June 12, 2024. And of course, Glanville said, "Nuh-uh, I'm not going away." He denied said motion. Kendrick's motion to recuse, as well as a similar motion filed by co-defendant Young Thug, were subsequently considered and granted by the Honorable Judge Rachel Cross way in July. And she did that because she had no choice. Talking about the judge didn't do, Judge Glanville did nothing wrong. Woman, going on with all that. We know he gave you $2,000 for your campaign. Number 7, Mr. Williams, through his attorney, has since filed a motion for a fair trial on July 10th. Williams' motion alleges and discusses several ways in which this trial has been unfair and has failed to meet constitutional requirements for Mr. Williams. Mr. Kendrick, through his attorney, also filed a similar motion July 23rd, 2024. Mr. Stillwell adopts both of those motions. Just so we're clear, because the Harvey rule covers all of the defendants, but just to be clear, he's putting it in paper, he's putting it in writing that we adopt all of those motions and incorporates their contents into this motion, as Mr. Stillwell has been similarly affected by the errors in this case. Mr. Stillwell does not wish to demand a mistrial, absent jeopardy attaching. So this is an important line right here that, so we can be clear. They basically are saying the only way we want a mistrial is if the case could never be brought again. So what they're saying is, if you give the state a mistrial or give the defendant a mistrial and you let the state re-prosecute the case, and we have to start all over again, then Matthew Shard said, I don't want it, or Matt Shard said, I don't want it. Because he knows he has a chance to win this case. But if you kick out the case and the prosecutors can never bring it again, then do that. So I believe that's an important sentence out of this whole motion. This is like the single most important sentence in this whole thing. He does not wish to demand a mistrial absent jeopardy attaching. Mr. Stillwell has been incarcerated since and has suffered through the duration of his case. Starting trial all over again is not a viable option for Mr. Stillwell. Furthermore, the defense has completely neutralized all testimony. He said they neutralized all of y'all weak testimony, state, and documentary evidence presented against Mr. Stillwell thus far. He's saying that they're kicking y'all butts in the courtroom. In other words, the defense is winning this trial. Well, make it plain. Make it plain. Make it plain. You see what it say? He said the defense. Is winning this trial. The confidence to put that in writing to the judge. Judge Whitaker, we know you haven't been here since day one, but guess what? The defense is winning this trial. Not only are we winning, but it said the defense is winning despite the persistent legal errors, despite the cheating that the DA's office has been trying to do to get an edge on the case. Despite the Brady violations, the ex parte secret meetings, the withholding discovery that you're supposed to turn over to the other side, you're supposed to give all discovery to the defense counsel, prosecutors, you know that. All of that stuff that plagued this case, they still winning. And Mr. Stillwell specifically said he do not want to start over. Matt Shore said, I'll take my chance with the jury and get a not guilty verdict, then start all over again from scratch. Then my client have to sit in jail for way longer. They've been doing this since the beginning of time. Putting people in jail based on eyewitness testimony or supposed eyewitness testimony. You shouldn't be able to put someone in jail for life based on what somebody said. Sean said them boys might come home, man. And they may actually come out better than the people that took plea deals. Because the people that took plea deals are going to be on probation for what? Some of them 20 years, some of them 15 years. But if these 6 defendants win, they could come out free. What they say, not being on nobody's paper. Somebody said he putting up ops on the screen. Who the ops? Sean said them boys might come home, man. Politicking with Mill said they definitely coming home, just a matter of when. Yeah, 20 years of probation is crazy. Yeah. Let's keep on going. Nonetheless, serious errors have tainted this trial and continue to prohibit Mr. Stillwell from receiving a fair trial and from confronting witnesses called against him. Mr. Stillwell's due process rights have been and continue to be violated. These errors, as described in detail in the Williams and Kendrick motions, have been caused solely by the Fulton County District Attorney's Office and Judge Glanville. Who runs the Fulton County District Attorney's Office? That's true. The state playing dirty. And I believe at one point, even the judge, Glanville, he got frustrated with him. He said, give him your file. He said, when Fonnie Willis was trying cases, he said that she always turned over her evidence. She gave her whole file. She said, hey, if I give you my file and you beat me with my file, then you deserve to win. And not only that, but you're required by law to give over your file, because if you don't and the prosecutor win, then the conviction will be thrown out. If the lawyers ever find out that something was withheld, a lot of times you don't find out something was withheld until maybe it could be years later. A new DA's office come in, a conviction integrity union might come in and look at it and find out that the prosecutor was holding stuff back. Let's keep on. These errors cannot be cured by curative instructions. You just can't tell the jury, oh, jury, forget about it. You know, you remember what y'all heard from June 12th? And every day after that, just forget about it. Anything after June 12th? They said you can't fix that with a curative instruction, and will ultimately prevent these proceedings from meeting the federal and state constitutional requirements, adhering to the Georgia rule of evidence, and fulfilling the requirements of Brady. And I agree, it's going to be hard to, even though I believe this judge might try it, because the way she got all her rules and stuff down, she might kind of like being on TV. But there's no way the jury can be fair after so much time has passed. Mr. Stillwell specifically incorporates past and future filings on behalf of co-defendant Williams and co-defendant Kendrick and the list of legal errors, prosecutorial misconduct, Brady violations, discovery violations, and other legal arguments included therein. Wherefore, undersigned counsel respectfully request this court considers Mr. Stillwell's arguments and issues in order which will fully and adequately protect Mr. Stillwell's constitutional rights. This 23rd day of July 2024, Max Sharp. Why I called that man Matthew earlier, Max. And he served a copy to the Fulton County District Attorney or one of her agents. And hopefully it wasn't love, because she gonna say she ain't get it. She gonna say she ain't get it. Y'all know how she play. The defense got to get a dismissal or mistrial with prejudice, because if it goes through, I think they'll find them guilty, but they'll definitely have a good chance at appeal. I don't know, because I don't see guilty nowhere in this case, and it could just be me. What y'all think? Guilty or not guilty so far? Sean say guilty. Sean say if the jury, after all this time passed, yeah. Keys Mobile agree with India, hung jury or acquittal. Gigi say not guilty. Erica say they haven't proved anything. Ms. Daniels say send them in home. Tracy said they may be guilty for being in a game, but it's not illegal, so it's not guilty. Shout out to Tracy. Regina, not guilty. India said, I don't want it to have to be appealed. Appeals take years to get resolved. Regina said not guilty, but she gonna even add a little further, not guilty beyond a reasonable doubt. So yeah, it's a lot. And I believe they have what 20 more minutes to file any more motions that haven't been filed already. Somebody said they're waiting on Steele to file his motion. I'm trying to see now. Let me go back and search and make sure nothing new came in. I know y'all watching it. Y'all on it quick. I think we got another one, y'all. We got another one that just came through. Well, if I can get the thing open. So this is another motion. Not Law Malcolm say guilty. That's charged. All right, let's go through the second motion that was filed not too long ago. All right, here we go. Motion for reconsideration regarding certain hearsay statements. So I can make this bigger. It don't look like it's that big. Hide this. Get that out of the way. So I can blow this one up. Shout out again to Tia for sending me these clean copies that I can read. All right, let's go through them again. Comes now. He said, I'm not done. I back go. Max Sharp. Mr. Shannon Stillwell. And files his motion for reconsideration. In support of this motion, Mr. Stillwell shows as follows. What do you show? I want to know. Mr. Stillwell is accused of multiple felonies, including count 1, conspiracy to violate the Georgia Rico law, and specific substantive felonies. Ooh, it's a lot of reading today. Mr. Stillwell is innocent of all the charges against him. See, my only thing when you have motions and they're like similar, you probably want to use different language because I know this paragraph is exactly the paragraph that I just read on his other motion. And sometimes judges have short attention spans. You don't want them to look at it real fast and say, I already read that. You don't read it. So I always try to diversify my motion with different language, just so judges get like a different feel for the motion. And you don't want them to get, bored from reading the same stuff over again. But everybody got their own style. So here we go. Number 2, Mr. Stillwell is charged January 10th, 2015 with the alleged murder of Donovan Thomas and count 2 of this indictment. Mr. Stillwell is innocent of that charge as well. Number 3, Woody, a witness called by the state, is currently on the witness stand. Woody has never claimed to have any firsthand knowledge regarding the death of Donovan Thomas, aka Nut. Woody, however, did meet with law enforcement several times in 2015. On June 10th, 2015, in what was Copeland's 5th meeting with law enforcement in 2015. We sure got a lot of 2015s in that sentence, huh? Mr. Copeland told law enforcement that he possessed specific information regarding the shooting death of Donovan Thomas. Mr. Copeland, aka Woody, made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Woody did not mention this information on any of the 4 prior meetings with law enforcement. So obviously that's a problem, right? If Woody had 5 meetings with the police, 5 meetings, and the first 4 he never said nothing about Shannon Stillwell having anything to do with a murder, then all of a sudden on meeting number 5, there's you're talking about a murder out of nowhere, then that could be cause for concern. That could mean that somebody lied. And not only that, Woody said that when he was at the police station, he was lying. He said, I was doing a whole lot of lying. Let's keep going. June 10th, 2015 interview, Woody told law enforcement that he picked up Demikian Garlington at a McDonald's restaurant on Cleveland Avenue on the evening of January 10th, 2015. Woody reported that Garlington walked to his Copeland's car, and while the 2 men were briefly alone, Garlington told Copeland that they killed Nut. I don't know who is they, but Garlington told Woody that they killed Nut. Woody told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland told law enforcement that he had interpreted Garlington's words and actions to mean that Mr. Stillwell, Mr. Kendricks, Mr. Justin Cobb, and Mr. Demise McMullen were all present for and all participated in a drive-by shooting of Donovan Thomas. Per Woody, Demise McMullen, I may not be saying it right, entered his car shortly after Garlington, and all communication about the event ceased. The event, yeah. Y'all be having some names down there in Georgia. Well, that's interesting. I feel like I almost got to read that again. Anybody understand that? Let's just go through real quick. So Woody told the police that he picked up Garlington at McDonald's. So we got that part. And then once Woody got there to pick up Garlington walked to Woody's car, and it was just them 2. So we got Woody and Garlington by Woody's car. And while they were alone, Garlington told Woody that they killed Nut. So Garlington made a confession that they killed Nut. So I guess we got to find out who is they. And Woody told the police that Garlington then pointed to a group of people who were pulling into the McDonald's. So I'm guessing he's saying, we killed Nut, and he pointed to the group that maybe supposedly did it with him. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that Mr. Stillwell, Mr. Kendricks, Mr. Cobbs, and Mr. McMullen were all present and participated in the drive-by shooting of Donovan Thomas. So it was never confirmed. That's Woody's interpretation of what he thought Garlington meant. And then per Woody, Mr. McMullen entered his car shortly after Garlington, and all communication about the event ceased. So I'm guessing once McMullen got in the car, everybody got hush-hush, because Garlington probably would have gotten in trouble for running his mouth to Woody. So once somebody else got in the car, the conversation was over. Let's go to number 5. Now, Woody is a sworn witness for the state, and he's currently on a witness stand. That man ain't on a witness stand. That man playing basketball, swimming in the pool, having a time of his life. On direct examination, this is direct examination when the state is asking Woody questions. Woody has not denied making this June 10th, 2015 statement to law enforcement. Woody has repudiated the contents and veracity of his prior statement, however. So now he's not saying that he didn't make the statement on June 10th, obviously because it's on video, but now he is taking back some of the stuff he said and the truthfulness, the veracity of some of the stuff he said in that video. Woody testified at the trial that this conversation with Garlington never occurred. So he said he was lying to the police. It never happened with Garlington. And that Woody, fabricated the event to get himself out of legal trouble. Furthermore, Woody had denied contextual clues surrounding the out-of-court statement, testifying that it was Mr. Stillwell and not Mr. McMullen who got in the car with Woody and Garlington that evening. All right, so that's kind of a lot right there. So they're saying not only did Woody change his story, first of all, he said he lied about it. And now he's saying that it wasn't even, the third person that got in the car wasn't McMullen, but it was Shannon Stillwell. It was Stillwell, not Mr. McMullen, who got in the car with Copeland and Garlington that evening. And that's to read this footnote. It should be noted that Mr. Garlington is charged in this indictment, so he's a co-defendant. But he's having a separate trial. He was severed from this trial as he remained unrepresented until the winter of 2022. So he don't have a lawyer. He didn't have a lawyer. Garlington is not expected to testify at this trial, as his case is still pending. Nut and Peanut were Donovan Thomas' nicknames. So that's a lot right there, y'all. That's a lot. Somebody said the state has filed a motion to prevent defense attorneys from talking to the media. Oh, wow. I haven't got that one. Let me check. Well, we're almost done with this one, and we'll take them in order. I told you, it's motions day. It's a lot coming down the pipeline. Number 6, Stillwell has challenged the admissibility of Garlington's out-of-court statements on hearsay and confrontation clause ground. Let me see something. Hold on. I believe that might be an error. Furthermore, Woody has denied contextual clues surrounding the auto court statement, testifying that it was Mr. Stilwell and not Mr. McMullen who got in the car with Copeland and Garlington. And then I think it's an issue right here. It probably should be Woody. Stilwell has challenged the admissibility of Garlington's auto court statements on hearsay and confrontation grounds. Let me see some. Oh, okay, I guess so. So what Matt Shard is saying, Garlington's out of court statement is the statement that he made to Woody, like we just killed Nut. So it's really not Garlington's. It's Garlington's out of court statement, but it came in is hearsay because Woody said that's what Garlington said, and that's hearsay. You can't tell me what somebody else said because you may have it all mixed up. I need to talk to Garlington myself. But wait, I can't talk to Garlington myself because he is a defendant. And as a defendant, Garlington has a Fifth Amendment right to remain silent. So obviously, Garlington is not going to testify against himself. And nobody can call him to a stand to make him testify against himself. All right, so that was a lie right there. But let's keep going. Judge Glanville, who has since been kicked off this case, ruled that these statements were admissible as statements of a co-conspirator. That's strange because that's not a statement of a co-conspirator because he didn't actually say it. Woody said he said it. All right, but anyway, let's keep going. This ruling does not comport with the U.S. Constitution or the Georgia Rules of Evidence. The plain text of the rule requires not only that the proponent of the evidence establish the existence of the conspiracy and show that the statement was made during the pendency of the conspiracy, but that the proponent must also establish that the statement was made in furtherance of the conspiracy. Assuming that Garlington actually said these things to Copeland, which we don't even know if that's true, these statements were not made in furtherance of the conspiracy. Yeah, this is insane. I mean, because you can't say that they conspired to kill Nut when, if it's true, Woody had just found out about them killing Nut after the fact. Almost as if he didn't know nothing about it. If it's true, and Woody already said that wasn't true, he made it up. So that's why the judge should have just kept it all out. To find otherwise simply overlooks, disregards the plain language of the rule and the line of controlling cases that establish that statements that spill the beans by definition do not further a conspiracy. Just because somebody spilled the beans, they tell the information, that don't mean you're furthering a conspiracy. I mean, that's pretty self-explanatory. So number 3, a footnote, Mrs. Stilwell, through undersigned attorney, filed a motion in limine. And motion in limine is basically a motion to keep out certain evidence, motion to exclude. You don't want the evidence to come into court, so you file a motion in limine to block it from coming in. So that's what that means. I know we're going to kind of, earlier it was kind of entertaining, now we're getting more technical legal stuff. We're kind of going to school, but we're working our way through it. So they filed a motion in limine to keep it out September 30th, 2022. Judge Glanville eventually considered brief argument and ruled on the admissibility of the statements. Defense counsel was unable to locate a written order regarding the admissibility of Garlington's alleged statements. So Judge Glanville didn't even make an order. Garlington has never publicly acknowledged making these statements to Woody, and that Woody now denies that Garlington ever made these comments to him. Right. So Garlington has never said it out loud that he told Woody that. And Woody is now not lying about, Woody is now admitting that he lied about Garlington in making those statements. That alone should have told the judge, like, hey, I'm gonna err on the side of caution, and I'm gonna keep it out because it's too messy. If somebody say Glanville, he like mess. And say that's all he keep up in his courtroom. Somebody say y'all do too. Y'all on YouTube talking about it. Number 7, the state plans to elicit testimony from Woody regarding Garlington's alleged statements. While Woody is now denying that Garlington made any such statement, Woody has openly acknowledged that he previously told the police that Garlington made those statements. The state has attempted to improperly introduce the contents of Garlington's statements through recordings of Copeland's, aka Woody's, prior statements, including his June 10, 2015 interview. The state's method is improper for 2 reasons. What are those 2 reasons, Matt Shard? He said, I'm going to tell you. First, Woody has not denied making these prior statements, and therefore no foundation for prior inconsistent statements has been laid. So basically what they're saying is, first the state has to ask him about it, and he has to deny it. And so far they haven't asked him about it, and he hasn't denied it. He said, second, which is the focus of the motion, Garlington's statements to Copeland, even if uttered, were not made in furtherance of the conspiracy and therefore failed to meet the requirements of the OCGA Rule 24.801D2E. Wherefore, undersigned counsel respectfully requests this court consider Mr. Stillwell's arguments and reconsiders whether the state has met their burden in establishing that Garlington's alleged statements satisfy the requirements of OCGA 24.801D2E. Oh, well, yeah. So that was a lot. That was a lot. So basically, they wanted to keep out hearsay statements. Somebody said that's one busy McDonald's. See, but my thing is, because I know a lot of people are putting a lot of pressure on Woody, but imagine if Woody never testified and they played all of Woody police interviews. Then in the jury's mind, they're going to believe what they hear in the police interviews. But now that Woody did testify and told the jury, like, hey, don't believe those police interviews, I lied in those police interviews, that's actually helping Young Thug and the other co-defendants. So I think by him testifying actually backfired on the state. Let me pull up those other motions. Here we go, y'all. This is the one y'all wanted. This is the one y'all wanted. The state's motion to restrict extrajudicial statements. No. She want to silence the lawyers. Somebody say she mad. The DA is salty that other people outside of the mainstream media are covering things so they can't control the narrative. Right, Regina. And when you tell too many stories, they don't know which one to believe. So they throw them all out. That's a reasonable doubt. I don't know if you're telling the truth now, you lying now, you were lying then, Woody. I can't believe none of it. So all of it goes out. But yeah, they mad. Let's see what they say. Let's keep on going. Reading. Comes now the state of Georgia and moves its honorable court. Can y'all see that? Something like a little bit. All right, let me leave good enough alone for it, and went all the way down. Moves its honorable court to instruct the defense to refrain from making further, see, added further, so they've been doing it, extrajudicial statements about this case moving forward. Georgia Rule of Professional Conduct Rule 3.6 prohibits lawyers from participating in litigation, from making extrajudicial statements a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably know or should know that it will have a substantial likelihood of prejudicing, oh my God, an adjudicative proceeding. Whew, somebody got to come read for me. It's been a long day. A relevant factor in determining prejudice is the nature of the proceeding involved. Who want to come up? Because this is insane. I need a reader. Who want to come read for me? I've been reading all these words and starting to run together. I don't know where I'm at. Okay, here we go. I'm gonna push through it. Somebody want to read? Let me know. With criminal jury trials being the most sensitive. Let me drink some water. Oh my God. With criminal jury trials being the most sensitive to extrajudicial speech, the character, credibility, and reputation of a party, in any opinion as to the guilt or innocence of a defendant, are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated. Oh, come on here, Regina. Regina says she's going to help us out for today. Thank you, Regina. Sometimes when you've been going 3 hours, all the words start running together. All right, let's keep going. Extrajudicial statements explicitly about this case while a jury is sworn. Defendant Williams' counsel, attorney Brian Steele and Keith Adams. I don't know. Did they make interviews? I don't know if they made interviews. Defendant Kendrick's counsel, attorney Doug Weinstein, defendant Stilwell's counsel have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. That's interesting. I don't know about that. Let's go to Rule 3.6 real quick, y'all. This is insane. That's okay. I'm gonna share this rule right quick, y'all. If not, I keep on. If not, I keep on pushing through. I can. Hey, I'll keep on going. But let's look at Georgia rule right quick. 3.6 prohibits lawyers from making extrajudicial statements that could materially prejudice an adjudicated proceeding. This rule applies to lawyers who have been involved in the investigation or litigation of a case, as well as their associates. However, there are some exceptions, such as when the lawyer is stating the claim. They state the claims, the offense or defense involved, or the identity of the people involved. See, Love, she left that out. There are some exceptions, such as when the lawyer is stating the claim, the offense or defense involved, or the identity of the people involved. The rule also recognizes that informed commentary can be valuable to the public, and that lawyers who are not involved in a proceeding are unlikely to prejudice it. Therefore, the rule does not appear to prohibit comments that could influence settlement negotiations, as long as they are not also likely to influence a trial or other adjudicated proceeding. So yeah, there's a rule there. Oh, come on. Who's there? Joe say keep pushing. If somebody did somebody come up, I was reading, I didn't see it looked like somebody wanted to come up and then they backed out, they got scared. It ain't gotta be perfect, just we buried on page 2. All right, let's go. I agree, Tasha. They haven't drink some water. All right. If somebody come on, let me know. I'm gonna keep on going. If not, we're gonna be here all night. Okay. So basically, what she said all of the lawyers, Brian Steele, Keith. I don't remember seeing interviews from Brian Steele and Keith Adams. Kendrick's counsel, Weinstein, Stillwell, Max Shaw, all have made statements to the media. You know what I'm doing? I'm gonna skim read. The statements have included, among other things, interviews and statements to the Associated Press. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things, the attorney's view and opinions about the case itself, opposing counsel, the now former. Don't try to protect your boyfriend. She don't want us talking about her man. The now former judge, the jury, the outcome, and the guilt innocence of specific defendants. Come on now. Right. But she said he did. Why is she lying on that man? Let's see. Pursuant to the rule, y'all see all that long stuff. Courts have the power to control in the furtherance of justice. Y'all, I gotta take a sip. Excuse me. Okay. Courts have the power to control the conduct of its officers and all other persons connected to a judicial proceeding before it in every manner appertaining to it, or appertaining thereto. I don't know why they just want to use regular English. Appertaining thereto. We don't really say thereto like that anymore. The state thus moves its honorable court to instruct the defense to refrain from making statements about this case, extrajudicial statements. And this was signed today by Adrian Love. I knew it was her. It had to be Love. Love, the only one that's going to come in and try to stop somebody from doing something. Right, bro. Bro, I'm not an English major. By no stretch of the imagination. Oh, but then guess what? India say she gonna handle it. Put some headphones so I can hear her. Hello.
Can you hear me?
Yeah, I can hear you. You sound like a hello. Thank you for joining. I definitely appreciate it. So if you don't mind, well, it looks like we on page 10. I mean, page 2 of 10, but it looks like they may just be exhibits. Let me see.
Yeah, they are.
And let me know if you need me to make this bigger for you to see it on your screen.
And I can see it.
And then I think it's some feedback.
For me?
Yes, it sounds like it's a little feedback. Did anybody else hear the feedback?
Hold on.
Okay. Erica said, who said something bad about the judge? Me. Yeah, I don't even think it's bad. It's not bad. I'm just saying that he didn't follow the law. Somebody said, love be lying and pour in on paper. But while she getting set up, I get us to the next page. So below we got the recusal order. And it's basically the recusal order that Brian still filed saying Jeffrey Williams innocent. He want to clear his name, ask for a speedy trial, and he want a constitutional right to a fair trial with an impartial judge, presiding over the case, ethical prosecutors. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. All that. We look forward to proceeding with the trial judge who will fairly and faithfully follow the law. So Keith Adams did an interview. Wait, how long ago was this though? Hold on. Oh, that took me to what's her name? Miss Sylvia's channel. They didn't put Miss Sylvia's channel in the motion. Let me show y'all where when I click the link, this is where it took me to. And y'all see the title, exclusive Young Thug Attorney Keith speaks out on Glanville's recusal. I'm just showing y'all where it took me to. Because I don't remember him giving an interview. I guess he gave one to her. Oh, wow. Somebody said, y'all auntie and some more paperwork. He said, no promo for the ops. Oh, somebody said that's why they didn't want to hug her. Oh, somebody tried to hug her. She tried to hug him and they told her no. They didn't put her in emotion. I mean, it ain't no bad. I mean, they could have. I didn't know this. So now I see why Still doesn't do interviews. No, India's here. Yeah, thank you, Keith Mobile. Somebody said she tried to hug Hilton, and Hilton is like, hell no, get away from me. Yeah, I can read and write, Malcolm. I've been here for 3 hours. I couldn't pass a 3-day and night bar exam if I couldn't. Okay, let me keep going. I guess she probably say there ain't nothing to read. Whenever you're ready, India, you can. Yeah, they never said anything of substance. Somebody said yes, Hilton shaded her. What? I didn't know this. Well, shout out to her channel. She done made a motion. She done made a motion. Well, they better not have my name in no paperwork. Hold up. Somebody said that might be a good thing. You holding them accountable. You interviewing them. I mean, there's a freedom of the press. No, she said, "No, you be deleting the video." Oh, my bad. My bad. I just see your comment. Oh, she been sitting backstage, y'all. I don't even know how. I thought she was up. She said she sent me a message. She said you gotta let me up. That's funny.
So you want me to read the article?
Somebody said they may have you and Kayla interviewing there. That'll be wild. Well, Kayla and the lawyer are on the case. Hey, let me ask this one more time to the can y'all hear feedback coming from India's mic?
I think that's the earphones, because I closed out YouTube and everything.
Okay, let's see. I don't know. It just sounds like it's Oh, well, let's try. Nobody's saying nothing that is feedback, so maybe it's not. Okay. Okay, let's see. Let's see how it goes. All right, whenever you're ready.
Okay. Exhibit C. The Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Willis's office declined to comment. While I respect Chief Judge Glanville and his service to this community and the country, he simply became biased over the course of this case, Kendrick's lawyer Doug Weinstein said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only just outcome at this point is a mistrial and bond for Kendrick, who has been jailed for more than 2 years.
Okay, thank you. And let me see what this turn. Okay, so let me see what this link is. Oh, okay, yeah, we know he went to Megan's channel. So we already know that part. Okay. Okay, Megan interviews Max. Okay, we know that one. The debrief. I don't know who this is. Let me open this link.
Oh, I'm not a lawyer.
Oh, okay, yeah. I'm not a lawyer, but yeah.
No.
Oh, yeah, that's good. Thank you. And okay. So we got that. Okay. Let's see. I think it was something else. Let me stop sharing this right
I have
quick.
a question for you too.
Oh, yeah, go ahead.
So you do criminal defense, right?
Yes.
Do you do interviews with the press during the course of your cases, or you just are like anti-interview, anti-making statements? Because I watch another lawyer on here and she says she never like gives statements to the press or anything during trials.
Right. It can be hard, but at the same time, I never had a case where you take over a month off, a month and a half off.
Yeah.
I guess you don't have nothing else to do but give interviews. But while the trial is going on, I don't really see the time you can give an interview because trial lasts from morning till 5, 6. By the time you go home and you prepare for the next day, the evidence you got, the next witnesses for the next day, you don't have time to be talking to the press. So normally I wouldn't consider it a good idea, but this is not a normal case. I put it like that. Let me see what this say. I think we did the hearsay statements. Let me see what other motion we got. Okay, here's another good one. I won't say good one, but one that ain't gonna waste your time. Something that you can actually read. You know, I said these little one paragraphs. This is a few pages, so this is good here. Let me see if I can share it right quick. And this appears to be another motion from. Let me see who filed this. I don't even know who filed this. Oh, this is from the state. This is from DA Love, so we should get a little attitude in this motion. Okay, whenever
Make
you're
it a
ready.
little bit bigger.
Okay, let me see. It may not all.
Not that big.
Oh, hold on. Right now.
Okay, that's good. State's motion to exclude victim character evidence. The state believes the defendants in the above styled case may attempt to improperly place the character of the deceased victim, Mr. Donovan Thomas Jr., in issue at the trial of this case. For the reasons stated below, the state moves this court to prohibit any attempt by defendants to elicit and introduce improper character evidence as prohibited by OCGA 244404 and 405. Defendants Diamante Kendrick and Shannon Stillwell are charged in count 2 with the January 10th, 2015 murder of Donovan Thomas Jr. overt acts 16 through 20 of count 1, conspiracy to violate the RICO Act. Also pertain to the murder of Donovan Thomas Jr., the defendants have pled not guilty to both count 1 and 2 and have never raised or asserted any claim of self-defense.
Oh, if you don't mind.
Oh, you want me to read the footnotes?
Yeah, if you don't mind.
Okay,
You get some good tea in the footnotes.
Additionally, 3 separate co-defendants, Javaris Bradford, Justin Cobb, and Damaz McMullen, are also charged in count 2 for murder. Defendant Williams is charged with overt act 16. Defendants Kendrick and Stillwell are charged, along with other severed defendants, with overt acts 17 through 20. Argument and citation of authority. AOCGA 244404, 244405. Georgia Evidentiary Evidence Statutes, OCGA 244404 and 244405, govern admissibility of a victim's character. These statutes generally limit evidence of a victim's character to reputation or opinion and not specific bad acts. OCGA 2404A provides in pertinent part as follows: evidence of a person's character or trait of a character shall not be admissible for the purpose of proving action in the conformity therewith on a particular occasion. There are 3 enumerated exceptions in 24404. Pertinent trait of character offered by a party to rebut the same. 2, evidence of a victim's character trait for peacefulness to rebut evidence that victim was initial aggressor. 3, evidence of the character of a witness. Where the evidence of a character or trait of a person is admissible, proof shall be made by testimony as to reputation or by testimony in the form of an opinion. Generally, a murder's victim's character is irrelevant and inadmissible Walker v. State, 294 Georgia, 851, 852. A victim's character may only be admitted if there exists some factual nexus to the conclusion for which it is being offered. It is impermissible to establish such a nexus through sheer speculation. Even if cases where an accused is arguing self-defense, the accused may only seek to introduce evidence of the victim's violent character through the admission of reputation and opinion testimony. Ward v. State. B. No factual nexus to the admission of victim's character. The character of Donovan Thomas Jr. is irrelevant and inadmissible in this trial because there exists no factual nexus for introducing any evidence pertaining to his character. Furthermore, any evidence of the victim's violent character is unequivocally irrelevant because no defendant has claimed self-defense. Finally, even if the court were to find a relevant purpose for victim character evidence, it would only permit admission through reputation and opinion testimony, not specific acts. See Ward 901. Conclusion, the state requests this court to prohibit the defense from intentionally or inadvertently eliciting improper character evidence. Respectfully submitted. This 23rd day of July, 2024.
Okay. Thank you so much for doing that. And not only did you read it well, it also is like a breath of fresh air when you can have a different reader. Because 3 hours of the same person to get boring. So when you came in, I was like, oh, this is good. You talking some good stuff. You talking that law.
Yes.
Yeah. So thank you so much. May I ask if you from like the South?
No, I live in Pennsylvania.
Oh, okay. I thought it was an accent somewhere. Okay.
Everybody say that, but I don't know. I can't hear it. When I
You
listen
can't
to
hear
it back, I can hear it, but while I'm speaking, I can't hear it.
Oh wow. Okay. Well, before I let you go, let me make sure that I hate to let you go and then I pull up something else. Oh, do you have a few more minutes or are you done?
Yeah, I was just in chat, so I'm.
Oh, okay, good. Okay, good. Thank you. Let me see. So we did the statements. Wait, so this is it? No way. Now we just knew somebody said they just knew Brian Steele was gonna have some motions coming out today. Oh wow, I think that's it. That's it. Boy, quit trying to get people location. What part of PA? Yeah, man. Why she just bring this up because she knows Glenville would have sided with her without a motion. Okay. Well, thank you so much, India, for reading for me. I definitely appreciate it.
And one more thing.
Oh yeah, go ahead.
I don't understand the last motion because they already brought in that he was a gang leader. So is that not character or is that just like a fact?
Well, I mean, I agree. I think it was a pointless motion to tell you the truth because she's saying that they can only bring it in if they say it was self-defense. They only shot down at the time of self-defense. Nobody's claiming to have anything to do with that situation at all. Nobody's putting themselves on the scene of that. So of course they're not going to say it was self-defense now at this late in the game. So they have no reason to bring up his character because if they say, hey, we didn't kill him, so why do we need to bring up how bad of a person he is? I mean, it don't make sense. That's between him and whoever actually did the killing. Somebody said, "Don't let her go yet." Oh, we got some more action.
Oh, Harvey, my favorite.
Shout out to Harvey,
The OG.
the OG. Let me see if I can find that one. Yeah, Harvey, he laid back. I like Harvey.
Yeah, he's really, really. Well, they're all smart, but like he's really, really experienced.
And it's good. You got to have a good experienced lawyer when you, especially when you playing around with people that like to break the rules.
Mhm. That's why I was disappointed that he wasn't there the day of the impeachment because I know he would have had a lot to say.
I'm waiting for somebody to send. Uh, Shout out to Tia. Tia, I know as soon as she get it, she'll send it. But for the sake of time, we can start off with Thug and Daily. You know, Thug and Daily, they be on it as well. They be. So I'm gonna see if I can at least we can at least start it on his. But I don't think he has the whole thing, his or hers. We always assume it's a.
They.
Yeah,
I think it's
they.
more than
There
one
you
person. I
go.
think it's more than one person.
Oh, they like the shade room. We got a couple of people running it.
I think so.
That makes sense because they're almost like a team the way it be coming up so fast. But whatever y'all doing, keep doing it. Keep doing what you're doing.
Yeah, because honestly, back when I first start following this, because I didn't really start following it till the start of the actual trial, and then I just looked back at like the other pleas and stuff. But I really started watching the like opening statements. Him and like Law and Crime, like they were the only people covering it. Like there was nobody else covering this trial.
Wow. And right, I think the fire didn't get hot until
Still got impeached. Then
still got
everybody came out of nowhere.
wait until when?
Still got impeached, like the whole impeachment, and then um what's the girl? Ashley Merchant and all them came in.
Oh yeah, when he was held in contempt.
There was light coverage on YouTube, but it wasn't
Right,
a lot until after that happened.
right, you're right. And because it was so many days and days that people just weren't interested in, all these days of testimony. And every once in a while, I even pop in and watch it, and I'm like, okay, you can tell the judge not fair, but it wasn't consistent enough to where you can just actually um, stir up a whole topic about it. But until we found out about that secret meeting, it was on then. I think all the YouTubers jumped back on it or started it.
Yep.
Okay, here we go. Shout out to Tia. She says she fast as lightning. Ooh. Oh, you pouring your drink, ain't you?
Drinking my water.
Oh, okay, you got to. Oh, I heard that ice rattle in that cup. I thought, oh yeah, I know. I know the feeling. Okay, is this it? No, this the one I just. Oh, now. All right, here we go. Here we go. Is that a
Okay.
good?
Yep,
Oh,
perfect.
okay.
Motion for mistrial and objection to mid-trial substitution of the trial judge. Comes now the defendant Quamarvius Nichols by and through undersigned counsel and files this motion for mistrial in the above caption case. In support of this motion, Mr. Nichols shows the court as follows. Mr. Nichols adopts all motions and arguments for mistrial as filed by co-defendants. If such motions are denied, Nichols further moves for mistrial and objects to mid-trial substitution for the following reasons. Number one, Mr. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because here, for a judge to be substituted after 19 months of trial, including 6 months of testimony, and the admission of evidence prejudices the defendant's right to a fair trial under the 6th and 14th Amendments to the United States Constitution, as well as
Give me the line.
concomitant
Right. Like, why? Why?
concomitant provisions of the Constitution of the state of Georgia. Further, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because the current presiding judge was not the judge during the last 19 months of trial when, for example, Mr. Nichols moves for directed verdict. This court will be unable to adequately evaluate the entirety of the prior proceedings in order to rule on the request. Of the 19 months of trial, over 6 months has been testimony for which this court was not present and therefore cannot base its decision on what has occurred during trial. Number three, additionally, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because on Friday, July 18th, 2024, this court advised the parties that she was unfamiliar with the previous trial proceedings that have occurred over the last year and a half. During the trial, before this court became the presiding judge, Judge Glanville made several contingent decisions, noting that he would revisit his rulings as trial proceeded. These contingent rulings covered several aspects of the tentative admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months' worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court could not possibly make decisions based on what has occurred, which the court was not privy to, nor has reviewed the record. Mr. Nichols further moves for mistrial and objects to mid-trial substitution of the judge because Nichols specifically on several occasions during the trial moved the court to give Curative Rule 105 instructions. The court denied each request to give such instruction at the time, but indicated it may be necessary to give at a later time or at the end of trial. Mr. Nichols also moved the court for severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would need to be revisited. This court would now need the benefit of the 6 month worth of previous testimony to adequately and fairly make decisions regarding whether an instruction or a severance is warranted. Given the court is unfamiliar with the trial proceedings and has indicated that it did not intend on familiarizing itself with the trial proceedings, Mr. Nichols' constitutional rights are violated because this court cannot make informed rulings based on the record. Trials evolve and decisions are made by the court based in part on the way the trial and evidence play out over time. This court has missed crucial proceedings necessary to make fair and well-founded rulings and to properly instruct the jury both during and at the conclusion of trial. Nichols moves for a mistrial and objects to mid-trial substitution of the trial judge because this court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigation that have already occurred, for this court to step up for the court to step into a 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions such as the credibility of the witnesses that have already testified, the lack of trial court being personally familiar with the record but presiding over the continuation of this trial, making decisions regarding trial and instructing the jury, violates Nichols' right to due process and a fair trial as guaranteed by our Constitution. Number six, Mr. Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because even if this court attempted to read the transcripts of the past 6 months worth of trial, that would not be an adequate substitute for the court observing live testimony. Even if this court attempted to watch 6 months of 6 months worth of trial proceedings via media recordings from afar, that would not be an adequate substitute for the court's personal and direct observations. If there was an argument to the contrary, Nichols notes that the media was not allowed to film several witnesses and at times were not recording due to technical difficulties. Number seven, Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because the trial has been suspended for over a month and jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings which the judge is unfamiliar with. Number 8. Further, Nichols reiterates and realleges his request for a severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred and no jury could be expected to compartmentalize the evidence as it relates to the separate defendants and charges. Wherefore, the defendant moves this court for a hearing on this motion for mistrial and objection to the substitution of the trial judge, this 23rd day of July 2024.
Oh, wow.
Well,
Hey, thank you again for reading that for us. Yeah, so this is insane. So now it seems like the lawyers, although they have been playing like on the same team, now they starting to have different game plans. Because now it seems like this lawyer is objecting to this judge coming on at all in the middle of a trial, and I think it's a fair objection. I mean, she come in the middle of the trial, and not only do she not know what's going on, I think she even said that that you had read the court has indicated that it did not intend on familiarizing itself with the trial proceedings. So she's saying she's not going to go back and revisit and re-rule on.
yeah, she did say that she wasn't going to re-rule on previous motions.
Right. She said I'm not going to do it. And that wouldn't be fair to the defendants because a lot has happened during the trial. A lot of people are saying thank you for reading. I don't know if you can see the comments or not, but yeah.
Thanks, guys. Tough crowd, so I'm glad I,
right.
did okay.
Oh yeah, it's a real tough crowd. I said don't pay attention to some of these some people, somebody always has something to say. I don't care what you do.
Yeah.
But somebody has said send me your cash so I can send you something. So I don't know if you were open to that or not, but somebody did put that in the comments. Thank you, Allah Mapper. Somebody said drink some water, Bookie. We got another motion. She gonna be like, you know what? Don't you ask me to come on here no more. What's the other motion though, y'all?
I think I seen they said still file for bond.
Oh, still talking. Okay, let me see. Now we're getting all the he said they coming in. Yeah, I'm waiting to get a hard copy, and then we can jump right in it. Yeah, Chicky said thanks. You seem very nice, Kayla. Yeah, so for the people that's popping in, we're just waiting on another motion. Several motions that came in today. Some of them said a whole lot of some, and some of them said a whole lot of nothing. And some of them are repetitive, so we're waiting on them to come in. And for those that are stopping in, if y'all don't mind hitting the like button. And if you like what you hear, subscribe. Come back for some more. And if you don't, still come back for some more so you can talk about me like Law Malcolm. We take all of that. She said, see, Tasha said that was the best one yet today.
I told you he always come through with the heat.
Hey, yeah. I wonder what
he stated some stuff that I didn't really like think about.
Well, let me just kind of skim through while we got a little time while we waiting.
Basically, she can't come in without really. She wasn't keeping up, and basically, she wasn't there for certain. I don't know if you like remember like at times when the trial was going on and the judge would be like, oh, one good example when Sharp was cross-examining Gaither and accused Sharp of being condescending. And he basically said, well, the court, it goes by the court's observation, and I didn't basically he thought Sharp was being condescending, even though we could see that he wasn't. But basically, she's not privy to that type of thing. So how could she really fairly judge coming in the middle of the trial like this? How can she fairly judge everything?
Yeah, I agree. There's no way that she would be able to just pick up and carry on like nothing happened, as well as the jurors. So I don't think that this motion is just so far left. I think it's an appropriate motion. But the only thing is they don't want to get in a situation where the judge declare mistrial and give the state another opportunity to refile the case and start all over again. While you have a jury now, I think this is the best time to go for a not guilty, because so much has been done in the trial, so much has been said. The prosecutors are having backroom meetings. The judge kicked off the case. This is a good time for
messy.
Yeah, it's too messy. This is the best time for it to get a not guilty from the jury, just because of that alone. So I don't think.
Has this ever happened before for a jury to be out for such a prolonged period of time? Like, I feel like a month is an extensive amount of time to be just like for the case to be paused and them to just come back like, oh well,
Right.
it was nothing happened. We're back now. Like, how does that work?
All right. At this point, too much has been done. Too much has been said for them to try to come back now. Jiggy, what did you say? Can you look up what YSL pointed to a client is charged with in the Rico? What is his client name? Let me go see. All these names and stuff starting to run together.
Some of the people are only charged with the one count of which is the Rico.
Let me see if I can pull up the.
I think it's in the indictment.
Okay. It might be a lot of. Okay, so we got Quanteri. Not Quanteri. What you say his name was?
Quamarvius.
Quamarvius, thank you. Quamarvius. And then the name underneath it was Dolly. Boy, we having some names. Trontavius. Okay, so he's charged with count 1, 49, 50, 51, 53, 54. So I guess what's count 1? Conspiracy. Okay, so we got the Rico. And then we'll go to 49, 50, 51, 53, 50. Okay, so 49 through 54 minus 52.
Oh, he got a.
Also, he got murder. Yeah, murder, participation in criminal street gang activity, participation in criminal street gang activity. Skip 52. Possession of a firearm by a convicted felon and possession of a firearm during commission of a felony. Yeah. So he got all these except 52. Let me go back and double check. Yeah, 49, 50, 51. Yeah. So there we have it. So yeah, I don't know what really separates him from anybody else.
Little Rodelius is only charged with one.
Who?
Rodelius, Ryan, Lil Rod.
Oh,
He's
okay. He's
only
only
charged
got
with the
one.
Rico.
Okay.
Tick was only charged with the Rico.
We got about 8 pages on this next one if you up for the task. And this is for the people joining in. This is one of the motions that were filed today, not too long ago. Matter of fact, the clerk posted it at 5:22, and it's a renewed motion for bond by Brian Steele. And we have Miss India up here helping us read, and she's been doing really good. So if you don't mind, whenever you're ready, we can go through this one.
Renewed motion for bond and brief in support of pre-verdict bond. Comes now defendant Jeffrey Williams by and through undersigned counsel and hereby files this renewed motion for bond and brief in support of pre-verdict bond in the above referenced case. In support of this renewed motion for bond and brief, Mr. Williams shows the below. In the great state of Georgia, unlike other states, for purposes of pretrial bond analysis, could you make it a little bit bigger?
Okay, no problem. Let me see. I was thinking that too. Right
Okay,
there, one more.
yeah, perfect. Okay. In the great state of Georgia, unlike other states, for purposes of pretrial bond analysis, the presumption of innocence remains with the person accused of an offense, even a capital offense, from arrest and even during trial. See Vanderford v. Brand. 126 G, all those numbers. That means prior to and during trial, courts view the criminally accused to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecution proves guilt beyond a reasonable doubt. 2 ABA Standards for Criminal Justice 10-1, 1980. Thus, the granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. See Stack v. Boyle, 342 U.S. 1. All those numbers. In order to protect our firm foundational belief that the accused is presumed to be innocent prior to a finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing this honorable court that there are no set conditions or circumstances that can be ordered to permit Mr. Williams' pretrial release on bond. 2 ABA Standards of Criminal Justice 10-5. The state bears the burden of proving by clear and convincing proof that the pretrial detention is warranted. Ayala v. State, 262, Georgia 704. This requires the prosecution to carry the burden of proving by preponderance of the evidence that this honorable court must deny Mr. Williams' motion for bail outright rather than set bond with the conditions of the same in order to ensure Mr. Williams' presence in court and to protect the community. See Ayala v. State, 262, Georgia 704. It is so significant to deny Mr. Williams' pre-verdict bond that the Honorable Supreme Court of Georgia requires that this honorable court to specifically explain why no bond could be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. See Lane v. State. When considering pre-verdict bond, alleged guilt is extraneous, is completely irrelevant, and not considered for the pre-verdict bond analysis, as supposed guilt has no place in the bail proceeding since Mr. Williams is presumed innocent. Cowards v. State, 266, Yorker v. State. Our highest court explained that in a bond hearing, Mr. Williams bears the initial burden of producing evidence that he would 1. Not propose a significant risk to flee the jurisdiction and would return to court when required. 2. Not be a significant threat or danger to the community or to any person or property in the community. 3. Not be a significant risk to commit a felony while on bond. And 4. Not be a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. See Ayala v. State. 1. Mr. Williams is not a flight risk. To meet this burden, Mr. Williams must first present evidence showing his roots in the community, which would include the length and character of residence in the community, employment status, and past history of responding to legal process. See Dunn v. Edwards. Mr. Williams was born and raised in the Jonesboro South section of Atlanta, Georgia. Since birth, August 1991, Mr. Williams has maintained residence in Atlanta, Georgia. Although Mr. Williams has traveled the globe, has performed his music and artistry in every continent save Antarctica, he always returns home. He always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Mr. Williams returned to Atlanta, Georgia from the country of Norway. Mr. Williams is one of 11 children, and he is the father of 6 children, ages 16, 13, 12, 11, 9, and 9. All of Mr. Williams' family lives in the Atlanta, Georgia area, including his parents. There is not many among us who has stronger roots in our community than Mr. Williams. Mr. Williams has been working since he was 6 years of age. At 14, he was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Mr. Williams was signed by Atlantic Records and was paid $1 million. Mr. Williams is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Mr. Williams has demonstrated a strong history of lawful employment.
Okay, let me go up a second and make sure. Okay. Not okay.
Mr. Williams has appeared in courts in the past, represented by undersigned counsel Brian Steele for approximately a decade, to wit, Mr. Williams' entire adult life. Mr. Williams has never missed nor been late for a court appearance. Mr. Williams has a long history of responding to the legal process. Undersigned counsel is in possession of Mr. Williams' passport and has permission to surrender this passport as directed by this honorable court for purposes of bond. Furthermore, when a bonding company writes a bond for the criminally accused, that company takes the financial risk in ensuring the criminally accused presence in court. In the case at the bar, Free At Last Bonding Company has agreed to write a bond set by this honorable court, and the representatives of Free At Last Bonding Company are motivated to keep track of Mr. Williams and prevent any possible flight. See Easy Out Bonding v. State. The bonding company is additional evidence that the accused will return to court when required to do so. Mr. Williams intends to present witnesses to testify at the renewed bond hearing. Specifically, Mr. Williams' parents, managers, members of his record label, childhood friends, business associates, and the like will be present in court to testify and or show support for the granting of a pre-verdict bond for Mr. Williams. Number 2, Mr. Williams is not a significant threat to the community or any person or property in the community. Mr. Williams has taken the initiative to secure commitment of full-time, off-duty, sworn law enforcement officers to watch his home and secure him in his home 24 hours, 7 days a week. If house arrest is ordered by this honorable court as a condition of pre-verdict bond, Mr. Williams will also submit to wearing an ankle monitor if ordered by this honorable court as a condition of pre-verdict bond. Mr. Williams will submit to a condition that any person who would visit him at his abode would have to be on an approved list provided to this honorable court as well as the district attorney's office. And if the individual's name is not on the list, that the person will be denied entry into his home. Moreover, any visitor will have consent to being searched physically and electronically by the off-duty sworn police officer, and if the visitor does not agree to consent to this search, the person will be prohibited from visiting with Mr. Williams. Mr. Williams also agrees that any of his text messages, telephone calls, emails, or other forms of communication in any matter can be secured and the information provided to this honorable court if desired, as if Mr. Williams was in custody and on a recorded line. The cost of 24 hours, 7 days a week, 7 days per week off-duty sworn police officer detail, as well as the cost of the ankle monitor and any other related costs, will be incurred by Mr. Williams. With these parameters in mind, it cannot be said that Mr. Williams would be a threat or a danger to the community or any person or property in the community. Underside counsel will agree to meet with Mr. Williams at his home to continue to prepare for trial. The above conditions place Mr. Williams in custody in his home. See Brown v. State, 314 Georgia. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. The legislature found that the electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Mr. Williams' home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. See Brown v. State. Ordering Mr. Williams to wear an ankle monitor and to be in total lockdown in his home is the equivalent to custody and confinement and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Mr. Williams. See Brown v. State. Since May 9th, 2022, Mr. Williams endures the torturous conditions in the county jail, to wit, 22 out of 24 hours a day, locked in a small cement cell with no contact with another human being except when his counsel visits and in court proceedings, inedible food, living in squalor and infested room, and unable to see any activity or movement outside of the cell's windows. Number 3, Mr. Williams is not a significant risk to commit a felony while out on bond. Mr. Williams is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9, 2022, after the arrest of Mr. Williams, and the original grand jury indictment and incident to the search, drugs and guns were allegedly located in this home. At the time of this search, there were numerous people at or in Mr. Williams' home. This is because others live at this home more often than Mr. Williams, who is at this home intermittently, as Mr. Williams has several homes in the Atlanta area. Thus, Mr. Williams is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered above. Since Mr. Williams is not a significant risk to commit a crime, he is also not a significant threat to the community, property, or person insane. See Williams v. State. Number 4, Mr. Williams is not a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. Mr. Williams has suggested as a condition of bond that all of his calls, text messages, and other means of communication are to be monitored, save privileged communications, and additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate a witness or otherwise obstruct the administration of justice via electronic means. In today's time, the legislature has provided that ankle monitors are a humane method of incarcerating a criminally accused without the need for punishment that is endured by languishing in the county jail. This honorable court's foremost consideration with fixing the amount of bail should be the probability that Mr. Williams, if granted bond, will appear at trial. See Hernandez v. State. Mr. Williams is a respected, high-profile artist who has positively impacted the lives of others who would otherwise never break the poverty line. Mr. Williams has made a tremendous positive impact in our community. Mr. Williams is a positive member of society. He will continue to lawfully and ethically fight these baseless charges, governed by the above facts and law. Mr. Williams satisfies all four prongs of the Ayala v. State super test. Mr. Williams satisfies these four bond factors, and thus the burden of production falls onto the prosecution, and the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Mr. Williams to be entitled to pre-verdict release whatsoever. See Dunn v. Edwards. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. See United States v. Salerno. Indeed, the most important element of liberty is to be free from physical detention by one's own government. See Hamdi v. Rumsfeld in Carr v. State. Based upon the above, Mr. Williams must be granted a reasonable bond with conditions of same. Wherefore, Mr. Williams respectfully requests a reasonable bond to be set by this honorable court with reasonable conditions of same, this 23rd day of July 2024. Respectfully submitted.
Oh, thank you again. That one was kind of lengthy, but
It was.
you pushed through. Yeah, you got it. You did. You took care of it for sure. So what do you think about that? While I have you here, about the bond motion.
I think that him, out of everybody that I know of, he doesn't have a felony. And he also is high profile. So I never thought he was a threat or anything like that. And he has no history of it. Like, I thought the things the prosecution was saying in their previous bond hearings, like, we're 100 days into trial, and I don't feel like they have proven any of that. So I feel like while they might have got away with that earlier, I feel like now they don't have a leg to stand on, and they have to grant, if not to everybody, him not being a convicted felon or having any like criminal history should be released on bond. And I don't think he should even have to do all the that extensive surveillance. Like, an ankle monitor would suffice, but all that monitor communication, I don't think they should do all of that.
Well, I'm glad you said that, because Car Global had mentioned that if you're innocent, why are you willing to do so much? But you know what? I don't know how far Car Global has been following this case, but Young Thug's been in prison or jail, just like prison, for over 2 years.
Jail's worse than prison.
That's what a lot of people say, because there's so much going on in there, especially in the Fulton County jail. There's no secret that jail is terrible. And he's been in there. We just read it, in a cement box for 22 hours out of a 24-hour day. So he's only out for 2 hours, and he has no other human contact. So what he's telling the judge is, Judge, I'm willing to do all of that just to get out. So, of course, he's willing to go above and beyond. He may be innocent, but he still want to be at home, sleeping in his own bed, and having human contact. A TV, getting to probably visit his children he haven't seen in over 2 years. His 6 kids. So that's a good incentive of why he, is willing to do all of that. That you commented about. Let me see. I think the motion was well written.
I enjoy Steele. He's I like his language.
Yeah, what he said at the beginning, he said it has been written. Where is that at? Let's see if I can find that. I wonder if I can do a search. Yeah, it has been written like it's scripture. Go ahead, Brian. But for the most part, I like this. He listed the children ages. The children ages is 9 and 9. Are they twins?
Project twins, maybe.
I don't. What does that mean? I may be thinking of a
Different moms.
Oh, okay. 9 and 9.
Different moms, but the same age.
Okay. Unless she, is it possible to have kids at the same? I guess if you have them back to back, maybe.
Guys can if there's two girls pregnant at the same time and they have their kids at the same time. That's Project Twins.
So if
they have different moms.
Okay. No, what I was trying to figure out if two kids from the same mom and dad can have the same age at the same time.
Oh, Irish twins, like if they're born in the same year, like 9 months apart, or like even 11 months apart.
Mm-hmm. Yeah. Okay. No, just because the judges, they read into stuff like this. Anything that they can, and also he said he was representing Brian Steele Brian Steele was representing Young Thug for 10 years.
And I agree with his statement about how he never, through Brian Steele's representation of him for 10 years plus, he's never been late for a court date. He's never missed a court date. So I feel like that should mean something.
Do you think that's would that bring like a negative connotation to the judge? Like, obviously he's never been convicted of a felony, but what the hell has he needed
court
for 10 years? That's a whole lot of traffic, ain't it?
Well, when you're a celebrity, or even if you're somebody, a business owner, they have lawyers on retainer. It doesn't mean they were actively like he has this extensive criminal history. He could have him retained for various reasons.
Right. So do you think that should have been elaborated just for clarity for the judge? Or by him saying that he has no felony convictions, that's enough to let the judge know that it wasn't because he was in trouble for 10 years?
I think it would suffice, but I'm biased, so maybe I'm
not the person to ask. Yeah. And obviously he had to talk about the drugs being found in the home, because the state will argue that. They're going to say, hey, you can't let him go, judge, because when we arrested him for this particular charge, there was a lot of, drugs everywhere, but he already cleared that up and said, yeah, it was drugs everywhere or found in the home, but other people live there.
And it wasn't his main residence. Like, he really didn't, he didn't stay there all the time.
Right. I hope that video that his kids put out doesn't hurt him for bond. I don't know what that means, the video his kids put out.
I don't think it can. They couldn't bring something like that in at this point, could they?
Well, for purposes of bond, the rules are pretty relaxed when it comes to bringing in certain factors. Like, I wonder what the video showed.
It was like his kids doing like a rap, like a diss rap.
Oh yeah. And when was it?
Last week, I think.
Oh, okay, yeah. He can't control that. He's been in jail over 2 years.
It hasn't seen the kids.
It hasn't seen it.
He only get visits from the lawyers.
Right. So maybe if he was out, they wouldn't be making these videos. So he can actually, be a parent to his children instead of locked up in a cell while he hasn't been found guilty of any crime so far.
22 hours is crazy.
Yeah, that's crazy work. And then they said the food is inedible. Somebody said, well, he picking up some weight though. He must be eating some good
snacks.
Good snacks. Go, shout out to the commissary. Shout out to the commissary.
But all that stuff's bad for you.
Yeah. And I get it. Instead of eating some nasty food, I live off of snacks too. But at the end of the day, he'd rather be in his own home in his own bed. He ain't got to worry about the safety, the yelling, and all, everything that comes with the jail.
And I honestly feel like the charges that he's facing, like just being like the Rico and not him having any direct, what's the word I'm looking for?
Well, like direct connection to any of the crime?
Yeah, he's not directly involved in any of these crimes so far. So I think like that alone, I don't understand why he didn't get bail from the beginning.
Right, he might have the least. I think he was count 1 in 56. Um, where
And
his
I guess
name
this
go?
will be a question for you. Like, so being that this bail hearing now takes into account the 100 days of testimony and everything. So some of those arguments they made before trial started, like how they were intimidating witnesses, or they were doing this, they were doing that, they were so dangerous. Doesn't the 100 days of testimony, like, won't they factor that in to basically like a lot of the stuff they said they haven't proven?
Right, I think that'll be a very big deal to factor in because at first the state was making arguments saying that all of these people are being threatened. They threaten witnesses. If you let them out, the witnesses won't be safe. But now all of these witnesses have showed up to court,
And
and
said they weren't
now,
scared.
right, they're not
Definitely.
scared. So now you have a problem, state, because you can't use that lie anymore. And what they are pretty much saying is, hey, judge, they lied about that. They lied about the state is lying about all the other factors. They can't say for certain they're a flight risk. And I mean, let's be real. Where Young Thug gonna go? They don't find him easily. He has no reason to run and hide and get himself in hell without bond indefinitely. Car Global say y'all justify everything. What Car Global? I'm gonna drop the link. What are we justifying? We just saying what we read. Car Global say he buys too. Anybody got a camera and mic want to come up? Let me know.
I
Uh,
just I just feel like people should be mindful. Like, I mean, a lot of people, like, it's supposed to be innocent until proven guilty, and a lot of people have already convicted these guys or already think that they're guilty, and they should be mindful that today it's them, tomorrow it can be you. Like, this stuff happens all the time. Like, just because you think you're this upstanding, law-abiding citizen, you never know what could happen that could turn into you being falsely accused of a crime.
right.
And would you
Yeah,
feel the same way? You would want the benefit of the doubt.
I agree, and that's your your constitutional right to that. And I wonder how many witnesses testified. We read a motion earlier today, and it was like 75 witnesses, and then this was saying over 100.
I
But
don't
when
think
it,
it's been 100.
so not quite 100 yet.
I don't think so.
Okay. That's what I was thinking. I was like, okay, they're not consistent on the amount of witnesses, and if the judge reading it like we're reading it, she might even wonder like how many witnesses have been called. But in any event, no matter how many witnesses, they've been in court forever, and nothing has been. Uh, let me share. Let me see if I can go to this one.
So during this time, like, is the judge like? Because I think they said the transcripts had to be prepared, but do you think she has been watching like the streaming, like the streaming coverage of the trial,
I don't
or
think
like she's
so.
just waiting until like Tuesday and just waiting for them to argue their motions?
Yeah, I don't think she went back and watched. I mean, she could have, because some of the stuff she said will make you wonder, like, is she, you know, it, do she have some knowledge that we
I
don't
think the
know
only
about?
well, I don't know what they talk about behind the scenes and just being in a courthouse, but I think she probably knows about the big events, but she doesn't know the day to day. Like, she probably knows about the contempt and all that kind of stuff, but not like, the everyday ins and outs of testimony and stuff. I don't think she is fully abreast on that. How could she be? Like, she was, running her own courtroom.
Right. That makes sense. Um, and I think today they limiting how many more trials she can get while she's covering this big trial.
Yeah, I think they said it was like a motion to take her off the wheel so she
Oh,
can't get
okay.
any more cases assigned. But is that do you think a sign that this is just going to keep pushing forward?
Um, well, it just depends. I need to see that one because is that an order that she entered into the clerk, or did they come from like the administrative
I think
judge?
it came from like The administration.
Oh, okay. Well, yeah. I mean, if it came from her, then that could be an indication that maybe. But since it came from, I mean, while she has this trial, and it might not be that much of a process. Take her off the wheel right now, and if she throw the case out, then I'm sure just push of a button to put her back in the wheel.
Yeah.
Yeah, and taking her out the wheel basically means the random wheel of when judges are selected for cases. And since she has a big case right now, they're going to take her off so she don't be randomly selected and pick up more cases while she already has a big case in front of her. So it's not like taking her out of the wheel, like her parents are cutting her out. She's not getting that left to her. That's a different type of wheel. Just in case somebody was wondering what they mean by taking them out the wheel.
And you probably answered this before, but just because there's a mistrial in this case doesn't mean anything's going to change with the other defendants, right?
Yeah, I agree. Now it might help out the other co-defendants that haven't went to trial yet, but I don't see what it can do right now as to what can help the ones that already took plea deals.
No, not the guys that took pleas. I'm talking about the ones like that are still awaiting trial.
Oh, okay, I
Because
got you.
isn't like because it's severed, it's a whole separate trial. So
Right.
basically, a mistrial or or acquittal in this case wouldn't carry over to them. Like they would still have to go through like with their whole trial and everything, right?
It would seem so because I don't see how any way they were set at a disadvantage right now because the whole issue in this trial is a secret meeting was happening and the jury is poisoned. Well, this same jury and judge has not presided over their trial because it hasn't even started yet. So I don't know how they can make a legal argument as to why their case, should be thrown out as well. But the issue they may run into is if these six are found to be not guilty, then jeopardy attaches. They can no longer be tried again. And it'll be a sad sight for the prosecutors if one of the defendants in this case come in and testify on behalf of the other co-defendants. You know what I mean?
Oh yeah.
What if they come in there and say, you know what, since I've been found not guilty, now I can talk.
Yeah.
Those guys had nothing to do with it. It was me. And the state can do nothing to come in and try to recharge them again. So it could be sticky.
Yeah.
I mean, I wouldn't be shocked if they move to dismiss the charges against those other guys if this one falls through. And Keys, do you have a camera and a mic? I can pull you up. Whenever you're ready, I can pull you up. Oh, let me move it. Hold on, let me read.
Let me turn my Bluetooth off.
Oh, okay. Let me take this
Okay, so
down.
I got a question about like how are they going to move forward with all these motions?
So it appears that the judge told them to file by the deadline today, and then they have to respond to each other by Friday. By Friday the 26th. So that gives them 3 days. And once they respond on Friday, then the judge will take the following week, the week of the 29th, to go through the motions with just the lawyers. And depending on how fast they move through the motions, then the jury can be back on that following Monday, August the 5th. And based on the motion we've seen today, there should be no reason that they can't finish this up next week.
So you think, I mean, realistically, that a jury can come back? I mean, like even what is stated in the motion, do you really think they could come back and just go back to work?
I don't think they can legally speaking, I don't think it'll be fair, a fair trial at that point. But from a strategy perspective, why not? I mean, my whole thing is let's see what we can do now. Let's see if we can get a not guilty. But if we can't get a not guilty or hung jury, they retried, or they're found guilty, then you can go back and complain to the appeals court. Say, hey, judge, the appeals court, judge, justices, she made us go through with this trial even though we didn't want to because the jury was off for over a month. The judge is new. She don't even know half of the pretrial rulings. Not only do she not know the previous rulings, she says she don't want to know. She says she's not going to go back and review all the Glanville ruling. So I think that's enough for any appeals court to say, okay, yeah, you're right. Y'all got to get a new trial. But why get a new trial right now and start all over when you might have a chance of winning? So I see the strategy to keep pushing right now with this jury that you have, because this is your best shot at getting not guilty right now.
So what do you think about Miss Love's the state's filing? Because for one, her involving the bloggers, and then I don't know if you've seen the video with, well, Mr. Adams never was on video with her, but he was more or less kind of saying it's not a good look to be talking to the witnesses or whatever. But so what do you think about that, and how are they going to use that?
Wait a minute. Who said what now?
So Mr. Adams, the attorney Adams for Jeffrey Williams, was on Sylvia, the link that was in the thing you read, the motion you read. So it's an interview that Miss Sylvia did with him. And the first thing I heard on there was that he wouldn't be doing interviews with witnesses while they're still on the stand.
So Keith Adams said that to.
I think there was like a question in the chat because I guess she was taking questions from people in the chat,
Okay.
and I guess somebody asked what he thought about that, and he said he doesn't think it's a good idea for people to be basically for like people to be talking to witnesses, like sworn in witnesses, basically.
Right, exactly. Thank you.
Oh, okay. Yeah.
But I have a question in regards to the media too, like, because I know we are. Well, I don't know what type of rules they have regarding the press, but I know like we have a right to, what is it called? Like the right to.
Well, like a public trial.
Yeah, like a right or like reporters. What's the rule that reporters have? Like they have
like
like
freedom
the
of the press.
Huh?
Freedom of the press.
Yes, freedom of the press. So technically, like they really couldn't ban them for doing like interviews and stuff like that. But are they allowed to like introduce rules that they have to follow?
I really think that this motion is kind of irrelevant right now. I'm thinking the only reason that the attorneys are just making their rounds and speaking out is because they have the time to do it. But now, as this judge has told us, when she plans on taking over, it's going to be 8:45 to 6 o'clock every day. So they're not going to have time to be, doing interviews. They're going to be preparing for trial. And if I remember correctly, before this long break, I don't remember any attorney coming out, and doing an interview. It only happened recently because of this break.
I agree. I do agree with that.
Yeah.
And then, yes, you answer my next question, India. But also Brian Steele's tweet is in that motion too from the state.
What was his tweet?
I think he made a statement to Thugger Daily. It was just like it was the exhibit. It was like the first exhibit in the first motion we had. Well, I guess it wasn't the first motion, but it was the first exhibit in the state's motion about the press.
Okay, let me see.
And it
Okay.
looked like somebody just asked him a question and he responded. It was just like a short statement basically.
That wasn't nobody but that love.
I told you
GA love.
love is watching. Hi, Miss Love.
Oh yeah,
But
she watching.
she's been watching because I remember one day when they were arguing in court and she was saying how, yeah, because they say it was her arguing with Glanville, and she was like, yeah, because they say that you don't ever say anything to me. But I can remember when I forget what had happened, and he like chewed her up, and she was like, yeah, and they were saying, and I'm like, they like, why are you watching the blogs?
Oh yeah, you're right. You're right. It was Exhibit A. I think I had skimmed through it. Yeah, you're right. Okay, I was trying to
But
figure out like.
she's bothered by the court of public opinion, which really shouldn't matter. Just
And
put on your
you're
coat.
exactly right. She is watching.
She watching.
And she's been watching. This was before like the impeachment and the ex parte. This was like pretty early in the trial. This was like probably a month or so ago. But she had mentioned basically something that basically you could tell that she's been watching social media in regards to what people are saying.
Yeah, I mean, I don't see what love. It seemed like she should have used her energy focusing on the actual case itself. But for her to, maybe this is a way to hit back at Brian Steele. But cause we gotta remember they got a pending motion right now to kick her and Love and Hilton off the case. So maybe this is her way of getting back at Steele. But if she get kicked off the case, then her motion should be irrelevant at that point.
And she can't really get back at him because that little statement is the only thing he's ever
Right,
said. He has
right,
declined interviews so far.
right, right, right.
Like, so
Yeah, I don't see nothing significant. I mean, it's not like they were falling all over themselves to talk about this case. It kind of like became a thing. Once the break happened, one attorney started talking first. Actually, it might have originally. Um, I remember when it first happened. Me and Kayla popped into the chat over here, and we had a brief interaction. It wasn't even like an interview.
you kicked
Um,
off the tour.
yeah, hey, that's what happened. Kayla came over here, and then people were trying to like copy and paste the video. So what I did was I just posted it, and they still copied it and pasted it everywhere. But that was kind of like, it set off everything in motion. And now Kayla has her own channel with thousands subscribers. I don't know why they keep messing with her videos, taking her videos down. But she was able to really set the groundwork because the other attorneys were kind of scared. They didn't pop out. So till she did, and then next thing you know, we got an interview. I think Weinstein came first, and then
Start.
yeah, Char, yeah, came. So yeah, it was just coming down back to back the interviews, but I don't think it was nothing that was intentional.
I just can't
So
wait until Tuesday
what's Tuesday?
to see them argue the motions. I want to see how the judge is going to handle things. I want to see who will be doing the arguing, especially when it comes to um the rivals, Steele and Miss Love. Like, I want to see how that's going to go and how the judge is going to handle it.
Cutie Pie say just coming in. Anything new today? Anything new?
I
How many
agree
motions was
with
it? It was like
India.
6.
Yeah, it's been it's 4.5 hours of nothing but new stuff.
And I was going to say, Miss Love almost couldn't contain herself in the court that day. That they just had they weren't really, they were just going over stuff, but she almost couldn't contain herself.
Yeah, she couldn't. You could tell it was taking a lot for her, especially when she had got up because she
So,
was going to say something, but then the judge had like moved on, so she sat right back down. And in Glanville's court, I mean, y'all seen how she pushed what's his name off the podium like that? I couldn't believe that. when she pushed Melnick off the podium.
Oh yeah,
Yes, and
yeah.
she almost did it that day. I forget who was at the podium, but she almost did it kind of in a way that day.
It was still,
And
I think.
did you hear when the day before the ex parte meeting, her
Hey,
say that she asked the judge for could she talk to him about an ex parte,
Yeah, she did say that on
right? When
Friday
the
at the end
court
of the
was
day.
ending.
hey, simply,
Yes.
simply, do you have a your camera so we can pull you up? Um,
She had requested one, I think that Friday, but I don't think they had it till Monday.
Right, but she had asked the judge about it that evening. So I'm wondering, did they make arrangements to meet that morning? You get what I'm saying?
Oh yeah, I think they did, but I don't think. Well, I don't know. I don't know their intentions, but I don't know what the prosecutor's intentions were, but I don't think the judge necessarily intended on things going how they went. But he didn't stop it. Like he didn't. The train was going off the tracks, and he didn't steer the train back in the right direction. He just let it go off the rails.
Right. And
And now here we
DeAndre
are.
said, yeah, she was itching in her seat. Yes, she was.
Because they were supposed to have a hearing that Monday morning in open court. That's why I was confused. I'm like, I'm sitting there watching, and it's like, okay, nothing's happening. Like, we still looking at the seal because they were supposed to have that conversation in open court the same way they did on Friday when he explained it to them. They were supposed to do that again on Monday. So I just didn't understand why this happened.
Right. And I feel like she's not the only one watching. I think the judge was watching too, because it was something he said on the bench about how many people are watching this case.
Yeah.
yeah, simply, I don't see your name.
First off, I don't know how you don't know who I am. This is Tot. I
Okay, yeah, I just
hold
like
on. I
no,
just
no.
changed my name to Slick to mess with Slick in the comments, but
Oh, okay,
I
okay, I
can't
got you,
believe
got
you.
you, I got you. No,
I
I
just
just
came up here because you have yet to read the new motion that came out.
what?
It's a new motion that dropped. Still
When?
dropping a new motion.
When?
Um, what is it?
I thought we went over all of them.
No, it was one that was dropped at 522. Is the motion to correct discrepancies concerning Mr. Williams' trial exhibits.
Ooh.
I dropped it in the chat and you did not acknowledge me.
No, it don't let you drop links in the chat, so it might show that you dropped it, but it won't show nobody else. Yeah.
Yeah, YouTube block links.
What does that mean to correct?
He's basically saying he's trying to correct lies.
How long is it?
Okay, thank you.
1, 2, 3, 4. Four, it's 4 pages, but it's 100 exhibits, it looks like.
Mm, 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 mm.
I don't know. Hold on, wait. It's like 1, 2, 3, 4, 5,
Tuesday
6,
is going to
7,
be
8,
so
9,
interesting,
10,
y'all.
19, 20, 21, 22, 30. I
So
think it's like
Friday,
35. It's like 35 links that he
Ooh.
has.
so Friday is not, I wonder, did he also get stuff off the internet?
Yeah, they've all been putting links to like law and crime and stuff for certain timestamps instead of like, because I think typically before live streaming the cases, they would cite like transcripts and stuff. But since things are streamed, they could just give you the timestamp in the video.
Right, but I mean, I know that part, but I'm saying in the terms of the bloggers. You get what I'm saying? Because they've been, like you guys were speaking earlier, Law and Crime were the original people
I'm
in
sorry. I'm sorry.
Atlanta. Go
TalkThatLaw,
ahead.
I dropped it in your private link.
Okay, all right, thank you.
So I was basically saying, like the bloggers and all these, Woody 20 versus Woody, and just like I said, the interviews like Miss Love used, for example, Miss Love used the interview with Adams and then the
But I
Twitter
think that's
tweet.
because well, for one, it's an interview with the lawyer, and for two, it was done by, she's not just a streamer, like she's somebody who actually has like the Rule 22 and it's in the courtroom. So I think it's kind of different, but I don't even think they cited it because it was her. I think it was cited because it was an interview with the lawyer. So she was trying to prove that all the lawyers she named have been talking to the media, because she had the tweet from Steele, the video from Adams, and what the video, yeah, because Megan Kuniff was on there as well, right?
Right. And Weinstein, she had
Yeah,
something
that was on
about him.
It was on Megan Kuniff's channel. So I think it's more because they did the interviews with the attorneys.
Right. And then Weinstein was on I'm Not a Lawyer too.
Oh yeah, yep.
Okay, so I think I see it. It's not lengthy at all. Thank you for sending that. Let me see. So basically, the judge had asked for a list of exhibits. Hey, I'm gonna just mute because it's a lot of feedback, and then I'll mute now. It's the judge asked for a list of exhibits from the state to see what was admitted, what was not admitted, and she wanted a list. And what Brian Steele is saying, Young Thug's lawyer, she sent y'all a list, but the list is wrong. And he basically saying that he filed his motion to correct the discrepancies. And it's pretty straightforward. He says after the review of the YSL exhibit status Excel spreadsheet provided to the undersigned counsel about this report, Mr. Williams identified the following exhibits which were admitted and not recorded. So good thing they have YouTube links so they can actually hear the judge say, without the YouTube link, you got the transcript, but that can take forever for Ms. Weaver to go through. You just play the video and it'll show you that a certain exhibit was admitted. DW2 was admitted at that time stamp. And they're saying that Brian Steele is still analyzing the potential discrepancies in the state's exhibits. At the time of this filing of this motion, it's believed that there are approximately 100 state exhibit discrepancies, not 100. And that's at the time of this filing. They're still going through it. So all of these are discrepancies of where stuff was admitted, but it's not reported by the state. Law and Crime posted February 6th. Trial proceedings, okay. The exhibit. They're pretty much all the links showing what the state missed. Moreover, the following exhibits were not admitted at trial. However, the honorable court reporter has marked the same as being admitted. So some of the stuff wasn't admitted, but the court reporter marked them that they was admitted. And I get it. It's a long trial. You're going to make mistakes. Further, the following exhibits have been admitted in the case, and these were not listed on the spreadsheet. Brian still ain't going to let you get away with nothing. So wherefore, Mr. Williams respectfully requests that this motion be spread upon the minutes of the court, and if needed, Mr. Williams stands ready for hearing on same. So yeah. Thank you, Tasha, for sending that. If y'all want to talk, y'all can just unmute y'all. I just muted it for the feedback. But yeah.
It just get crazier and crazier.
Somebody say, what's Love's name on YouTube? Which one of these names in this comment? So is she Law Malcolm? Law Malcolm. Did you keep the L for love? While you're saying they guilty? Yeah. So yeah.
So are they saying, like, did they already get the spreadsheet, or did the state try to give them their own, like she tried to do in court, saying she would, give them the exhibits and stuff? So, or did they get the spreadsheet from the court reporter?
No,
I
I
think both.
believe.
I think both happened. It seems like from what he's saying, um, what the state sent them was wrong, and he like cross-referenced it to, I guess, maybe his own records, and it seems like they did get the one from the court reporter, and the court reporters didn't match the states either, so he like basically cross-referenced all three. It seems like from what you showed.
Okay,
Yes.
that's what I kind of got, but I wanted to make sure that's what I was understanding.
Yeah. So what he may have done first is check the record. When he saw certain things missing from the state's list, he probably checked and said, okay, these things were omitted. He checked the transcript; they there. And then some of the things weren't on the transcript, so he went back to YouTube. He probably said, "I know I'm not tripping. I know this was omitted," and then YouTube shows it there. So it seemed like he's just trying to get it straight. It may not be intentional, but since the state has played so dirty, I don't put nothing past them. They could be trying to leave stuff out on purpose. So
And I felt like that's why the judge was saying she could get the records versus relying on the state to do it, and then give them out to everybody.
right, and this and the state gave a list that's not correct. So
And I have a question too.
oh yeah, go ahead.
How do they keep track of exhibits in cases like when you're in court? Like, is there like a running spreadsheet? Like, how do you guys keep track of like everything like as you enter it?
Well, everything is really, you can keep track of yourselves, but most of the time, if not all the time, the court reporter is documenting all of the exhibits, and the court reporter is in possession of those exhibits. So we might introduce something into evidence, then we don't keep it when we go back to our seats or we show the jury. We give it to the court reporter, and
Okay.
then the court reporter has access to it. So in doing closing arguments, if I want to refer back to that exhibit that was admitted, I'll just get it from the court reporter beforehand, and then I give it back to her, because once it's admitted, it's in the custody of the court reporter for record purposes. Because if you have an appeal and the court reporter has to send the whole file to the appeals court, she's going to need to send those exhibits as well. And not only the exhibits that are admitted, but the exhibits that are denied. Court reporters take those as well, because if you do an appeal, then the appeals court will want to take a look at what was denied, what was kept out of evidence that you wanted in evidence, and then the appeals court can make a decision.
Oh, that's a lot of work.
Yeah, it's a lot. So that's what I'm saying. I don't think the court reporter did none of this intentionally, but that Love and that Hilton, watch them, Brian, watch them. I don't put nothing past them. Because let's say that some stuff got in that helps Young Thug and the other co-defendants, and the state don't want the jury to see it again. They can just, intentionally leave it out. So their case can be strengthened. Somebody says so. Somebody said so. I guess Weaver was doing the mannequin challenge. She wasn't typing nothing the whole time.
Yeah, it's like they do like shorthand, right? And then it's
Right,
recorded too.
right. And that's probably why she used her personal recorder. Because if she missed something, she could just play back her personal recorder. And that's why people are now requesting, and I'm people, we want to hear the tape of the secret meeting. We got the transcript, but we want to hear the actual voices. We want to hear the tone in the voice of Glanville when they were threatening Woody to testify. I bet she's gonna sound worse than than how it reads on paper.
Oh yeah.
So we know how Glanville can get with his ways, and I can hear Love raising her voice. You're gonna be in the jail until this
And
trial.
cutting people off.
Yeah, okay, yeah, we need all of that, all of it. We need your recorder, and I think it was a motion already that was put in for that. So hopefully we can get that. Jiggy, you missed everything.
So
But
what
yeah,
is Miss Love's whole purpose of her motion? Just to keep them quiet, or
She's just mad.
yeah,
That's how I feel. She's just mad because the court of public opinion is tearing her up, and they've been tearing her up, and she don't like it. And like I said, I feel like they like to control the narrative, and because we have these, like, we have streamers and stuff now, and like the court cases are being streamed, and like this one thing, like, court has always been open to the public. If you go down to the courthouse, you could sit in the courtroom, but I think the fact that it's being streamed online, like, the world is watching, so
right.
it's like,
But the thing is, the the lawyers that's actually in the case. Oh, it's some feedback. I'm gonna mute you while I talk. I think it's feedback from my. I don't know. I don't know if you're using headphones or not. It might just be my voice when I talk bouncing back into the device you're using. But in any event, hold on. Let me see something. Yeah, the lawyers like Weinstein and Shard, they haven't been just dragging her or dragging the DA's office. They mainly talking about their case and the strategy for their defense. I mean, what she really want to file a motion for is me and all the other YouTubers, because we the ones that's reading her rights and calling it how it is, calling a spade a spade. India say the chats are dragging her to field. That's what she really
yeah,
mad at.
she's getting drugged.
That's why she mad. Let's tell it like it is. So, but I don't think it's gonna make much of a difference, because right now they focusing on winning the case. So she might be helping them out once again. She doing a favor to them by telling them, hey, don't talk to the media. Concentrate on your case to make sure that when we're doing something unethical, you'll have enough time to catch us right away, because you're going to be so laser focused on us and not your media appointment that nothing's going to be able to slide. So I think Love is inadvertently helping the defense again without even realizing it. And not only that, they're not even just, like I said, just doing a whole lot of media appearances anyway. They did a few with people they know. I think Sylvia, she thought I was in the courtroom, and I think Weinstein has some connections with Megan, the reporter Megan, and I believe, did Kayla talk to somebody? Maybe Kayla talked to Melnick.
Yeah, she had Melnick
Kayla
on
talked to
her.
everybody.
Kayla talked
Right.
to everybody.
But
Right.
I was gonna say, like, I feel like Miss Love is not that smart, because I don't know, she just showed it a lot of times in court that the lawyers are kind of quite smarter than her, and she doesn't know the law as well, because when Weinstein was filed the motion, what is it, the mandamus?
Right.
He so when the judge was denying it the first time and he was reading back um the law, she was over there shaking her head when the judge started reading, his reasons why he wasn't going to do it or what have you. But she was steady shaking her head like, that they didn't know the law. And I just feel like she's not as smart as is why she uses the tactics she uses.
Uh, so wait, what you say, D? You and Kayla interview was in the draft paper. What paper? And which one? Because I think me and Kayla, I went to her channel and she was over here. And matter of fact, and we spoke again on Dear World Christian's channel.
And you know they took all her and Woody's videos down.
That's probably what they did. But I'm gonna put
Like
them on note. Don't
all
come
the
over
ones
here. Don't come over here messing with my videos.
because I think the last time you were on live is somebody was putting it in the chat and saying that, and it was true that they had took both of their stuff off their page.
Wow, yeah. And I had heard that they had took it down and I believe she tried to put it back up and then they took it down again. I might have to call Kayla and see what the hell going on over there in Georgia. I don't know if she's in
Yeah,
Georgia, back
because
in
they
Texas.
right, because they only have her like her little promo she had that was up there for like a year, and then some like the stuff. No, none of her really new stuff, and then whatever Woody had on his page. Even I think the video for the 20 versus Woody or
That wasn't on his
however
channel.
it wasn't. I thought it
No,
was
that
on his.
that was with another YouTuber, so it's on that YouTuber's channel.
Okay, I got you. I got you.
Yeah, but I
But
remember this. Oh, go ahead.
I was just gonna say, but the videos he did, whatever couple things he had on there, he had some little TikTok. I don't see them on there.
He said they on their way to Houston. Don't worry, get your paper delivered by hand. And so come on. uh
But I don't think Attorney Love is like not smart or like she don't know the law. I feel like this case. Well, for one, I think it's what 6-on-1. And I just think the stress of the case I don't know because I don't know how she is on a regular, but it just seemed like the stress of the case has made it more like emotional than it needs to be. Like the lawyer from Baldwin, the prosecutor who withdrew from the case, I can't think of her name, but like she said, the state is supposed to just present the evidence. They're not really advocates. They're supposed to present the case to the jury and let the jury decide. And I feel like this case, like Love has like gotten really emotional,
yeah,
and it's just
yeah,
not a good look.
yeah, that could be bad.
Yeah.
You
No,
know,
I
when
agree
you
with you, but I just think the reason I said that is because of her track record, not just her prosecuting this case. Like her as a judge, usually judge build more, accolades as they sit on a certain seat, and for her to go from judge to DA, that's kind of like backwards. You get what I'm saying? And in the business they are, you have to be smart enough to be able to control yourself. That's as a lawyer, because you don't want to show your hand every time. And to me, that's what she's been doing, is like she really messed this case up with, some, yes, her attitude too, but in her posture, but also um some of the decisions she made. And you're right, some of those have been emotional decisions, but I just feel like, you know, if you're using your brain, your critical thinking, she wouldn't make certain um mistakes that she's made in this case.
I've never known or heard anything about her being a judge before.
I think it was in juvenile court or like
Yeah,
yeah, I
she
think
was a
in juvenile court.
juvenile court judge. Yep, you're right, India.
Oh, okay. When was it? Let me see.
And while
I
you're looking
can't
that up,
remember. I'm sorry.
while you're looking that up, I agree with what you were saying because the one emotional mistake was when it was Miss Bennett was on the stand. I think it was her emotions that made her even mention that, basically, like, what did you say when we were texting? I feel like if she was really like took off the emotional hat and put on her lawyer hat, she would have known better than to even mention something like that that could be held against her.
Exactly. And I think that's why she ruined this case, is why so many, because Hilton, like I had said to in the chat before, Miss Hilton had me kind of fooled because she kept a good game face. I would never have thought she would have had that type of meeting or been able to even, but if Miss Love and Fonnie is her boss, she gonna have to follow what they say. But I feel like to a certain extent she wouldn't have went as hard. But it was like she was in it to win it too, and she got wrapped up in it. But I don't know. That could have been her just having a good game face.
And I'll have to ask you, since you're a lawyer, um, basically from what I've been hearing, prosecutors don't really have, like, there's really not going to be any repercussions for their actions. So it doesn't really matter. Like, even though we think they look bad and they're doing this wrong, etc., it's not like they would necessarily lose their job or have to face any real repercussions for their actions besides like hurt feelings. Is that right? Or I'm wrong?
Well, they might still file bar complaints against them. So I don't think they're out of the woodworks yet, because I don't think he's still going to let this go. He might be waiting till the trial is over with so he can stay focused. But I'm sure bar complaints are going to come flying left and right for them as well as Glanville. So yeah, I do think that something's going to come out of that. And who knows? Maybe we can cover that. They may, not to mention, we don't even know if the Senate in Georgia will subpoena any of them to testify once all of this is over. We already know they won't find it because of the Trump case. So we don't know what we don't know. So I think could be some serious issues at the end. And we got to remember the legislature in Georgia is mostly Republican. And they don't really like Fonnie's office right now anyway. So I think it'll be nothing for them to turn up the heat on them. Yeah,
And so I got a question. So do you know about I guess, I don't know, it's a policy or bill that was passed in Georgia that the governor can remove a prosecutor or something? I have to go and read it verbatim, but have you seen that?
I heard about it, and I believe they were trying to say it was targeted at her, at Fonnie. In a lot of different states, especially like Republican-led states, have been targeting liberal prosecutors as a way to punish them if they don't prosecute certain crimes. And the Florida governor did that quite a lot. He actually has the power to single-handedly remove prosecutors, and I think he has removed several prosecutors from office because they neglected their duty to follow the law. So yeah, that's not nothing new. I'm gonna see if I can find the one specifically for.
So that this judge was cited with that law, like a couple other judges didn't, but she was for it or something. The one that's sitting on the bench now.
Right. From my understanding, prosecutors sued to stop this law, saying that it's unconstitutional because it infringes upon their powers. Because normally prosecutors have what they call prosecutorial discretion. They can decide who to charge, who not to charge. And if a panel or governor can come in and take over your discretion or remove you because they think you should have charged somebody and you didn't, or you did charge somebody and you shouldn't have, then it's infringing upon their power. So I think that's why a lot of prosecutors in Georgia got together to sue. But this judge, the judge that's on the case right now, the YSL trial, Judge Whitaker, she sided with the oversight board, saying that it should be some type of oversight for prosecutors. And here, let's see if I can make it a little bigger. It say Georgia next law letting panel punish and off prosecutors. Signed a bill into law Friday, creating a new commission empowered to discipline and remove wayward prosecutors, saying it will curb far left prosecutors who are making our communities less safe. So, in the law, parallel pushes to remove prosecutors in Florida, Indiana, Missouri, Pennsylvania. Yeah, so yeah, a lot of that's been going on. They removed a prosecutor in, what was that lady name? In Florida. Let me see. Ron DeSantis. And I believe she was an African American.
Who they removed?
Yeah, who they removed from office because I think he had an issue with something that she did.
I think that's good for if this trial does continue. I think that's good for the defense, is like they will get a fair trial because knowing that the judge doesn't agree with, certain acts that the prosecutors, do or don't do.
Right. But even outside of that, even if the board doesn't go after the district attorney entire office, they can still go after the prosecutors individually and punish them that way. And
Right. That's a good thing.
Got recused. Jiggy says still a motion to recuse Hilton and Love, and that has to be heavily considered, especially if the judge already got recused for the same thing, and he's supposed to be held to a higher standard.
Yeah. But from my from my understanding, he didn't get recused. Well, basically by, what was the lady's name? Krause. She didn't recuse him for the meeting. She recused him because of what he did after, like when he basically tried to argue his case in response to Weinstein's motion. That's why she recused him. So
yeah, that's the lie she came up with because she's trying to say he did nothing wrong in the meeting. So
I thought that's what Steele was filed the motion for.
Right.
Is to correct what Judge Krause stated in the recusal motion.
Yeah, she's trying to say he didn't do nothing wrong, and he only did something wrong when he came out and talked about it after the fact, in order to still try to save grace for Glanville. And Brian filed a motion saying, no, she's dead wrong for saying that she's dead wrong for saying that Glanville did nothing wrong. When clearly anybody that's watching this trial, if you put yourself in the shoes of a defendant, it's easy when you're talking about somebody else. But imagine if you're sitting there and you find out that the DA has a witness back there with the judge, and they pressuring that witness to testify against you behind closed doors. I mean, anybody in their right mind would be upset that a fair judge, supposed to be fair, is behind there trying to make somebody testify against me. Like, what? And then Judge Cross come out and say, yeah, that was totally fine. It was appropriate. He did nothing wrong. Without the appearance of fairness, I'll let him go anyway.
Yeah, so I had a question on that, what you just spoke of. because my original thought when she put that in the motion was so that the other motions they filed would not be valid. So is that true that why he's asking that is to make those other motions they filed after that to be valid?
Well, I don't know because it's hard to speak to the motives of what her intentions were. I don't know if she was just trying to make it sound good for Glanville. You know, he donated $2,000 to her campaign. She know him. She probably like him, and she didn't want the final case that everyone to remember him by. You know, this big case is he was kicked off the case because he did something wrong. So I think she kind of let him off the hook lightly, and that may have been the reason that she wrote the things that she wrote. But then on the flip side, she could be setting precedent down the road. And Brian Steele was like, no, you cannot say he did nothing wrong because you may have other judges that may think it was okay that, you know, they may start having secret meetings in the back room with the lights off. So, and Brian Steele, he still got to practice in Florida, Georgia. That's his court, Fulton County. So just because this trial go away for us, he's going to still be there another, you know, who knows, 10 years, 20 years. And he want to make sure that this judge is not giving permission for other judges to do the same thing Glanville did. And the appeals court can speak to it by fixing her ruling, the appeals or contesting her words. Then the appeals court can actually, let's say this judge denied, she don't want to fix the words of Judge Whitaker, don't want to fix the words of Judge Cross. Then he can take that motion in front of the appeals court and let the appeals court rule whether Glanville was correct to have a meeting behind closed doors or not. And I think Glanville know he was wrong because Glanville, he's not appealing to get back on the case. As far as I know, have y'all heard anything like that?
I think he was relieved once he got off the case.
You think so? I didn't think he wanted to let it go.
If you see how he's on his like relaxed days and in his foot, because he just, I don't know, he was like grungy, like type of judge. I don't know, it just wasn't. And I think he really was relieved because he has a therapy dog. Like, you got to have some patience and, you know, to sit there for this type of trial. This isn't just a mini trial or him doing, you know, those civil cases and stuff.
They say now the dog stressed out. The dog need a dog. Thank you so much to my 4 girls for the kind contribution. She said the state ran a play with Clanville. He talked about his ruling over the bench on the ex parte, and she recused him on talking about it. It was a play. My 4 girl said she saw the play from a mile away. Thank you again for your kindness. Yeah, it could have been a play. I don't put nothing past them. You know, some people saying that they were giving signals to each other, baseball signals, touching the ears, touching all type of signs to each other. So who knows how heavily involved Glanville was in this trial behind closed doors? Was he helping the state when they needed a break? Did they give him a signal? Like, hey, this witness is not going to act right. We need more time. Did they give him a signal? Or when the prosecutors are what I call cooking and they're doing a good job with a witness, do they signal the judge saying, hey, you know, Brian's still tearing this witness up. We need a break so we can tell that witness what to say.
Exactly.
So I don't put nothing, and I mean nothing past the prosecutors. Because I get they want to win, but they shouldn't stoop to the level of breaking the law and risking themselves in some serious trouble or losing their bar license.
Exactly.
You want to win a case so bad that you lose your bar license and now you're done for good. Now, would they be disbarred? I think not. because
I swear I would have thought Brown was Miss Love's son.
Oh, I cannot stand him.
you think so?
I
I
can't.
don't know.
I
I
cannot
can't. He
stand
acts
him.
just like her. It's like I know he's not her son, but oh my God, I think she could you adopting.
It seems like Brown is not as tough as Love. It seems like Love tougher than him.
No, true, but he does the faces and he does all the emotions like
Right,
her.
like her. So he don't have a good poker face.
No,
They
he be back there turning his nose up. He just does the same thing she does.
he does.
Meanwhile, he should have been preparing for his questioning of his Hertz witnesses, but he back there rolling his neck and bobbing his head.
No, not
Yes,
rolling his
yes, and digging in his nails. I'm like, is this what he is doing in the court?
She said, for me, it's the head bobbing and weaving. The head bobbing and
Yes,
weaving is
yes,
yeah.
yes, yes. I'm with you. I
Lip,
can't take him.
lip smacking, eye rolling. I don't know if she was. Minister.
Somebody said Brown was too sassy for TV.
He really is, and you know the camera's always right on them, so it's hard not to see
Y'all
it.
funny. Y'all funny. Y'all know. Right, the camera literally sits right in their face. Literally sits in their face. So he really can't hide it. Shout out to Minister
And that's why they
Fears.
be mad too, because their little whispering and stuff, they whisper real loud.
Yes, and shout out to Lee. That was a good one.
Minister Fears said, I agree. I think Glenville was relieved when the final decision came back. He seemed overwhelmed and out of his depth, especially the way he exploded on Attorney Steele. Thank you, Minister Fears, for that comment and for joining the live.
Yes, I agree with Minister Fears.
I just think he didn't like Steele.
Yeah. Some people
Or
say,
Short. And I'm like, what Short do?
And yes, the person break it down with B. Yes, BBL Brown. They had some names for him in the chat.
what's going on, Coca? Thank you for stopping in. Wait, who? BBL? Y'all funny. Y'all know what? Y'all know what? Oh, that is funny. That is funny. But yeah, y'all ain't. I mean, y'all see what everybody else see. I mean, Brown sit back down that back table. Sometimes he'd come to the front. I just don't like his style of alluring. Maybe because he's taking after Love. But everybody
I didn't like when he was up there asking. I mean,
yeah.
you know.
I like questions that's going somewhere. I mean, don't ask 50 questions and it don't go nowhere. Like what's the end of the story? And I didn't like his style. And everybody got their own style. He may come to text and say, I don't like your style. But hey, that's cool. But you ain't gonna have me showing my emotions on the camera. You ain't gonna know what I'm thinking. And I tell my clients that too, do not react because the jury is watching you. So, don't get angry.
You look like you give a good poker face.
Oh yeah. And then when I get out with my team outside of the courtroom, we talk about like a dog. Did you hear what? Soon as we get out, did you hear what she said? Did you hear him get on the stand and lie his all? I'm trying to keep it clean. But yeah,
right.
It happens. It happens. And actually, I was supposed to go to trial on Monday, but it was pushed back. A guy had a trial ahead of us, and they thought he was going to take a plea deal, and he said he going to trial. So we got pushed back. Right. So I got to stay here, and she pushed it to the end of August. So that's really good because now I can have more time. I want to be here on the 30th.
Right. I was going to say so you can catch up.
Right. I can catch up. God say the same on the 30th. I plan on being here so we can see what the fuss is about. I want to see them argue back and forth.
Yeah, I'm with India. She hit the hammer on the nail. She said it.
Shout out to
She here for the arguments.
Yeah, I mean that's what's going to be really interesting. But I wonder if they're going to control themselves. Did y'all see? But Love and this judge, she don't have that much rapport with this judge. You can tell like her and this judge ain't like on no friendly type of time. Did y'all get that vibe, or y'all think that?
Yes, her or Hilton.
Yeah, they were on their best behavior. Like, okay, yeah, this judge ain't gonna play.
And she's not like Glanville was, like I think it was a gender bias. Like he was his tone was different with them than it was with the male attorneys in general. Not to mention his own biases for whatever reason. But,
yeah,
I agree.
But it's not like she's a woman too, so that's not gonna fly.
Right. Yeah, y'all can wear them skirts as short as you want to. I don't think it's gonna do it for her. She might say
no, because she actually had that. You see how she had the computer in front of her?
Right. So she ain't studying them.
Yeah, you could kind of tell, like it's gonna be a different setup, which I like. It seemed good, it's gonna be an even balance.
Right, yeah. I like a fair trial.
Yes. But Miss Love, you could tell her faces she was making that she's not with this judge.
Right. You can tell. And not only that, I mean, they are in another judge's courtroom based on something that they call. Like they put themselves there by making, and I say making because they literally made Glanville have a secret meeting. And they know they can get over on Glanville. He when it comes to a woman, they say he look like his wife, he gonna do whatever she tell him to do.
Right. And then also another point to my point I was saying earlier about her not really being that smart. I feel like that it might have been a response to their motion that she filed before they came back to court. I think that was like what, 1 or 2 pages against, these lengthy motions being filed by the defense.
Right, and I believe that was a motion that Judge Rachel considered, the motion as to why Glanville shouldn't be kicked off the case.
Right, but she couldn't give that many reasons of why he shouldn't be.
Right. Yeah, she couldn't give no. Well, let me show y'all this part. I know y'all seen this. When Love was still trying to talk, and the judge was like, he heard enough.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay, thank you.
Look at it, try to go back up there.
All right. With regard to
yeah, sit it down.
I had to push my mute because I laugh every time I.
Let me go do it one more time.
That'll be great. Okay.
Love was biting her tongue literally.
Oh yeah, look.
And she was uncomfortable.
All
right, sit down.
With regard to the most immediate,
I will say, Love do look like she wore out. It looks like she's tired. like her face is tired. Let's see.
And Miss Hilton kept looking down like she doing work.
okay. Wait. To all witnesses being shown
It
or being
just look like she's tired to me.
Okay. Well,
They stressed out.
Yeah. And normally, wait, who she just wave her hand at? Wait a minute. Hold up. Let me unmute it.
all witnesses being shown or being excluded. Okay. Well, All right.
And I'm in front.
Okay, well, that's why I guess
Ooh.
it's being taken up on a case witness by witness basis. So, Ms. Love, then you're providing that to the court and the opposing counsel. If there's objection,
Yeah, Love, she don't have a good, you see when she get upset, you
You
can see
see
it on
her,
her
she was
face.
annoyed. You see how annoyed she was and how she looked.
Wow.
She's so attitudey, like she can't even help herself.
Like she was really annoyed when Weinstein spoke,
Yeah.
and then when the judge said what she said, but she had to hold it in.
And I think she was done at that point. That's why Hilton went ahead and jumped in and took over. Let me see.
Her explain to the court. Ms. Hilton says she has been providing that list. I will let her explain to the court.
okay, because I guess I'm wondering, how is there a list if
And when has Miss Love ever let Miss Hilton explain anything to the court? She always was doing the talking.
there hasn't
Exactly.
been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially
Okay.
prepares the list.
All right,
Good morning, Your Honor, or
good afternoon at
Your
this
Honor.
point.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as the opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state
Yeah, we back here. Y'all see the look at us?
sounds like what y'all have been
Yeah,
getting
we
the list
watching you.
from the
Yeah, we still here. We still here. Oh, and what was his I don't think Brown was there. I don't know who this other young guy. I think I've seen him before. The one that
I think he's the right. I think that's the other guy for the prosecutors, for the tech guy, I think.
No, I think he's a lawyer.
Is he?
Yeah, I think so. I remember him arguing a bond motion, and he had actually got caught in a lie in one of the bond motions, and he just started. His hand was literally shaking at the podium.
What?
I'm gonna see if I can get that
Brown or the other girl? They weren't there.
Let me see.
In that last little thing they had. Did you see the guy in the middle? He kept shaking his head to the judge about everything. That's the most I seen him really, like look up.
Which one?
The guy in the middle of Love and Hilton.
The guy in the middle of Love. Let me see.
The
Oh
other
yeah.
prosecutor.
Oh yeah. He
Cause
I think he came in later on in the case. Matter of fact.
Yeah, I think he did.
Let me see.
They need to take notes from him on his temperament because he had a difficult witness and he didn't act how they was acting.
No, I don't mind when he gets up there and really, even though it'd be kind of boring, but he does know how to question a witness on the stand.
Yeah, he had, what's his name? The one who was in jail. He did the examination of him.
Oh, which
Right.
one?
The one who was in jail when he wanted to go back to jail. He kept telling them he didn't know nothing and he wanted to go back to jail.
Was that Tick?
No,
Or
it wasn't.
No, not.
It was one who was in the car with the one who got powed in the head.
Oh, I know who you're talking about.
So there's been so much happening.
Yeah, D'Angelo.
Oh, okay. Oh, politicking with Mel. See, politicking with Mel is on it.
So I had a question for both of y'all. So what do y'all think about the whole car incident with Woody? I mean, I don't really want to say on here, but more or less, do you think he's lying? I'll just say that about the whole story. And I feel like I'm asking, do you think he's lying to exclude himself?
I
Just
don't know.
based on what we know from him admitting certain things, allegedly.
Oh, I think you can answer.
Yeah, I don't necessarily think he was lying to like protect himself. I still don't know. But I will say one thing, like I have watched like some of his lives that he has done, like not with other people, but like when he would go live on like Instagram and stuff, and he just be talking. Like, how do I say it? I wouldn't really put much weight on what he was saying. Like, I really do believe that he was telling them anything. Like any good liar, it's always a little bit of truth in every lie. So, how do I explain it? I think when they told him something that they wanted to hear, they just took it and ran with it. Because to be honest, I don't really think in regards, especially in regards to the nut situation, nothing was ever really corroborated. So it was like you're just taking his word for it. He could literally be telling you something he heard through the grapevine, and because he told you in a way that sounds good, you believe him. And he's good at, like, I don't know, like he's good at that. Like he can talk, he can make something sound good. And like I've heard somebody say before, he's a liar until he says something that they want to hear.
Mm-hmm.
Right.
Yeah,
Right.
yeah, and I agree. When you got somebody that you really can't assess their credibility, if they're telling the truth or not, then that's the embodiment of reasonable doubt. And
Right.
and they have to prove these cases beyond a reasonable doubt. And if you have some reasonable doubt as to Woody's testimony to tie up this Rico case, and he's the star witness, then I think the whole case falls apart. And that's why I'm thinking not guilty. You might have a holdout or two that may say no guilty. It may be a hung jury, but I don't foresee a guilty verdict. But I mean, nowadays you never know.
Yeah, I don't think so. I just feel like the case was all over the place. If they had, like basically telling a story and not the Jungle Book, it would have went well. But because you can't follow along, it's like you go here and then the other chapter is different from the first 3 chapters you read. Like,
Yeah, that makes sense. I don't know. I mean, what she was thinking with that, with her opening statement in the Jungle Book reference. I think she just started off on the wrong foot, and then DA love. She can't hide her face when she upset. She don't get her way. The jury, they see all of that.
right.
And
And the Jungle Book just threw me on the floor. I just can't get past that. Like I said, if I was a juror, I don't really know if I could have really took her serious after that.
you said not threw you on the floor, right? Not the floor.
Yes, the Jungle Book, I was laughing for a couple days.
It was the burden shifting. None of those lawyers in our courtroom are rookies. Why are you burden shifting the first day of this trial? Like, you know better. Like, I just did not understand that.
Yes, you are so right.
Yeah. I've seen trials. There was another case. I don't remember the exact case. It was another TV type of case. And the prosecutor made the argument that the defendant did not tell his side of the story to the police. And obviously basic. That's a basic right to remain silent. So for you to say that in front of a jury, you should have known better. You can't mention to the jury that someone decided to exercise their rights well, he must be guilty. He's not, saying he didn't do it. Well, he don't have to say he didn't do it. He can just sit there in that chair the whole trial. If he was innocent, he'd get on the stand and tell you he's innocent. There's stuff like that. The courts have ruled consistently prosecutors can't do it, but they still try to do it. They're still trying to shift the burden to the defendant. Instead of the state proving that he did it, they'll just say, prove that you didn't do it. And that's not how our laws are set up. Supposed to be set up anyway in some states in the United States.
Yeah, I totally agree with both of you. And I feel like some of the things with Miss Love, she forgets that she gets out her head when she's asking for the defense to produce certain things and let them know what witnesses coming in when you're still trying your case.
Yeah, I agree. And now I'm trying to figure out what witnesses even the state will call now, maybe just a few. But if they don't think that the state proved their case, and they said as much in their motion that they're winning and the state is losing, then they may not even put up many witnesses.
I think it's going to be just more cops. And what did they say? I think what Monk Tunk is like the last, like, I guess, big witness or.
Now that we have a judge that's willing to work, this case might be wrapped up next month. If we start August the 5th and the judge is going to work, she said 8 to 6. She may have to cut it back if the jury have like children in school or something like that. I think she's going to work them. And she's already said she's going to exclude evidence that's a waste of time. The only thing is, it's going to be hard for her to say what's a waste of time when she hasn't been there for the past 6 months.
But the state is not arguing that, though. The defense is. And then another thing to that one, what you just said was, I think, was good. And the fact that she said that they got to have their witnesses ready to go. Like after one witness, they have to have the other one prepped and ready to go.
Yeah, that was strange right there. She wasn't playing at all. She said she don't want to be waiting 5 minutes. She's saying that as soon as one witness get off the stand, the next witness should be lining up.
And I think Glanville should have did the same thing, because that would have helped. Like, he was in control of speeding some things up.
Yeah, because we did not need those 2 days of testimony from the Hertz people. We do not need this gang detective to come back 5 times or however many times they're bringing him back. Like, it's just unnecessary.
Yeah, I agree. That's too much.
To just say the same thing over and over again. I just don't understand it.
And now the thing may be they may bring in some extra witnesses, and the defense may say, hey, this is repetitive testimony, but the prosecutor may say, no, they're saying something different than the previous witness said, and the judge won't be able to know who's telling the truth. So she might just err with side with the prosecutors until she start hearing repetitive testimony herself.
But didn't she tell them that she wanted a rough draft of the witnesses and what they're supposed to be saying?
Right. That would be good for witnesses going forward, but it really won't give her a roadmap to what's on that list repetitive from the past 6 months.
Right, right, right.
So it'll only help her stop going forward from here on out. But as far as going back, it might be 3 people on the list that the defense may argue, hey, it was people already testified to this stuff. And the judge might say, well, I wasn't there, so I'll allow it. But only one per
But don't you
subject.
think in that motion that some of that repetitiveness is in that motion that Brian still filed?
Yeah, I guess you can. The argument could be made for that.
Because I feel like he put so much in there. I'm just thinking, you know, some of that evidence is probably some, you know, some witness like India just said, like people that came back 2 and 3 times. I don't know because I haven't looked at it myself, but I'm just assuming.
Breaking it down, what B said, Glanville was trying to help the state win with cough, hand signals, chewing candy, blowing his nose. He wasn't slick. He said Glanville was doing the most.
He really was.
He was doing the most. You can't make this up.
I was uncomfortable when Brian Steele was trying to file. I think this was after the ex parte, but he was drinking out his cup and then he put cough drops, something in his mouth, and it was like all on the mic. It was just uncomfortable. It was just uncomfortable to watch because the etiquette was like, ooh.
So you said he ain't got no home training.
Yeah, like there's mics in here. We can hear all that.
Right.
Yes, yes, like you drinking everything.
Yeah, that's true. And it was a lot of that going on in the courtroom, and that's probably why the judge was like, "Nah, we're not gonna have none of that eating in this courtroom." She not already heard.
And I have another question. So you know how like say okay, go through all the motions and the trial continues, hypothetically. So they're gonna play those tapes. If they're playing the tapes, why do they need the cops to come in and talk about the tapes too? Or they wouldn't need that.
Well, it'll be the tapes themselves will be hearsay because you can't cross-examine the tape. So I actually need a witness to walk me through what's going on the tape. So if something's not clear, or what did you mean by this when you said this on the tape, then I actually have that person there to testify to it.
Okay.
But playing the tape alone will be hearsay. I mean, people can bring in, prosecutors can bring in just nothing but tape and just play them all day long, and I have no way of cross-examining my witnesses. And you have a right to confront your witnesses, and you can't confront a tape. Somebody sending a tape, hey, this person assaulted me, and just mail the tape to the court. And we need you to come in and testify how they assaulted you, and the jury can determine your credibility, tell if you're lying, if you're changing your story. Yeah. Oh, King Stepper mad. You must be king of love. King Stepper,
I can't take it.
King Stepper, you want to come up? I'll drop the link for you. Yeah, every once in a while you'll get a troll.
And so the other reason, somebody put it in the chat too, like if Kimberly, that's why they need, remember, if you don't remember something, they can bring the tapes in, like she was saying with Woody. But that's what I was going to say too, the same thing. If I guess what they call it, impeachment, when they're either not saying the same thing they said on tape or they don't remember.
Yeah, because that's what I was talking about was the Woody tapes because they're so long and it just seems like to play all those hours of tape plus testify, but I don't know, it just seems like a lot.
Plus,
Like
they
too
wanted
much.
to, they were being slick though, I feel like with Woody. You know what I'm saying? Because some stuff was accumulative and he said a lot though. She did get some answers out of him. And then she would go and ask it in another way.
Hang on a second.
What's up,
Hey,
y'all? How y'all doing?
thank you for joining. Why you mad?
How you doing?
No, I ain't mad. No, it's just like
We can't hear you.
shit.
Okay, right there we can hear you.
How do I like Bluetooth it to like another speaker so you
Well,
can hear me?
when you first started, it was good, but then it had went out.
Okay.
Yeah, right there.
Okay, y'all can hear me good?
No.
What about now?
No, not yet.
Yeah. I'm trying to.
We can
Okay,
hear
right
you
there,
now.
right
You
We
there,
can
good
hear
right
now.
you
there.
now.
You
Freeze
We
it
good
can
right
now.
hear
there.
you now.
All right, we good. All right, bet. All right. So no, it's just what you were saying. It just kind of sounded a little. You know what I'm saying? I'm not with love them. Heck no. You know what I'm saying? We all on the same.
Hey, let me ask you this. So what device are you using? Are you using a phone?
Yeah, I'm using the phone, but I was trying to connect it through my vehicle because I'm driving right now. That's all.
Okay, because it's
Man,
going in and out.
it
Turn your
is.
phone up. Cause I think when it's connecting the volume get real low.
Okay. Hold on one sec. Let me try to see if I can do my one sec.
All right, okay. I'll pull you back up. Just pull over and just disconnect the Bluetooth and you just hold it. You can find a safe spot so you don't have to be. But yeah. I thought he was working with love. That must be his auntie. He say, don't come on here talking about my
Oh, she
people like
said he
that.
had to move his hand to the side. That's why.
Oh, okay.
That was in the chat.
Yeah. Okay, hold on. Let's see. It seems like he's trying to come. Oh, maybe he's gonna disconnect and come back and we can see what he's talking about.
It's just a mess because this is just a waste of resources. Like they could have took the evidence they had, tried who they could, and been done. But now it's all it is.
Yeah, and I agree with some of the opinions people, well, not people, but some of the attorneys was saying they should have just tried it separately.
I will say this. It may have worked out. They may have originally wanted it separately, but now it worked out, for the good because the state has a whole team of resources, and now the defense attorneys get the unique experience of teaming up. Because normally when you go to trial, just your lawyer, your client, and maybe another, second chair. But now they got a whole team. You got Weinstein, Matt Shard, and Brian Steele, Keith Adams. Who the other people?
Miss
The
Westmoreland.
Miss Westmoreland. Is it
Harvey,
Harvey? The party
yeah,
said Harvey.
Harvey, yeah.
And then the other guy, he's kind of older. He bring a lot of wisdom.
Bots.
Mr.
Yeah,
Bots, yeah,
Vibes.
yeah, yeah.
This thing would. Yeah, you got the whole team, and even the one that may not be talking as much, they may not be as vocal, but we don't know what they're contributing behind the scenes. There's
To
also
me, they got the dream team, like OJ.
there's another lady behind the scenes. She started off pretty hot in the beginning, but she don't really be questioning, asking them any questions. Now she's sitting way back.
I know who you talk about. She's a good attorney too. I
Yeah,
looked her up.
yep.
Yeah, she is. But a
She's
lot of them attorneys are part of bar association. I mean, the little outside stuff they have, like Brian Steele being part of the thing with Ashley Merchant and and Weinstein. They all have connections too.
right. Yeah, I agree, and it helps as well because the trial is so long. Some days you can't be there. So when you have a team of lawyers, like when Weinstein can't make it, sometimes you have a lady sitting in there with him or sitting in for him, and I think that helps as well because sometimes Love can't make it, or some of the other prosecutors, and they get to sub in and out. They coming in fresh. So the defense lawyer should be able to do that, but not Brian Steele. Brian Steele, he's gonna be there every day.
Yes, he is a man of steel.
A man of steel. And even Kayla, when we first talked over here, before she blew up, she said that she had the dream team of attorneys represent her as well. She came in there with some hard hitters
Oh
to
no,
protect
she
her.
did. All them attorneys were good attorneys.
Mm-hmm. Yeah, she came in there. I don't know. It wasn't Ashley Merchant, but it was another guy. I think she said his name was Gabe, and he was a top.
Yeah,
Um,
Gabe was the black guy.
yeah,
Yep,
and
yep.
then there was another lawyer in there that was with Gabe that represented Kayla, and the judge tried to say it could have been a conflict of interest because that lawyer represented Gunna, but then that lawyer told him Gunna has nothing to do with Kayla. They
Sh-
completely separate.
She had her on her show too.
Oh, okay. So that's good. Yeah, so it seemed like King Stepper, he's still trying. I don't see his camera or he's trying to still work it out. But sometimes it's good to get opinions from the other side.
No, for sure. Cause I've never like I do want justice for the family, but I also have 3 sons, and I would never want them to experience anything like this. And knowing that we live in a world where this can happen, you know, or what have you, because you see what happened to the lady that got killed in her house. I mean, unalived in her house.
Yeah, I actually did, and I was supposed to be going over that last night with Mr. Michael, but we didn't get a chance to do that. So maybe we can do that sometime this week. But yeah, I did see that, and that was real tragic what happened. Uh,
Yeah, that's crazy.
yeah, that was real strange for I mean, I don't know what he was thinking. I really just don't know.
Exactly. I mean, to me, it showed what he was thinking. Every piece of down to his bones, and what he said and how he said it after he shot her.
Um,
But I'm glad they made an arrest. He's charged, and it didn't take weeks or months.
yeah, they can move fast when they want to. And obviously, we know charging is half the battle. It's still a start. You got to start somewhere.
Yes, yes. But usually in these typical cases, they, prolong it.
Right. Yeah. If you get a good, jury, I need to. That's why I want to watch and analyze it and see, because some people were saying
I
you're
think you
gonna
need
have
to
people
do
on both sides.
a video with that by itself and watch the video.
Wait, say
Yeah,
that
for
again.
sure, for
Oh,
sure.
I said I think you need to do like its own video for that and watch the
Right.
video.
Right. Yeah. I plan on definitely doing that sometime this week, giving her her own
Yeah, but I was just
space.
saying how the law, you just want the law to work if your child gets involved in it any type of way, or any interaction we have with the police or the courts, whether it be male or female. But I just feel like the men get it a little bit harder.
Right, right.
It just comes down to a lack of accountability. Like I think they're starting to try to hold officers more accountable, but they're really not held as they should be, like held accountable as they should be. And it's the same with um like the DA's office. Like they kind of can do what they want. Like they have a lot of leeway. Well, not even a lot of leeway. There's no repercussions for their actions. Like
Right,
even with that tragic situation, if that body cam wasn't rolling, he was going to tell a whole different story.
right. And I like what Kimberly said, because that's what we gotta, give.
Oh yeah, they'll make the story fit their narrative. Um, I believe I've seen an article where it was rumored that somebody tried to say it was self-inflicted, and eventually they had to clear that up and say no, that wasn't the case.
Yeah, because her family, they read the information online. They didn't even know that it was a police officer involved shooting when they, I guess, initially seen it on the news or online. Something about the uncle seen it first when her dad had spoke in the press conference.
Oh well, see. Wait a minute, let me see. Have y'all seen this while we wait for he trying King stuff, but he now he got two devices up. He trying to get both of them. One, they both pitch black, and one of them say device is not connected. So if you can hear me, King stuff, it's saying that you're not connected. Oh, now we got three devices. Oh, bro, it's three devices showing up. They said God will fight your battles. All you gotta do is be still. Hold on, let me hit you up.
This is my first.
What's up? No, you good.
This is my first time, being on one of these, so I had to figure out how to work it.
Hey, and I'm gonna say this: it don't sound like you did anything different, but we gonna try. Can it still sound the same?
Just talk loud.
Okay, can y'all hear me good?
Yeah, right there.
Yes, we
Yes,
can hear
yes.
you.
All
We
right,
can
all
hear
right.
you.
For sure, for sure. Okay. I know y'all switched topics. Y'all went to the shooting in Springfield, Illinois.
Right.
But if just getting back to the YSL thing, what I was gonna say is basically the state has to lay a foundation down, right? But those tapes aren't necessarily necessary, you know what I'm saying, other than like confirmation, you know what I'm saying? But then again, they want to use the tapes to kind of impeach what he's saying, you know what I'm saying? Because if he's not saying what they want him to say, right? They want to bring in the tape so they could be like, well, he said this right here. And then also they're trying to play a dirty game by bringing in certain things within the tapes so that the jury can hear certain information that they're not really supposed to hear, that it make them in their mind wonder like, oh, so well this was said, then okay, they must be doing this. You know what I'm saying? So they're trying to sneak little nudges in there to kind of poison the jury's mind, and that's why the defense is so adamant about like, hey, it's a bunch of hearsay within side of these tapes, or information that's not supposed to be heard by the jury, but Judge Glanville is allowing stuff that to come in that shouldn't come in, like stuff like, for instance, um, somebody, they might mention somebody else's name, or told them this or that, right? Well, the defense has a constitutional right to uh, go to how
Confront
do
their
you,
accuser.
yeah, there you go. That's exactly what I'm trying to say. You took the words right out of my mouth. But yeah, they got a chance to confront their accuser, but their accuser won't be there to testify, so they don't have that opportunity to do it. But Judge Glanville is letting stuff like that ride and basically violating their rights, the defense rights, and the state is playing a dirty game, and Judge Glanville is playing along with him, and he's trying to come with any type of reasoning to allow it, even if it's not um, rooted in the law. So he'll just let Love say anything, and then he'd be like, "Well, she said this, and so yeah, you got to understand where she coming from." No, if it's not rooted in law, then it shouldn't be coming in.
Yeah, and there's a lot of exceptions to hearsay that it can come in, and also if you're a co-conspirator, and what the state has been arguing is that any evidence that can be used against one defendant can be used against them all. So that can be an exception as to why we should be able to play the tapes. And a lot of times, prosecutors, I see it all the time, they say, "Oh, we're not offering it for the truth of the matter asserted. We're not offering the tape for what's actually said on the tape. We're offering it to show that it's an inconsistent statement with a prior statement that someone made." So I mean, it's not uncommon.
And what you're saying is good if the other part of it isn't violating the defense's rights
And that's
to a fair trial.
why they following the motions now. They are saying that Glanville violated the law by letting it in, even if the state can say that it was brought in for one reason, but it's violating their rights on the back end. Then Glanville should have kept it out altogether because it's going to poison the jury pool and it's more prejudicial than probative. So I get it, and sometimes judges have a lot of leeway to when it comes to evidence like that. I don't think that's enough to have a mistrial in of itself.
Well, the thing about this judge that we have, Glanville, leeway. Okay, you do. It's up. He's supposed to be the person who knows the law, and he's supposed to kind of use wisdom within letting certain things in. But he was doing flagrant things, and he was pretty much just letting Love have his way. He was being very biased, and he wasn't moving according to the law. They have a certain level of leeway, but when the defense come and quote you the law, right? When he come and quote you the law, and then you make a ruling that's not based on the law, you just say, "Well, I believe and I feel," you know what I'm saying? Then okay, now you're not operating correctly. You know what I'm saying? And that's why motions are being made. Now motions was being made to him directly because he's the head judge in Atlanta, Fulton County. You know what I'm saying? So whenever they make these motions against what he's doing, he's the person that's saying, I'm denying your motion. I'm denying your motion. You know what I'm saying? So there's no way to get around him unless you like literally what the defense has done, went to the Supreme Court, do recusal motions, get it so bad to where the whole public has seen his how biased he is, by doing underhanded stuff like the aspartate meetings and things of that nature. You know what I'm saying? So now that it's got the public's attention, it's almost just hard for them to just like sidestep it. You know what I'm saying? It's just like police officers. Just how you talk about police officers, how he would have if the body cam and all that did come out, he would have just he would have tried to come up with a story and sweep it under the rug and make it seem like it was something it wasn't. It's the same thing when it's not that big enough for where everybody's able to see it on a grand scale and you're the top dog. You know what I'm saying? Like they you can tell that they've been practicing this way for a long time in Georgia, but the corruption is now being exposed, and it's being exposed right now because Young Thug is a very very high profile case. You know what I'm saying? And not only that, the same DA office that's trying Thug for a RICO, they're trying Trump for a RICO, and Trump already exposed corruption in their uh, in their system, in the DA's office, and with their whole process, right? And so now this is just compiling on to, you know what I'm saying, the corruption that they already found, you know what I'm saying? And so it's making it bigger and bigger. And so now because it's such on a big level, now something is being done about it. But had it not made it that far, nothing would have been done.
Yeah, I agree. I think it was time that it was exposed, and it wouldn't have even been exposed if it wasn't for Woody going into that back room and them trying to pressure him. We would have never knew. I mean, we had a feeling that the judge was biased. You can tell that he was leaning more prosecution than defense because of his rulings. But then when we heard he was in the back room, that confirmed, that removed all doubt. Okay, this man is no good. And once that happened, I think all of the YouTubers, the legal world, social media, the news, everybody started picking up on it, the Supreme Court of Georgia, and now it's a big flashlight on Fulton County. And I know they don't like it.
Even beyond that,
You went back low.
Can I piggyback off of him? I was going to say also, because I agreed with everything he said, but just to piggyback off what you said, a lot of money left the city when Thug went to jail.
Mm-hmm.
You know what I'm saying? Because he was given to the city and he brought people to the city, and that brought money. And as you know, a lot of people like certain star rappers are not in Georgia right now.
That's true. That's true. And also to piggy off of what my man said, my man, the host, what's your name? I'm sorry.
I go by TalkThatLaw.
Okay, Talk That Law. Talk That Law. My man, I like that. And just to piggyback on what you said about the S parte meeting, also it the thing that really, really caught everybody's attention was when the judge tried to hold Brian Steele in contempt, and he came out with the whole clan of lawyers, the whole council, and it came out with Trump's the lawyer who was the one who exposed DA Fannie's corruption in the Trump trial. So you see how they all link up.
Yeah, I agree. Ashley Merchant was the attorney. She showed up, and
correct.
And I'm thinking Fulton County. I believe that's the Atlanta. Is that the capital of Georgia?
Yeah, Atlanta is the capital of Georgia. Yeah.
Oh, okay, so I won't be surprised. A lot of high-profile attorneys are there, since Atlanta is like the biggest in the whole state. So I'm sure that's where the high-powered attorneys are, where the clients are, to make more, more money, more clients, so you can reach more people. So to see Ashley Merchant show up shocked me, but I guess it's not a surprise that good lawyers know good lawyers, because she's good and she knew Brian Steele. So of course she showed up in her pink cape, and she came in there. She wasn't playing at all with Glanville. She said, "You're not gonna. If you're gonna try to send this one to jail, you're gonna have to do it the right way."
Because Brian's still one of the biggest in Atlanta. So you think you're gonna just lock up one of the biggest in Atlanta? And all the attorneys they have.
The audio had went low again.
I said Brian Steele is one of the biggest in Atlanta, and you think you just gonna lock him up without any type of repercussions? You know what I'm saying? Those attorneys, they got their unions, they got a brotherhood, sisterhood, and they gonna lock in. You know what I'm saying? For somebody like Brian Steele, who's one of the biggest attorneys in Atlanta.
Yeah, and he's proven. I'm sure he's going to be bigger after this because he might have been known in Atlanta, but now he's known all over the country.
Exactly.
When you got people like us watching and supporting. But now it was just released that Fonnie Willis wrote a letter for YFN Lucci for early prison release.
Yeah. Do you know? I mean, it's been speculated, right? You know, it's been said that Fannie Willis, right?
Okay.
She was involved with Donovan Nut Thomas, which was I believe he was Lucci's manager. You know what I'm saying? He's the one who got killed. You know what I'm saying? And so it was been speculated that that's the reason why she really wanted to bring this case and put this against Thug or whatever because of her relations with him. So it would only make sense that she would want to release Lucci and target Thug. You know what I'm saying?
Wait a minute. So okay, so what you're saying is uh, YFN is a friend of Donovan Thomas of Nut.
No, D.A. Willis.
Yeah,
Was
YFN is If Gang, which they say Fonnie is affiliated. Well, she's like affiliated with him in some way. That's what they say.
And
no
wasn't
no
he
no
on?
they said
Wasn't
they used
he
to
on
mess
his
around.
record label or something? He was trying to produce him or something, and that was the issue with Baby and all that.
No, so what I was talking about is D.A. Fannie Willis, the one who was sleeping with Nathan
You went
Wade.
Hey,
back out.
yeah, move it again.
All right, can y'all hear me?
Yeah, right there.
Okay, what I was talking about is D.A. Fannie Willis, right? The one
Okay,
who was sleeping with Nathan Wade in the Trump case, right?
that wasn't no lie.
Wasn't no lie, right?
She confirmed it.
Right. So it was said that she had relations with Donovan Nut Thomas.
That's what they call it. Relations with. So wait a
This,
minute. So who is?
just like with Nathan Wade.
Wait a minute. So who was the other guy that said she was connected to?
Nut Thomas.
No,
Donovan
no, no. The other YSL guy,
They were saying Monda. She was his
Mondo.
lawyer.
oh yeah, I think she
Yeah,
did
they
like
said
some work for
Mondo,
him.
Oh,
but
she
they
was his
said,
lawyer.
but
She was
even if they weren't having relations, it's like Atlanta. From my understanding, everybody knows everybody too. So
Atlanta's not that big. It is kind of small. Like, you know what I'm saying? It's not as big as you think.
are
I
you
lived
from Atlanta?
I lived in Atlanta for about 12 years. I just recently moved from Atlanta to back to Chicago during the pandemic.
Oh, okay.
Yeah. So Atlanta, like once you in the circle in Atlanta, that you're in the mix, you'll see that you're running to the same people at all the same places. Like you're running to everybody, you know. So it's kind of small like that. But
Right. So that's what my understanding was. She was connected. She was close to that family regardless. If they
she was in like a relation. I can't say relationship or they were just having relations, but they were intimate. You know what I'm saying? So so naturally he gets killed. She wants revenge for him, and not only that, she's looking for her political um, rise in the ranks. She's trying to run for some offices. You know what I'm saying? That's why she took on Trump. That's why she wants to get all these rap people, you know what I'm saying? All these raps rap groups and different stuff like that. She's trying to, anger herself so that she can move up politically. But it's starting to
Yeah,
backfire
I
on her.
said that too, that it was political, but which that's usually in any state is usually political when it comes down to it.
She's trying to be Kamala Harris. Let's just put it like that.
She's trying to become who?
Kamala Harris. You know,
Oh,
Kamala Harris was a prosecutor locking up everybody too.
yeah, they said she started as a prosecutor in California, then worked her way up to the attorney general, and and then went to the Senate from there, and then obviously the vice presidency from there.
Able to put Trump.
Hey, do it again. Adjust it.
Can you hear me?
Oh yeah.
Okay, imagine if Fonnie Willis was able to put Trump and Young Thug in prison. She probably would be running for president next, or vice president.
I don't know. It seems like she'll probably alienate two bases at the same time.
She might. She might alienate bases, but just having those convictions, because you got to think about it, right? Why you think she's rushing so hard to prosecute Trump before the election? You know what I'm saying? Like, cases don't move that fast. You look how long it took for Thug case.
Oh yeah, they don't move that fast at all.
I thought Trump's case was paused.
No, it's paused now, but I'm saying when she was moving her efforts to try to get
Right.
Trump, she was trying to hurry up and get it done before the election. But outside forces stepped in and intervened because of her corruption.
Right. I mean, if it's supposed to be about justice, she shouldn't be concerned with when the election happens, when it don't happen, unless it's because when you start rushing before the election to try to hear if and make him convicted, it almost seems as if you don't want him to be voted into office. You want to hear if and try to get him before the election comes, and then if that's the case, then your goal is really not seeking that justice is done as a prosecutor.
Politically motivated.
Yeah, it's politically. It was seen as is politically motivated, and on top of that, she saw that in New York, that they did it there, but now it didn't stop nothing. They thought he was gonna get a felony conviction and just go away. Them people out there in New York, they more Democratic. But his base got charged up, supercharged now. So if they wasn't going to vote, they're going to vote definitely for sure now.
Yeah. So this is the thing, right? So they figure all these different DAs who's doing this to Trump, they figure, hey, look, let's hurry up and get them locked up. We got our biased judges that work for us and that's with us, right? We go ahead and hurry up and get them locked or get them convicted before the election, right? We know already that it's gonna be overturned, but long as we get him convicted before he's able to run for election, then
you call him a felon and stuff like that.
Yeah, so then once the Democratic president is elected, Biden, Kamala, or whoever, then he might win on appeal, but it's too late. You know what I'm saying? That's what they were all banking on, but
they
underestimated.
They failed miserably. That plan failed miserably.
Yeah, they failed miserably.
They don't know his base. Them people, and when I say them people, I mean his hardcore extreme base. Mm-hmm. They were willing to storm the Capitol. They would elect him sitting in a jail cell. They're not going to change their mind because a liberal prosecutor brought some charges from 2015 against him. That's questionable in itself. I don't know how many people would follow that trial with the Stormy Daniels stuff, but that almost seemed kind of political because that happened in 2015, and then a new prosecutor came and went way back to 2015, and then even with Young Thug, a lot of this stuff happened in 2015. Then you had a prosecutor like Fonnie Willis that reaching way back to 15, way before they were even in office. So it's kind of hard to say it's not political when you reaching back so far when the prosecutor that was elected at the time did not even prosecute those alleged crimes.
Yeah, now when all the cases. When that the girl who y'all just mentioned got in trouble, that was here in our state, in our city, and she came here for a show, and they had the cops raid the strip club she was appearing at. And she wasn't even taking her clothes off. She was doing like a meet and greet. But she ended up, I don't know if she sued them, but she ended up winning a case against the police here.
Mm-hmm.
I can't think of, what's the girl y'all just mentioned? That
You talking about Stormy Daniels?
yeah, she got in trouble here. Well, not really in trouble. They tried to, and that was political, you know. It was right after I think the case had just came out. The lawsuit had came out. But I wanted to say about back to the YSL case or what have you. I don't think I think it's kind of confirming, even if it's rumors or what have you, about Fonnie Willis involved with Nut. It doesn't look good with her trying to get YFN Lucci out of jail. However, anybody want to look at it, that's not a good look.
Mm-hmm.
Yeah, it don't look good, and I'm not sure if it may be a standard part of a plea agreement that they won't contest it, but it sounds like this letter that I just seen, and almost looked like it was personal because she said you can reach out to my office at any time, and that's what she said at the end, at the bottom of this letter right here. Please
Yeah.
feel free to contact my office anytime, and her office is Fonnie Willis herself.
Yeah. See, YFN Lucci, he already got sentenced, and he only got to do like a few months. To be honest with you, so at this
No,
point,
his parole date was for 2026, and I guess that's what this
no,
letter is to get him an earlier parole.
no. If you go check his if you go check his what you call it
It was
his
2026.
sentencing. No, in his sentences, they said long as he abide by the rules, he will be out in a matter of a few months. Like he only got like a few months.
But his date in the system was 2026. That's why there's now this letter to get it that he's released sooner.
No, go look it up. I promise you. I promise you. They basically said he was gonna get out in a matter of like 3 to 4 months from the time
It's past that.
huh.
It's past that. It's been like 3 months, hasn't it?
So I'm guessing what she's doing is basically like he has to basically like be on good behavior or whatever the case may be, and if he fulfilled that, then I believe maybe she would.
You're making that up.
I'm not making it up. If you really go look when they sentenced him. If you go look when they sentenced him, they said that he would be out in a few months, basically.
Yeah, they said that, but then if you actually looked in the system where it lists your parole date, his parole date was dated 2026.
Parole is different from being in prison.
Duh, I know what
What you
parole
mean?
is.
You could be free and be on parole.
You are free if you're on parole. That's you getting out of jail. You're just on papers. I know what parole is.
Okay, so by him having whatever deal they gave him, where he's able to be out in a matter of a few months.
A few months. That's what I'm trying to tell you. They said that. They said that in court. Like he got his sentence in court.
That's what I'm saying.
But you know when you're in jail, you have a parole date, like a date. I don't. What is it called? Like a TTP. What is it called? Do you know?
So
Talk
you
that law.
talk so basically you're talking about like the end of his parole. That's what you're talking
Well,
about.
No, I'm talking about his parole date that he
what
would be out of prison.
what we
No, no,
have
no, no, no,
here,
no. You could be out of prison and still be on parole.
You're not
right,
getting. You're
right,
not picking up what I'm putting down.
right? Because basically she's saying if you're out of prison, you are on parole unless you completed your full sentence. But we
Huh?
have
Hold on,
what
hold
we
on. Say
call.
that again. Say that again.
What she's saying is you saying that you could be out of prison and be on parole, and what she's saying is if you're out of prison, it's because you are on parole, unless you did your full 10 years that he got, and
No,
obviously he
no.
didn't do
Okay,
that.
okay. Parole is just like probation. You know what I'm saying?
We know what parole
Right.
is.
Okay. So all I'm saying is I did ask you. I said, are you talking about the end of his parole?
I'm not though. I'm saying he got his sentence in court and he got credited time served. but you actually have to have a parole hearing. His parole hearing date or whatever date that they put in the system wasn't until 2026. That's why he had to get this letter, or whoever filed the letter, they filed a letter to get that date pushed up so he will get paroled sooner. And I do believe when he was sentenced, that was part of their arrangement, that the DA's office would not fight if he got they wouldn't fight him for an earlier parole date or whatever, or earlier release. They wouldn't fight it. That was part of his parole, I think, if you go back and watch it. So that's basically what this is.
That's what I said earlier. I said that's probably the reason why she's writing that letter.
We can't hear you.
Yeah, it went.
I said that's what I said earlier. That's why I said that's probably the reason why she's writing that letter, because he fulfilled what he was supposed to fulfill in order to be able to get out in a few months. That's what I said.
He got time served. He didn't have to do nothing. He got time served. And his
Wait a
sentence
minute.
was what, 3 years? And he's been in jail
If y'all
2.
if y'all have the website, then I can try to pull it up to see exactly.
It's the
Okay.
jail website, the inmate website.
Yeah, let's see if we can look it up.
So it's Georgia prison website. Okay, Georgia.
Maybe just type in YFN
prison
Lucci.
inmate search.
Because y'all kind of both saying the same thing.
That's what I thought.
Way.
We were saying the same thing.
Just in a different way. I think she might know a little bit more recent news, maybe. I don't know. Y'all both got the same, sound like the same kind of.
I'm finna look it up. YFN Lucci release date.
But yeah, what we call it here is a parole eligibility date. So basically, when you're eligible for your first date, that don't mean you're gonna get out. But every 6 months, you'll go and have you're eligible to go before the board to see if you can get out. And I mean, that's pretty standard in all states. And I think she said it was in 26, but this letter had to get to 24, which is now, if I'm following her right.
Yeah, that's what I'm saying.
So what do it sound like that he's going up for parole?
So he was offered a plea deal. He pled guilty to 13 RICO charges against him. Murders. Let's see. Attorney Drew from pleaded reported. In fact. Okay. It say right here, breaking. YFN Lucci will serve about 3.5 months in jail, and then he will be released and serve the rest of his sentence on probation. This is by WSBTV. Let's see. Try to see if I can find another source. According to the AP, when Lucci agreed to the hold on, let me get to the actual. I'm trying to find another source, but that one said he's supposed to serve 3.5 months in jail. That's what that one said. I'm gonna find another one just to be clear, Okay. All right. This one says YFN Lucci is expected to be released on probation in the next 4 months after agreeing to last-minute plea deal.
So she was already saying, so that must be part of what India was saying, that the time served, wasn't that India that said that he did 2 years already?
No. See, the thing is, this is a plea deal. This is a last-minute plea deal. That don't got nothing to do, because they was gonna charge him with 20 years, but they gave him a plea deal.
Your mic is going back out.
I said they were gonna charge him with 20 years, but they gave him a plea deal. He didn't do no
Right, but
time served
how
for
many
2 years.
years has he done already,
He
though?
only been in jail for like 2 years, 3 years.
Right, I think that's what India said. That's what
But
she was
that's
saying.
not time served for a 20-year sentence.
He didn't get sentenced to 20 years. He did the plea agreement, And
It said
the years he's been sitting
it
counts
says
towards
Fulton
those
County
years.
DA Willis previously presented Lucci with a 20-year sentence deal, with 17 of them having to be served behind bars. However, he'd be required to confess to several crimes, including felony, murder, racketeering. He ultimately opted out to sign on the dotted line. Let me see.
What I'm trying to do is find like a recent article, and then I can.
Okay.
Do you know how to look up their like inmate search, like their jail system?
Yeah, I did, but it didn't really show me nothing as far as the parole dates.
Yeah. Like you really gonna have to look up his sentence. Just look up YFN Lucci sentence, and you just got to find a credible source. You know what I'm saying?
Yeah, because I'm on the state of Georgia site,
It's
and it
do
and
they
it
show their
shows.
docket sheets and stuff?
No, not on this one. It just shows him, his picture, uh, his max possible release date,
And what do that date say?
January 13, 2031.
Oh
Told you
yeah, no,
20 years.
that wasn't what I seen.
Yeah, that's a 20-year sentence. See, but I guess within the plea deal, they're gonna basically hit him with probation. Like you know what I'm saying?
Well,
Yeah, let him out in 4
well,
months.
yeah, but probation is separate, but the term is parole, like you were saying earlier.
Well, from what I'm reading, it ain't even saying parole; it's saying probation.
Yeah, so when you let out of prison early and you still have time on your sentence, then it's parole. But
No, no, it can be parole or probation.
if you're trying to stop from going into prison, let's say you were sentenced to 5 years, but they suspended it and give you 5 years probation, then you don't enter the prison system. You take your probation. So that's the distinction. Um, and with parole is when you're getting out earlier on parole, uh, and that's pretty universal across all states. The distinction between the two terms, um, and we can.
Okay. Let's see what they say. Okay, they say parole and probation are both forms of community supervision in the criminal justice system that can help offenders reintegrate into society and reduce. I don't know what that word is. I ain't gonna lie to you. But then it say parole is granted after a offender has served part of their prison sentence and is released early. The parole board decides if someone is eligible for parole and their behavior in prison can affect their changes, and parolees serve their remaining sentence community under supervision and can be returned to prison if they violate the terms of their parole. Parole officers help parolees re-enter entry plans and succeed their communities. Okay,
Right
that's
now,
parole. That's parole.
that's
Now,
parole, right? Now,
now
reprobation.
here go probation. I'm sorry. Excuse me.
Mhm.
Okay, probation is a component of a court sentencing process and is often granted as an alternative to incarceration for less serious crimes. Probationers serve their sentence in the community under supervision, but have not yet served prison time. The terms of probation vary by individual and charges, but probationers may be required to meet certain conditions, such as remaining sober, avoiding certain establishments, or attending counseling. If probation abide by the rules, they may avoid jail time and their changes may be reduced. Their charges may be reduced or dropped. The sentencing judge retains jurisdiction over probation. Okay. So, but check this out. So, with the distinction right there, it would make sense for probation because he hasn't been actually sentenced. He hasn't actually been to prison yet. He's been in jail holding for a prison sentence.
No, I think he's in prison. I think he's in the Department of Corrections.
No. What I'm saying when they make the sentencing.
Your mic,
Okay, hear me?
Yeah, I can hear you.
Yeah. When they prior to him being sentenced, right? He wasn't in prison.
Okay.
So if they said, hey, well, you have to do this amount of time and show, say, because you already did this amount of time. Now, I can't tell you for sure if they sentenced him to prison, if he went to prison or he just went back to jail. I don't know that. You know what I'm saying?
Yeah. Well, yeah. When you're anything over a year is felony, and felonies are handled in the prison system. So if it was, let's say he was sentenced to 9 months in jail, okay, you can handle that in county jail. Some states even have what they call state jail. But when you got 5 years in prison, 6 years, 7 years prison, 10 years, 20. I think his prison was 20 years. That's definitely what we call in Texas TDC, but over there in Georgia,
but technically, if he would be doing any prison time, it would be 3.5 months. Because he hasn't did prison time prior. He did jail time.
Hold on, let me share this to where he's at now. And then obviously this is the Georgia Department of Corrections. Obviously it ain't your local county. And it's actually currently serving in the state of Georgia for gang participation. He came from Fulton. His prime date was December 10, 2020. His maximum sentence is 20. And he started his actual prison term January 23rd, 2024. And he'll get credit for all his time served while he was in the local county jail. Wait, where'd he go?
He's still there.
Oh, yeah, you get credit for any back time. Like the trial I got now, my client's been in jail for 2 years. So if, let's say, in the unfortunate event that she does get a sentence, then she'll get credit for those 2 years. So let's say she's sentenced to 2 years in prison and she already got 2 years credit for the jail, then she'll potentially never have to even go to prison. Worst case scenario. Mr. your mic.
Oh, I'm sorry. What's the name of it? What's the name of the facility he's in? Let's see if that's the actual prison or. So Georgia.
Yeah, Georgia Department of Corrections. That can't get more prison.
No, we don't know. We don't know if that's a prison or a jail. We don't know that yet.
So you saying the Georgia Department of Corrections is not a prison?
So
Department of Correction is state or state institutions. It's
right.
the DOC. It's in every state. It's the DOC. When you're talking about county jails and things like that, that's different. But
I'm looking it up right
DOC
now.
or state.
We even have his. I think it said the most recent one he was at. And let's see what this pulls up as. So he's at the Barres Correctional Training. This the training center, and then I'm gonna Google what this is. The training center. I know everybody don't know.
That must be like a CRC, like before you go to jail.
No, this is the facility. And it's a adult male felons and medium security state prison.
To like a detention center. Kinda.
Yeah, that's what it sounds like. Like here in Ohio, before you go to the penitentiary, you go to CRC, and then you go to the penitentiary. It's like a place. It's like a penitentiary almost, but
It's
it's
like
No,
an
it
in
just sounds
between
like
center.
it
It's like
just
an
sounds
in
like it's just
between
not
right,
a
right.
it's just a lower
transitional
security
transitional
facility.
center.
Yeah,
It's like a transitional spot.
that's how they normally do here,
Right,
even in
exactly.
Texas.
Yeah,
They ma-
transitional spot.
they make
Exactly.
when if somebody gets sent to prison, they group everybody together and then they figure out, okay, which one we gonna send you to. It may be based on your education, your skill sets, um, the capacity of the prisons, and then once you get to that station and they can evaluate you, then they ship you off to the various prisons. And that's here in Texas. It may be different in other states.
So it sounds
Yeah,
like
that's what ours is.
so
CRC in
and
Ohio.
that's how Chicago is too. But it sound like they got him in a transitional center, basically before they let him out. You know what I'm saying? Versus going to prison. Now if he don't meet the qualifications, then they'll probably send him to prison. You know what I'm saying?
Well, it could depend because if he just went there, it depends on how long the process is. If he's
Well,
going to
it's
be
it's
an in
been,
and
it's
out,
been close to about 3 to 3.5 months since he got sentenced. It's
oh,
been close
okay.
to that. It's been close to. Matter of fact, let's look it up so we can be accurate though.
So he's been in a county jail this whole time until he was sentenced in January.
Yeah.
Oh,
Same
okay.
thing with Doug. Same thing with Doug. Doug is in Cobb County uh jail. That's where he been at.
And then obviously we can go back here to Fanny's statement. I mean, she clearly said the words prison. Y'all see it?
Yeah.
The first time he becomes eligible for parole after serving 1/3 of his prison sentence.
She said prison sentence, but that don't necessarily mean that he actually had to go step foot in prison though. But I'm finna look up what I said I was looking up. Damn, it just slipped my mind.
Uh, I think you were going to see how long
Oh
has
yeah,
he
how
done
long?
so far.
Yeah. I was gonna see how long. Yeah, how long? Yeah, that's right.
Oh,
How?
somebody. Okay, we got a shit. He was credited time served for the time he did in the county jail, and she's putting in I guess a word for him for early release date before 2026, and he'll be coming out on probation. So
Cause
that's
I
kind
be,
of like, yeah.
cause I believe what they said in court was like, if you meet the compliance, you know what I'm saying, after a certain amount of time, by the 3.5 time, then maybe they said something like she'll write a recommendation or something like that so that you can get out in three. So they basically say, hey, like, if you do well, you can get out. And she has to write that letter for him. So I don't think that was nothing like malicious or like, you know what I'm saying, that
What, what,
she
what
did
you
in
mean
that
by malicious?
on her end.
Oh
Like,
no, not writing a letter to get him out. Yeah,
no,
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 I don't think it was malicious. That's not a malicious act.
yeah, I
I
think I
think
think he just
I
meet the
think she
requirements.
had I don't think it's a good look with, even if there are rumors that she has a connection to the family already, and that she has a motive in prosecuting this case. You get
Hmm.
what I'm saying?
I definitely
Already it's a
agree.
dark
Definitely
cloud
agree.
over the case from just what the judge did with the ex parte meeting. So along with that, and then here you are, front page advocating for, the ops to get, so, hypothetically or allegedly, that, for them to get out of jail for whatever your reasons are. You get what I'm saying?
I think
Like,
it was part of the plea though. I think this was part of the plea, if I remember the
was
court
his
hearing
plea
correctly.
before? Was it before the young thug?
Okay, here
I
it is.
want
I
to
got it
say
right
it
here. I
was
got it
it was
all right
it
here.
was
I got it all
during.
right here.
I want to say it was during.
It
Right.
said
So
it said it,
that's
it
not
said
a
it said right here, y'all.
It's
It
on
says
YouTube.
according to WSTB, the Atlanta rapper was ordered 10 years in prison and 10 years on probation, with credited for already serving 3 years in Fulton County Jail. His time served also reportedly makes him eligible for parole in 3.5 months. So there you go, right there.
Right. I got what you were saying, but what I'm saying overall is that it's when they prosecute somebody, they don't just come up overnight and prosecute somebody.
Mm-hmm.
So I'm saying if this was during or after the young YSL Rico trial, then it could be. I'm not saying it's
Oh no
true.
no no no! Check
This
it out.
is only
I agree
my
with you
opinion
100%. I
of
agree with
what
you
it
100%.
of what the optics look like
Yes,
that you have a ulterior motive because all this was going on at the same time. And if she is advocating for Nuts family, that is originally where YFL Lucci or whoever was on that side. He wasn't with Thug, if I'm understanding it right. So
yeah,
if
yeah.
that's the case, it does not look good. It looks, I'm just saying the
No no
optics
no no.
of the situation.
You're 100% correct, and I believe that was my observation. Like I said, just the fact that she supposedly had a relationship with Nut. You know what I'm saying? The fact that she is pushing so hard to get Young Thug locked up. You know what I'm saying?
Right.
But
And
but
they're
but but but
they're
yet
not they're both rappers. They're both, you get what I'm saying?
yeah,
Like, so you're advocating for one and trying to put one in the jail, even
correct,
leaving out all the other stuff. Just
correct,
how that looks.
correct. Yeah, and my personal opinion is she's trying to get revenge for Nut because that's somebody who she had her intimacy with and somebody she probably cared for. You know what I'm saying?
YFN had a Rico too, though.
Yeah, they had a Rico too because it was bodies dropped on both sides. You know.
But the question
Right.
would
So
be,
that even I'm sorry. I was just one more thing. I just was saying that makes my point valid even more that, if he has a Rico and they have the same thing, but you're advocating for one and then you're, pushing hard for this one. And she is the DA.
You're 100% right. You're right.
yeah, and I mean,
I agree with you.
and I will say, but Nut passed away in what 2015,
Yeah, it's been almost 10 years.
right? So why would why
Oh,
would Fonnie prosecute YFN in the first place, only to turn around and help him out? It ain't like she didn't know about Nut's murder because that happened in
oh,
2015.
check this out though. Check this out. So she been tried to give Lucci a way out. She wanted Lucci to flip on Thug, but Lucci refused.
And then
Oh, I got you.
a lot of these charges that they're bringing up are old. That's why Woody looked it so young in the one picture. Like,
Real
because,
young.
yeah, because a lot of this stuff is old.
Where the statutes of limitation at?
Dude, we went through the law earlier. Right now, we just talking. we went through the law. We got that out the way earlier. You got to. I mean, we going on hour number 7, dude. So we just talking, trying to put pieces together, putting 2 and 2 together and getting 10. But it's good though to get different perspectives from different people. Oh, your mic, King stuff.
No, I said I appreciate you bringing me on because
Oh yeah.
I know you heard my comment. You like, man, what the?
Right. I was like, right. Ain't no way I'll be able to fake being a lawyer in Houston. As big as Houston is, it's like Atlanta. People
Yeah.
gonna know you, they gonna know your face. Oh, y'all seen him in court. Yeah.
No,
So
facts.
even though it's a big city, it's still small enough because everybody's still going to the same courthouse all the time.
No, big facts.
But I definitely appreciate you coming up and hopefully we can get you back sometime in the future. And
Yeah,
don't pay no mind to the
I like
comments.
talk about this stuff, man. And
Right, right.
I've been following it real close, and I've been following the Trump stuff real close. Because I feel like all this stuff is real relevant. You know what I'm saying, to like how us as black people, white people, whatever. You know what I'm saying. What we got to deal with, like when the law was being misused on us. You know what I'm saying.
Yeah, I mean it's good to know. I always tell people it's good to know your rights.
Yeah.
Because a lot of times people don't know their rights and they just, they think they know them and they start, oh, I know my rights. So I'll talk to the police and next thing you know, they get themselves in a world of trouble. But even more so than that, I always advocate prevention is better than a cure. Like you don't have to worry about taking medicine because you got sick. Uh, don't get sick in the first place if you can help it. Like don't get in trouble. What I mean, don't go to jail or be out there doing crazy stuff where you can get locked up on a Rico charge. But if you do get locked up on a Rico charge because you could be innocent, then you need to know your rights to like be quiet and get a lawyer immediately.
No, facts.
Yeah. But appreciate it. Hopefully, you said you're in Chicago.
Yeah, I'm in Chicago now. Yeah.
You definitely got to stay safe out there because they be shooting like crazy.
Yeah. Chicago, one of them cities, man. You got to be on point. But at the same time, it's a beautiful city. It is some really good people in Chicago. It's just, you know what I'm saying. I know it seems scary from the outside looking in, but like once you like in there, like if you know how to move, it's really a beautiful city, man. Like you think about the Lake Michigan, you think about the city itself. It's a beautiful city.
Yeah. I mean, I get it. You sound like the former mayor when she was advertising for businesses to come to the city. And a reporter was like, I don't know why you're patting yourself on the back. We had like 100 shootings in just one weekend. And I know the
Man,
lake
we
may
got
be
Angel
good, but
Reese. Hold on, we got Angel Reese.
I ain't trying to be ducking, brother. I know the
Wait a
lake.
minute. So what about the Tiffany lady that's always on all over the internet?
Who is that?
Tiffany, I don't know her last name. The mayor. Are you can't hear you.
She's like the mayor. She's the mayor of Dalton, and she's like the mayor. She's like a double mayor. She got she hold like two positions, but supposedly she's supposed to be real corrupt, like stealing money and all types of stuff, and they can't get rid of her. You know what I'm saying?
Oh yeah, I think I heard of that one. And then they brought the former mayor of Chicago
To
to
Right.
investigate her. Yeah.
investigate her.
Right, exactly.
I said that was so
You know
funny
what
to
I'm saying?
me.
I don't know enough about her, you know what I'm saying, but I've heard things, but I haven't really looked so deep into her
Right.
situation specifically, but I heard a lot, but I like to go off of facts before I accuse people of
What they
stuff.
saying
Right.
she
That's
did?
why I was
Did
asking.
she run
Did
off
you
with the money? Or what they
Man,
saying she did? What she's accused of?
so they saying that she taking the taxpayers' money. She closing down like clubs and businesses and stuff like that, and taking their money, and then she's going on extravagant vacations and using the budget of the taxpayers' money instead of putting it
Uh-uh.
towards the resources that it's supposed to go to. She's putting it toward. She's just pocketing in her pockets, and she's they basically saying she's stealing.
Oh, that's that's the easy one.
Yeah, they basically
Yeah, because she reminds you of Fonnie in a type of more
yeah,
ratchet way. Like she don't care about nothing. She doing what she gonna do. And
cause she got the power, just like Fonny. You're right, just like Fonny. Fonny is like even some of them the judges, they got to answer to Fonny. You know that, right? So it creates like a conflict of interest sometimes. Like so, if they trying to investigate Fonny, but the judge she paid the judge salary. You know what I'm saying? What you think the judge gonna do? He didn't all the way out just throw her off the case and stuff like that. He threw out Nathan Wade, but he left her on. You know what I'm saying?
Yeah, I mean they all get paid through the state.
Yeah, the
But
taxpayers paid her salaries.
Yeah,
but
but she's the head person in charge though.
I
So
mean,
But
I
she
would.
don't have.
they got to answer to her.
I've have said this before that prosecutors are really the most powerful people in the court system, even more powerful than a judge because they decide what charge to bring, what charge to dismiss, and the judge can only consider what the prosecutor brings. So guess what? If a prosecutor doesn't want charges to be brought, there's nothing a judge can do because it won't be before him. Or if a prosecutor do bring charges, the judge can just throw it out unilaterally on his own. The prosecutors speak on behalf of the people. So prosecutors are really powerful players in the criminal justice system. That's why they
And
got.
I'm glad
Do y'all remember
I'm
when?
glad you
Do y'all
said
remember?
that because hold on, sweetie. I wanted to piggyback off what he said because that's why we have to vote for because that's what I advocate for voting for prosecutors if you because they're the ones who prosecute us. So if we don't have a rapport with them, we can't win. You get what I'm saying? But anyway, my son was killed. And when I met with the head prosecutor, she was the because I had to advocate them for them not to dismiss the charges on one of the people that was charged in my son's murder. And I met with the head prosecutor. She's the one who makes all the decisions, like he just said, whether it goes to a judge or not. And we didn't agree. You get what I'm saying? Because first of all, they can't relate to us. Some of them, certain people that be in position can't relate to us. So when I see a person like Fani in position and abuse it the way she does, like that's where we come into play. If you're in that state or whatever state, that's you got to go vote. Yeah, this presidential stuff is matters, but the local stuff really matters. Like God forbid anybody has somebody murdered in their family and you don't get justice.
Yeah, I agree. You have to definitely participate in your local election, not just when a president is running. Um, but I do want to stop and pause before. I want to thank Minister Fears. Thank you so much, Minister Fears, for the cash app you just sent in. That was really kind of you. And it's not your first time supporting the stream. In fact, I think you had the last time you supported the stream, you sent $100. So that's not, it don't go unnoticed. So thank you so much for doing that. I know you didn't have to do with Minister Fears, and I got it scrolled up so don't share your information. But I do want to thank you. All right, I'm about to give me a hamburger. I always say that. Give me a
Yes, me
hamburger tonight.
too.
It's
I
definitely time
enjoyed
to eat.
talking to y'all though, and y'all
I
have a
enjoy
Yeah.
it
good
out
night.
too.
Yes, thank you so much, and I always thank you for sharing your story. I know it's not easy talking about it, but I think every time you talk, we have a different crowd, so it brings more awareness to what's going on
Oh no, it's
out in the
therapy
public.
for me too. It's definitely
Okay.
therapy.
Okay. Well, thank you so much, and hopefully, we'll be talking soon.
Yes, same
Okay.
here.
All right. Well, you have a good one.
You too.
All right. All right.
All right,
Bye,
man.
y'all.
Enjoy it, y'all, man. Y'all take care.
Okay. Well, thank you, India, for reading for me. India came on, and India like, man, I didn't got stuck. I thank you again, India, for reading, and thank you for coming up, King Stepper. Uh, and, and hopefully you come back again. You had some good insight on your views. Your mic is hit it one more time. Okay.
Oh yeah, for sure I will, man, and I appreciate you, brother.
Okay, all right then. Well, you stay safe out there. Yo, say it one more time.
Yeah, for sure. You too.
Okay, all right, appreciate it. All right, have a good one. All right, y'all. So you gotta go vote for local legislators as well, and no problem. Yeah, thank you so much, Minister Peters. You're always kind and supporting the stream. Yeah, you got to vote for your locals as well. Some people, we don't got to worry about them. The president not running, the governor's not running. Why even worry about it? But yeah, you got to do your local legislatures. And being in my field, you never know when you may run into a politician. I thought King Stepper was coming back. I see he clicked back on the link. Yeah, we just recently lost a politician. Rest in peace to Sheila Jackson Lee. She was a congresswoman from the Houston area for 30 years. I remember seeing her at an event. She said this is a noble profession, being an attorney. So I wonder what she would have said. She would have found out Glanville had all this carrying on and get-togethers going on in Georgia. Brian Steele said in the motion they having a get-together. Yeah. But all right, y'all. So I guess we will probably be back on Friday for the YSL responses to the motion. The state filed motions today, the defense filed motions today. We went over every single one of them. And then on Friday, the replies, they have to respond to each other's motions. And then we can come back on Friday and review that, hopefully. And then between time, we might even cover the video of Miss Sonia Massey and the incident that happened with the police officer after she called 911 for help. We might do that sometime this week. I got to get with Mr. Michael to see when he's available, because he emailed it to me. He asked when can we cover it, and we couldn't link up last night. So hopefully we can do that this week, just to walk through it. Most people already seen the video, but we can just still go through it and talk about it. But it looks pretty self-explanatory to me. If y'all do watch that stream, I want y'all to come with some questions. Was he justified? Was she attacking him? Did he fear for his life? Should he have retreated? Did he make it worse by running towards her instead of away from her? Should the other officer be charged, or did the other officer do all he can do? So those are some type of questions that I would want to ask. And I am curious because I haven't heard the 911 call yet. Anytime I get a case, I like to start from the top, because they are saying that she called 911. That's what started this whole ordeal that put the officers on her front porch. Where is that 911 call? If somebody get that 911 call, email it to me. My email's in the description. Because I want to see what was her call when she called 911, and then we can work our way down from the 911 call all the way to the end. They released everything but that, which is strange to me. You released the footage, but not the call. And I'm not even sure if the family is pressing, for the call, or if they even, I mean, after the video, they're probably like, whoa, do we even need the call? No. But it will help shed some light on why they was there. But then if there's no call, then I'm going to have bigger questions. I mean, you can't just say, oh, yeah, she called, we showed up, she was having a mental. No, where's the call? Did the call sound strange? When y'all knocked on the door, did y'all announce yourselves as officers? I mean, because if it was a woman alone alone in her home and she's thinking someone trying to break in and she hear beating on the door, she might not even realize that it's law enforcement. You might be still hiding in the, in a safe spot, shelter, closet. So those are all some things that I really want to see. But all right. Thank you again to Minister Fears for the kind contribution in the funny comments. I see them. I'm reading these. Y'all be lit in the chat. Y'all be lit in the chat. Who guilty? The officer is guilty, or are you talking about YSL? I got about 3 more minutes till we hit 7 hours. Let's hit that 7-hour mark and then we can call it a wrap. Let's hit that 7-hour mark. But yeah, thank you to Minister Fears and also to my 4 girls. For the contribution as well earlier today. Law Malcolm, guilty or what? Oh yeah, those comments are funny. But sometimes it's good to to educate and entertain at the same time. I'm glad he really came up with it. Sometimes people can just say some random stuff. Like what? Let's say some random stuff. Now I just went to the store and bought a law license. Texas is one of the hardest bars around here. Texas bars. All right, we got about 1 more minute. No questions, no comments. Because soon as we hit the 7-hour mark, then I don't think I have any. And hopefully my video, they said they deleting videos at the DA's office. They deleting the videos, y'all. DA Love is deleting all the videos. Regina W said, let me see that. Good night. All right, we got about 12 seconds. That's true, and I think you helped them understand the difference between parole and probation. Yeah. A lot of times people get them confused. But I think once he read it, like he like, okay, you on it. I know a little something. All right, let me go. But before I go, let me give y'all my legal disclaimer. No legal advice intended. Don't even start that lie. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right, y'all. I'll see y'all later on during the week. And if y'all see anything of importance or y'all think I'd be interested in it or y'all interested in it, send it to me. My email's in the description. TalkThatLaw@gmail.com. All right, y'all have a good one. See y'all on the next one. Let's go.